I beg your pardon, my lord.
Yes.
My lord, yesterday, my lord, after taking a lot of pain, my lord, in this crunching heat, my lord, I tried to list the two matters, my lord. This is a transfer matter. It's a very urgent matter, my lord. That SR has been made, my lord. The file has gone to the listing section, my lord, but they have not listed it.
Mr. The difficulty is that we are personally verifying that. So, so we can't change the system to oral mentioning.
My lord, at 2 o'clock.
There is a system.
Otherwise, they will be released by tomorrow.
We must appreciate that apart from you, we are working on that. So we know what exactly is happening, what is there. So maybe you mentioned on the next day, Monday.
Well, because they will be released by tomorrow. If this matter will not be taken, my lord, they will be.
Could be status quo ante can always be restored.
So matter may be taken.
We cannot prioritize on the basis of lawyer and the method and the mentioning. Please appreciate.
I tried a lot yesterday, my lord, and that file had got to the listing.
We also tried, Mr. Misra. We tried along with you. So nothing comes as a surprise, as you are saying. You are surprised. We are not surprised.
Okay,
so you mentioned it on Monday. There has to be uniformity because we can't pick and choose. Okay. Yes. File it. Even if possible, they file it today also. No difficult. We do not know. I think for Tuesday it will be Monday, not today. I'm sorry.
Yes, my Tuesday. But it is a very important matter, my lord. They will be relieved tomorrow, my lord. If today this
all matters are important. That is how we are sitting. In fact, we are taking up matters which are not important. In the garb of important matters.
Yesterday I tried a lot, my lord.
We have tried, sir. We are working instead of 11. It is 11 to 12. We are working till 3 p.m. The listing is at around 5:30, 7:30, around 7. It is released. So we know what is happening exactly. No difficulty. Yes.
Because this is a very important matter.
Correct. But you can't deviate for important matters to be taken up by oral mentioning. Yes. Please. Please call the list.
Vacation list, presiding item 1.
Lord, I'm visible to you, Lordship.
So last occasion, actually, the revenue was not.
Lord, I have informed both the Mr. Mohanty and Mr. Kedia. And my
Lord, just a minute, my Lord. I am appearing for all the opposite parties. And I peruse that writ petition, these annexes are not in order. Secondly, I've seen that in the cause list that there is another miscase is filed by them. The copy has not been served on us. So if my learned friend will serve us, then next date we'll see.
Mr. Padhi, you are right. Actually, there are a lot of defects pointed out. I don't know how it could be listed, but though it is filed in March, it is a lot of defects. We have to agree with you. No. But is it that you seek adjournment to receive copy?
Yes. Unless until I have not seen it is a demand, there is no such urgency. Only their predicament that because defreeze the account. Defreeze the issue is here. It is urgency. One part I am considering that it is urgency, but that no so much urgency because defreeze is before this vacation also. And they are coming in the vacation court praying there into the urgency.
You are right. You are right. It was filed in March. Maybe I don't know. They have filed an IA.
Well, yes, I filed it, but the IDA with only limited prayer that out of 22 bank accounts which are frozen, Lord, I'm only seeking the 9 account which is linked to the skill development program of the Government of India and the state of Orissa, as well as the PSUs and some the CSR fund.
Mr. Mohanty and Mr. Satyanarayan Patnaik. Satyanarayan Patnaik is along with Mr. DSA. Mohanty and Mr. Agarwal. What do you say? Mr. Padhi, the DSA wants a copy has to be served.
Yes, my lord.
I instructed Mr. Let this serve the copy.
So Mr. Padhi, it was on 2 days. So it was listed on 2nd. So then it has to it can possibly be taken up.
What I'm praying, my lord, because it is filed in March. Let it be opening day or after 1 day or 2 days. I don't know whether.
No, Mr. Padhi, without considering that, let the court decide. So it will be. So Mr. Das, the only way out is that the next date is 9th. You saw a copy today.
My lord, I only humbly request, my lords, there is a domino effect because of this particular phrasing, my lord. I came only in the March because after exercising my statutory.
So we are not taking up because if you are deciding to hear all of you, then we can take up. But
Right.
since Mr. Padi is saying that he's appearing for all and he wants copy,
I
and
would
Mr. Das, the defects are actually there.
I agree, my lord. I will.
So you what you do, you sir, copy and remove the defects today. Let it come on the next day. That is 9th.
May I have a suggestion, my lord? I will
Yes,
not
please.
go to the area of the defect, my lord, at all. I'll only will drive your lordships only through the undefected area, my lords. Only with the page number 205.
No, there is no such concept of partly defective. And apart from copy you, sir.
Because they
We
do
are eager to take up, no difficulty, since my esteemed brother is there. But we must hear the other side. So that is the problem. When he says that he is handicapped, so we can. Yes, Mr. Mohanty, what do you say?
Yes, copy may be solved, my lord.
Mr. Agarwal?
Let them give the mobile number. Here is there.
No, you sir, physical copies. You ask your associate to remove the defects. Maybe you are at Delhi, but you ask your associate to remove the defects and submit.
Our office is open for all time, all the office days, official days.
So you have to mention it on 8th. Okay, liberty to mention.
My lord, may I request you?
Learned counsel for the learned DSJ appearance lecture Samastankar. So Biswajit Das for the petitioner, Mr. P.K. Padi, senior advocate, DSGI for OP1, Mr. Mohanty,
My lord.
Subhash Chandra Mohanty,
My lord.
senior standing counsel.
My lord.
Senior standing counsel for OP2, Chief Commissioner Income Tax.
My lord.
Then
They
three
have
assistant.
instructed to appear for all the cases. Mr. Mohanty is appearing, he can join with me, no issue.
Okay.
They have provided the instruction for all the three parties.
Three, Mr. Agarwal, you are appearing for?
No, my lord. So I am not a party to this case.
Okay. Ciao. No, okay. Then 1 and 3, Mr. Yes, yeah. 2, Mr.
And Mr. S.N. Patnaik also appearing with me.
Mr. DSJ along with Mr. S.N. Patnaik.
S.N. Patnaik. Mr. Mohanty name also reflect this.
S.N. Patnaik CGs. The matter is listed for fresh admission on being mentioned by the learned counsel for the petitioner. Is submitted by the learned counsel for the petitioner that there is urgency as the accounts of the petitioner institution remain frozen by orders of the opposite party or by orders of the revenue. Stop. It is submitted by the learned DSJ that there are several defects. The annexers and the writ petition, which he had copied, which he has received, are not in order. He requests for an proper copy. Accordingly, it is directed. Copy of the writ petition in order shall be served on the learned CGC as well as Mr. Mohanty, learned senior standing counsel.
Income tax.
Income tax. Kali kon working. Kali by tomorrow. The defects as pointed by the SR be removed during course of the day.
My lords.
Right. Liberty to mention
My lord,
before the next vacation meet.
I have a suggestion, my lord.
Yes.
That these defects have to be, my lord, there are only the two annexes to be, transposed, the annexes 6 and 7.
Whatever you do, because though official time is 12th, but we have instructed they are allowing beyond 12 also. I'm sorry, not 12 midday. So they will allow you to do it beyond midday. So you remove it, after you remove it, then
May I do it, my lord, by tomorrow? Because it cannot be done right away because
no, please, Mark. I have said defect. I don't know. Kali registry khola ache. Just we are seeking that instruction. Just give us a second. Next. Call karo.
Item to
যদি ରେଜିଷ୍ଟ୍ରି ଖୋଲା ନଥିବ ସେଟା କାଲି ହେଇପାରିବନି ବଟ୍ ଆଜି ଆପଣଙ୍କର 12ଟା ନୁହଁ ଆଜି ଟାଇମ ଦିଆଯିବ ଆଟଲିଷ୍ଟ 2ଟା ଯାଏ ଆପଣ କମ୍ଫର୍ଟେବଲି ଷ୍ଟିଲ୍ ଦେयर ଇଜ 3 hours
2ଟା ବେଳେ ଯାଏ କରିଦେବି 2ଟା ବେଳେ ଯାଏ କରିଦେବି
ହଁ 2ଟା ବେଳେ ହେଇଯିବ
ତାହେଲେ ମୁଁ करेक्ट सो आई विल आल्सो
ଆପଣ ଯେହେତୁ ରିମୁଭ କରିକି କପିଟା ସର୍ଭ କରନ୍ତୁ ସୋ दैट दिस कन्फ्यूजन I mean this issue will not be there
ମୁଁ ଆପଣଙ୍କୁ ବି ହାଇକୋର୍ଟରେ ବି ଦିଟା କପି ଫାଇଲ କରିଦେବି
Right. That is how you remove the defect.
Correct.
Yes.
And I have one more suggestion, my lord. Can it be, though there is a liberty your lordships is giving me for 8th, may I then suggest, my lords, instead of my lord mentioning it, let it be, my lord, posted on the 8th itself or 9th itself, my lord?
No, because that's not by assignment. The assignment change is the last day. Both of us, we have the assignment till today.
ତେଣୁ
So,
ମତେ ଆଉଥରେ mentioning କରିବାକୁ
ଏଇ ଜିନିଷ ଗୁଡାକ peculiar to vacation ଆଉ ଥରେ ଆପଣଙ୍କୁ ମେମୋଟା ଦେବାକୁ ପଡିବ।
ଆଚ୍ଛା ଦେଲେ କିନ୍ତୁ ଆପଣ ଯଦି ଅର୍ଡରଟା କରିଦିଅନ୍ତି ତ ତାହେଲେ ଭଲ ହୁଅନ୍ତା ମୁଁ ପୁଣି
I mean, there should be committee. I cannot direct the matters to be listed before another bench.
my lord, your lordships is
Because I'm not assigned bench, you must understand.
I appreciate, my lord. May I have a suggestion?
Yes.
May I have a suggestion? That since lordships is exercising the power, my lords, through the roster, my lords, master of roster, my lord, through roster today, and your lordships is exercising the judicial function, my lord, power. Therefore, your lordships can always pass the order.
Maybe you are correct, but there should be a committee of courts. I should not direct listing before the other bench.
My lord, I leave it to your lordships now.
So that is how this process is, that the day before the memos are accepted. And one thing you must do, that since it is listed on 2 days, so you should mention in your memo that already memo filed on Monday.
My lords. Then
you can highlight, the deputy registrar can take no instruction.
Give a clarity, give me a clarification that in case if I will file it by today, then your lordships will just give a clarity that despite notwithstanding the mentioning, at least the DR should at least, my lord, list it. That's some kind of a, my lords, some.
No. Please appreciate, already you have given time today, soft copy. Rest assured, the DR takes care of everything.
I'll leave it to them. I'm sure of that.
If you please mention that it could not be taken up.
My lord, so much.
Yes.
Item number 2, Millets, I'm appearing. Millets, in this case is regarding GST RC cancellation.
Just my order will see there.
Cancellation of
I have
RC
given
cancellation.
So you are undertaking that you'll be paying everything.
Millets, it is already there in the order, Millets. That order I have given, it is
Corrected.
already there.
No. We directing and you undertaking are different. Have you undertaken?
As because it
Okay,
is
if you do not, then you fail. Upon যদি সেটা দেবেনি এটা within a time, তাহলে সেটা that will not work out.
Millets, that itself, that reflects.
I hope you understand what is being told to you. You are a seasoned campaigner now. Yes.
I will give an undertaking, Millets, to that effect. That I will.
Yes, you should have.
Yes, Millets.
It is the party for the petitioner. Appearance. ଆପଣ ବୋଧେ correction କରିଦେଇଛନ୍ତି.
I can.
କରିଦେଇଛନ୍ତି. ଆପଣ ବି ଲିଖିଦେଇଛନ୍ତି.
Madam, you are seeking after 9 years, 6 years.
Yes, Millets.
7 years.
This is how undertaking is more important. Because undertaking to act and undertaking to sleep are two different things. You have undertaken to sleep.
Hereafter, you have to make some arrangements.
Yes. Next.
I'm appearing for opposite party, madam.
Sorry.
Please, your lordships.
Sir, কি appear করতে পারি? Mr. Saurabh Tibrewal. Saurabh Tibrewal, are you there?
But I am not appearing, Your Lordship. Mr. Agarwal was appearing.
Mr. Agarwal is appearing.
I am appearing for opposite parties item number 2, my lords.
अच्छा. Junior standing.
ना लिखा है।
नहीं, बोल लिखा है।
बोल लिखा है।
Mr. M. Agarwal, Junior Standing Counsel.
My lords.
Grateful.
Mukesh.
Item number 3. Please, your lordships.
Yes, please.
Lords, here I'm challenging an order of
Comment. Yes.
adjudication passed by the central GST authorities. But the facts of the case are that in 2013, a lease granted by the state government expired. There were certain ores lying in the premises which were supposed to be sold out. I approached the government did not grant me the permission to dispose of the said ores. Then I approached this honorable court And this Honorable Court, by the order dated 14/1/2015, passed an order which is at page 155. If your lordships kindly go to page 155, the order starts at 147. The main portion is at 155. Have your lordships got it? 155, the second para, learned counsel for the petitioners also points out that more than ₹1 crore is lying with the state as advance royalty on account of royalty, and the petitioners are ready and willing to deposit any further royalty, if any, that may be computed by the state for granting permission to remove the unprocessed ore. Accordingly, the writ application is disposed of with the following directions. The Director of Mines shall consider and dispose of the petitioner's applications for removal of ore dated 16/5/2013 and 4/9/2013 within a period of 2 weeks from the date of receipt of certified copy of this order. On such communication, the Director of Mines shall compute the royalty payable after adjusting any amount that may be deposited with the department in this regard, and after service of notice of such demand, the petitioner shall make necessary deposit within a further period of 2 weeks therefrom. The next page, my lords. On deposit of necessary royalty, transit permit shall be issued in favor of the petitioners, and the petitioner shall remove the entire ore from the mining leasehold within a period of 4 months from the date of grant of transit permit. My lords, although this order was passed by the Orissa High Court, the government decided to approach the Supreme Court, my lords. And page 157, the lordships have the Supreme Court's order, my lords. The next page. This order was passed on 16/7/2019. It's almost after 3 years. My lord, the order says, having heard learned counsel for the parties, we dispose of IA number so and so by permitting the applicants to sell the total stock of iron ore totaling to so and so metric tons at Jalahuri Mines, village Jalahuri, Banspani in Keonjhar, under supervision of the state authorities. The state may designate appropriate authorities to supervise the conduct of the aforesaid sale. The proceeds of the sale shall be kept in deposit with the state to abide by such other order as may be passed. The sale proceeds be completed within 8 weeks. Still, the government could not do it. Then they approached the Supreme Court again for extension, and again an extension was passed. That is at page 161. The lordships kindly turn to page 161. That's the extension order which was passed on 4/10/2019. The last line, my lords, we cannot allow so much time and therefore grant time till 30th of January 2020. Liberty is also granted to seek extension. Since liberty was granted and the government could not do it also, they applied for further extension. And then on page 163, my lords, 18/12/2020, the extension was granted for a further period of 6 months. So thereafter, the sale proceeds were there. And then again, my lords, page 165, 11/1/2022, a further extension was granted by the Honorable Supreme Court. So, my lords, here, although I was supposed to sell my ores in 2013, long before the GST
just one something besides the issue. If you look at 149, I was appearing as the additional standing counsel, or maybe additional government advocate, in that before the division bench. So my name is recorded. So all of you agree for me to take up, or that issue is no more.
That issue is no more there, my lords.
My lord, for me, it is also not an issue, man.
My lords.
My lord, I am for a union bench. I don't have any objection.
My lords.
Okay.
Lords, we can continue.
Okay. So,
my lords, now I was supposed to remove the ores in 2013. I applied for it.
And that aspect of mining has been taken care of by the, removal has been taken care by the order of the apex court. We are not
My lord.
adjudicating that. It is something else.
No, my lord, the amount has already been deposited with the state government. It's lying in an escrow account.
Okay.
My lords, with all these things, now the department wants to assess me for the period 1920 till 23-24, my lords. Till 22-23, out of
So,
which, my lord,
So,
2
Mr.
years.
Mahantu, have they taken care of the Honorable Apex Court's extension orders?
My lord,
They
they
have-
have only referred to. They are silent that the payment, entire gross proceeds of the sale have been deposited in escrow account, my lords. I have not received a single paisa. Now they want me.
Because the Apex Court has directed that the proceeds shall be deposited and shall be abide
The
by.
SLP is still pending. My lord, the SLP is still pending before the Supreme Court. And in the midst of that, the assessing authority makes a demand, out of which 2 years.
So
already
any of
gone
the
by
Lord Counsel for the Revenue, please refer how you have dealt with the Supreme Court direction to that one line. Look at that page 161, I think that is.
My lord, I am conscious of that, my lord. But for all,
you not being conscious is not important, Mr. Kusti.
my lord, because my lord, with all due respect,
Understand the question, because the way you are answering as if you may be conscious of Supreme Court and Supreme Court's order, but the question is.
But for the department, my lord, the point of removal is important. If your lordship will see 76,
Mr. Krusti, have you read the brief?
Yes, my lord. Yes, my lord.
Otherwise, you take a passover and read the brief.
My lord, if your lordship will see,
we are not saying that for department the point of removal is not unimportant. That's no.
Date of point of removal, that is important, my lord.
Mr. Krusti, you are grossly wrong. You have to take. Please read the page first order of the Supreme.
My lord,
page 157. Kindly read it aloud for us, so that how do you interpret?
The consideration till yet not passed.
Let him read. Because the problem is that, Mr. Krusti, perhaps you have been briefed by persons who have not read the Supreme Court order. We have to tell this to you. This is not the way to read a Supreme Court order by your interpretation. Kindly read page 158.
158, my lord, to supervise the conduct of the proceeds of the sale shall be kept in deposit with the state to abide by such other orders.
Yes, so now the proceeds of the sale, if it is deposited by which state, then still this particular person is assessable, is to be assessed by you. That you have to tell us.
My lord, my humble submission is, my lord, if your lordship will see page 76, my lord, it has been dealt by the.
Either you have an answer or you do not have an answer. The question is,
my lord, I have an answer. Is
we'll record that. Having heard on it, Mr. Vivekananda Mohanty, senior advocate, along with Mr. Srijit Mohanty for the petitioner. Baki appearance lekhantu, Mr.
Satyanarayana Patnaik CGC.
Union Pine.
Union Pine Pari sir achanti.
Union
If your lordship will kindly see
You are Satyanarayana Patnaik.
Yes, yes,
Acha, Mr. PK Party, senior advocate, DSGI, along with Mr. SN Patnaik, CGC, for OP1.
Number 1.
For Joint Commissioner and Superintendent GST, K.
Mr. Mr.
Acha, Mr. Bhishma Anand Pusti, Standing Counsel.
Senior Standing Counsel?
Senior Standing Counsel. CGST for OP2 and 3. The senior advocate has taken this court through the series of orders passed by the Honorable Supreme Court. Stop. In the SLP. In the SLP, petitions for special leave to appeal, page देखिए लिखिए भूल करिए 157 रे अछि. Special leave to SLP number 20708/2016. Stop. The said SLP was filed by the state.
Yes, my lords.
Against the final judgment and order dated 14/1/2015 in WPC number 22559 of 2013. Passed by the coordinate bench of this court. while disposing of the IA 56934 of 2019, the larger bench of the Honorable Apex Court, by its order dated 16/7/2019, directed the following. Pura order ta copy paste kar dein. It will be easier for you. Hala. Prior to the order dated 16/7/2019, by order dated 4/7/2019, देखी देवे Supreme Court website पे देखते रहो. 4/7/2019, the Honorable Apex Court had directed no coercive steps are to be taken, and by order dated 16/7/2019, the Honorable Apex Court directed that order dated 4/7/2019, so far as no coercive steps are concerned, shall continue until further orders. Thereafter, the state appellants sought for extension of time to comply with the order regarding sale of the deposit of extracted mineral. Hello. By order dated 4/10/2019, the Honorable Supreme Court granted time till 30 January 2020. And also directed the state to file complete details of action taken, and also liberty was granted to seek extension. Thereafter, the state again sought for extension of time, and by order dated 18/12/2020, the Honorable Apex Court extended the time for sale of the extracted mineral. Who did they go to?
1812.
1812.
Now 165.
Further extension was granted by order of the Honorable Apex Court in IA number 67291/2021, page 165. By order dated 11/1/2022.
Well, this IA was filed by the petitioner.
Was granted IA जो लिख लेने की IA 6720291/2021 filed by the petitioner. Petitioner hearing, public respondent before the Apex Court. Thereafter, अपन जोटा sale टा देखेले केबे हला सेट? तो escrow account हला सेटा को पेज रच.
Well, it's 159 minutes. Page 159, Annex 6.
सेथिरे आपनकर डिपॉजिट हिची.
My lords. That's 159, paragraph 8 minutes.
The Honorable Senior Advocate for the petitioner draws attention of this court to order issued by the Director of Mines, the letter issued by the Director of Mines, Odisha Bhubaneswar, dated 4/9/2019 to the Deputy Director of Mines in charge Joda, with the caption subject sub disposal of stock at a page 159 rachi up to IA number 8. Paragraph 8 of the said letter indicates the following. The learned senior standing counsel appearing for the CGST is apprised of the order passed by the Honorable Apex Court, which directs thus, quote, page 158, already the proceeds of the sale shall be kept in deposit with the state to abide by such other order as may be passed. Stop. Quote. It is also asked whether the learned senior standing counsel is also asked whether he is instructed regarding the said aspect of the order of the Honorable Apex Court and with regard to liability of the petitioner to pay the CGST. Yes. Now your response, Mr. Pusti.
My lord, my humble submission is, my lord, for the department, my lord, for the levy of tax, my lord, the date of removal is important, my lord. On which date it is?
Kindly, Subilani.
The date of removal of the mines, my lord, that is important, my lord. That, my lord, even if, my lord, for any direction of the Supreme Court, my lord, it has been kept in another designated account, my lord. But, my lord, for that, my lord, the central revenue should not suffer, my lord. The taxability of that amount, my lord, that can be contained.
It is submitted by the learned senior standing counsel for the revenue upon instruction that even if the amount is deposited in a separate account as per direction of the Honorable Apex Court, the revenue should not suffer. And date of removal. Date kuntu hai, date ta kite kuntu? Mr. Pusti.
Different dates. It's from 1920 till 22-23.
Because his perception is different, Mr. Mahanti. Mr. Pusti's perception is different. Because even if the date is apparent, perhaps they think that you let him say. He should have the choice of telling. Yes. Yes, according to you, Mr. Pusti, the date of removal. Give the date now.
My lord,
It is submitted by the learned standing counsel upon instruction that the date of removal of minerals, date of removal within court rakhi.
Do you suggest that that is the taxable event?
My lord, my submission is that is the taxable event.
Mr. Pusti, first you complete your submission.
My lord,
I am still struggling though.
I may be excused, my lord, for a minute, my lord. I am just.
Date of removal dash. Yes. Yes, accordingly, ठीक अछि Mr. Pusti, you search for it. We'll give you some time. So, आपनकर केबे टू केबे आपन tax करछन्ती?
My lord, we have tax for the period.
The date of removal is dash. Data कहिबे.
Again.
And they have
it is for the period from 2017 to 2023, my lord.
And the tax has been imposed for the period from 2017 to
2023, my lord.
23.
My lord.
Okay. So you have imposed it on the state government or the petitioner?
On the petitioner, my lord. The mining belongs to petitioner.
No, the question would sound naive, but since you are stretching the argument, so I should get clarified also. Now you give the date so that we can ask Mr. Mahant to respond.
After minor 15/5/2013, it is written in the writ application.
You give your date. You give the date. After you can't be. It has to be a date.
My lord, because my lord, whatever I have to submit from their record only, because
sir, your submissions we cannot fortify. When you are taking a stand, we are sure, you are sure, we are sure that you have been instructed. Otherwise, no one will submit. So you are saying which date?
You'll also may kindly see
No, we don't have to see. You have to tell.
After 15/5/2013, my lord.
You are saying 15/5/2013 is the date of removal.
My lord.
15/5/2013, sir. Sure. Yes, anything else, Mr. Prusti?
No, my lord. My lord, my only submission is,
So
my lord,
15/5/2013.
my lord,
Yes,
that
Mr.
date, that date, my lord, I am just, I am also a bit confused, my lord. I am just praying for some time, my lord, that the exact date, my lord.
No, this is no round robin, semi-final, quarter-final, and it's eliminator and then final. So now the next question of my esteemed brother, that the taxable event is?
My lord, the act of removal from mining from the stacking area to the...
In respect of GST, you tell us.
My lord?
What is the taxable event under the GST Act?
My lord, yes.
Mining, I hope you follow the question of my esteemed brother. What? Removal is for imposition of royalty, DMF, many things are there.
Yes, my lord. And
as you know, this branch has evolved through Odisha, starting with Hingil. But Lordship's question is very specific. You are arguing for CGST. So what is the taxable event of imposition of tax CGST? That is asking.
My lord, that is supply. Your lordship will kindly see.
Mr. Prusti kindly appreciate that unless there is taxable event under a fiscal statute, can you levy?
The taxable event, my lord, he has removed and sold the mines to the other parties.
Is it that?
On a further query from the court regarding the taxable event.
Under the GST Act.
Under the CGST.
Both same.
CGST Act. The learned senior standing counsel submits that the petitioner has sold into court, sold the mineral, removed. He sold to whom, Mr. Prusti?
To my lord, other buyers, my lord. That details is not with me.
Buyers, the details of which is not with the revenue. What do you think?
Then what have you taxed, sir? What have you taxed?
The act of removal, my lord. It is here, my lord. The supplier is the
act
government,
of removal. Sir, act of removal cannot be. Can you show us any provision in respect of mineral removal that attracts GST?
If your lordship will, may I take your lordship to the statute, my lord, statute book, my lord? For a moment, my lord.
Definitely. Why not? CGST. Yes. Can you go to
Sorry.
Your lordship may kindly see section 7, my lord. The scope of supply, my lord.
Yes.
Hello. Section 7(1), my lord. For the purpose of this act, my lord, the expression.
Give us a moment. We'll get there. Yes. For the purpose of?
The purpose for this act, the expression supply includes, my lord. Here it is an inclusive definition. All forms of supply of goods or services or both as such as sale, transfer, barter, exchange, license, rental, lease and disposal made or agreed to be made for a consideration by a person in course or furtherance of a business, my lord.
Yes. Has he received any consideration?
That was asked prior to that. Since you did not answer, lordship asked
he has received. Maybe he has deposited in a designated account, my lord.
No, he has not. Please, Mr. Prusti, don't get factually wrong. He has not deposited. That is how we ask you that whether your authorities have briefed you reading the Supreme Court order. Then if he has done it, then the Supreme Court order is violated. So that's another thing. So obviously he has not done it. He has not done it because Supreme Court has directed otherwise. On being asked what the taxing provision, since it is suggested by the learned, it is submitted by the learned senior standing counsel that the taxing event is. Sir, लिखी दी चल बोले. कौन last टाइम कौन लिखी sentence टा? So हाँ, ताप और लिखो तो the learned senior standing counsel refers to Section 7(1) of the CGST Act, which is reproduced here, to support his submission that petitioner has, to support his submission, comma, and contains that the petitioner has received the consideration. The learned senior standing counsel is apprised of the fact that the Apex Court has directed the amount to be deposited in an escrow account, which is still continues to be in that escrow account. It is submitted by the learned senior standing counsel that that amounts to receipt of the consideration. Yes.
Another aspect, my lord, that date, my lord, I may be excused, my lord, that date is 2022 to 2022. That is, it has been written in this date. My lord, it is year 2020. My lord, I am 2020 to 2022. Year 2020 to 2022. It has been written. My lord, exact date is not with me. Whatever written in his date chart.
Then you should be always submitting. I think once I told you that submitting based on facts.
My lord, that is how
we are at the lawyers at a different level.
Sir, that is my mistake,
do not
my
have
lord.
The facts. Don't.
It is my mistake, my lord. But I am submitting from his date chart only. It is 2020 to 2022. Page E, my lord.
Date chart ko jantu ni.
First time पे आसी आगे मु आ गुटे instruction आनछि कि first time
आपन कहबार थिला. आपण जेतबे instruction नाही बोली न कहि आपण जहा जहा कहली we have recorded. That is
whatever from there.
We knew this. Now you can check.
That is my mistake, my lord. That date. So far as the date is concerned, that is my mistake. But that their date chart says it is.
If you want to withdraw your submission, then we can record that. It is up to you.
My lord, that date I am withdrawing.
After arguing for some time regarding the date of second sentence of dash joda thila. Regarding date of removal, the learned counsel for the standing counsel withdraws his submission, highlighting that he is not sure of the date of removal as he has not been instructed.
But their record says it is 2020. His date chart says it is 2020 to 2022.
Mr. Prusti, you have made pinpointed submission that dates of removal is the most important factor.
Yes, my lord. I stick to that. I stick to that.
Unless you have brought on record your adjudicating authority, unless it brings on record, these are the dates on which the mineral has been removed, and this is the taxable event. Unless that is reflected in the adjudication order, can you levy? This is the question I am asking you.
Yes, my lord. My lord, it is not on a particular single date, my lord.
Once failed to particularize the date, then
my lord,
there is a taxable event.
It is not on a single date.
Sir,
yes, my lord. I bow down, my lord.
If you read Gangasaran, I think that
Gangasaran Ramsar.
That judgment, 4 ingredients, they are very, very fatal. One of them, essentials.
Missing of one of the elements is fatal.
That will.
Because it is hit by constitution.
Yes.
Here, my lord,
compulsory exaction of.
Not on a single day, the entire mining has not been removed, my lord. It is from 2020 to 20.
So you
sir, whatever, sir, we are not asking you, did you suggest that every day it was removed, or that is not our suggestion also? The question is different. Yes, Mr. Mohanty, anything to respond to Mr. Prusti? Or Mr. Prusti, have you completed? Are you satisfied you have completed?
Well, my lord, my submission is that, my lord, I am just summing up, my lord, it is the date of, the time of removal.
We have faithfully reproduced that. So just to save time, because we have already spent for 46 minutes, let's say 36 minutes at least for your case. And you can check. We have faithfully reproduced whatever your submissions are.
My lord, that is my.
Yes.
Only one mistake I have committed. That date I have told, that is wrong.
No. You have not committed the mistake. Your submission is that the date of removal is the taxable event. You answered that. But,
yes,
when we asked,
what is the date, my lord?
So what is the date? There you are struggling. And still you are struggling. Now almost you have withdrawn the date. But that
Okay,
submission
but,
is there.
my lord,
Regarding
sir,
the
that
date, you
period
are saying
I-
you have noted. Regarding the date, we have your submission that you are not sure, that again we have noted. Yes, Mr. Mohanty.
Nothing, my lord. That's all, my lord.
Yes.
And all the submissions.
With the aforesaid submissions made at the bar, we are satisfied that this is a fit case where notices have to be issued to the opposite parties to answer the issues as recorded above. So notice along with this order. Extra copy क्या दिया Mr. Patnaik, Mr. Pushti.
Sir, ଗୋଟେ ଦେଇଦେଲେ ଚଳିବ, one
Extra.
one extra.
Mr. Patnaik, ଆପଣଙ୍କର अरे ଆପଣଙ୍କ unmute କରନ୍ତୁ.
I need one extra copy.
Okay. In view of appearance of the learned DSGI along with the CGC as well as the learned senior standing counsel, no further notice be issued. Stop. Para. Extra copy of the writ application. One extra copy of the writ application shall be served on the learned CGC, and 2 extra copies of the writ application shall be served on the learned senior standing counsel. Yes. How much time to respond, sir?
My lord, 3 weeks.
Mr. Pushti, again?
My lord, 3 weeks, my lord. 3 weeks, my lord.
As prayed for, 3 weeks time granted to Mr. Patnaik, 3 weeks?
Yes, ma'am.
3 weeks time granted to the OP number 1 as well as OP number 2 and 3 to file their response in counter to the writ application upon serving copy thereof on the learned instructing counsel, Mr. Mohanty, Srijit Mohanty, for the petitioner. And you will ask 3. Counter affidavit be filed by 30/6/2026. The matter shall be listed. Then Senior Mr. Mohanty, rejoinder. The petitioner shall have liberty to file rejoinder in response to the counter within 2 weeks.
My lords, oblige, my lord. 2 weeks.
2 weeks. Within 2 weeks. The matter shall be listed for admission before the assigned bench in the week commencing 20/7/2026. Yes.
My lords, an interim prayer, my lords.
Item 4. Again,
Not the interim prayer, my lords. I've made an interim prayer. No coercive action, my lords. So I've not received any money. All the money is with the state government.
My lord, the demand is 50 crores.
No, I mean, there is a good coordination between the judges. When I asked, you imposed on the state or then my lord asked, what is the taxable event? So, and Mr. Pushti also did a valiant effort. Yes. IA.
My lord,
IA 10038 of 2026.
demand is, my lord, 15 crores somewhat, my lord. So I am praying, my lord,
Yes,
will also make
per person.
You have to make, Mr. Pushti, you have to make the Advocate General party also. They have to pay it.
Mr.
Because money, when we find
It-
Supreme Court has
it is
allocated to the
not-
states in the SB account, we must understand, you must don't make we should not, looking like a funny thing. We ourselves record that the amount will be deposited in the escrow account. Then on the last line, we will say that 20% of that amount will be paid to the GST. You must understand what order we can pass.
Another thing, Mr. Pushti,
my lord.
you must be aware that after Article 246, capital A,
my lord.
in respect of GST,
My lord.
state and center,
both can, my lord.
one,
My
right?
lord.
So your submission should be like, whether it is deposited in state or center, it is between you and this center, the state.
I think maybe there will be another round of litigation. The lawyers will be happy, senior and Mr. Instructing Counsel, Mr. Mohanty, because when the amount will be decided from the extra amount where it goes, then you have to be active. We should not sleep. Like Mr. Tripaঠি's client, after 9 years, he comes for registration of re-registration. We should notice as above. the learned CGC, the learned DSA along with CGC, as well as the learned Senior Standing Counsel appear on waive notice. Extra copy of the IE shall be served as directed above. The opposite parties shall file their response to the IE along with the counter to the writ petition. In the interim measure, it is it is directed that no coercive action shall be taken against the petitioner pursuant to the notice to order demand. Tepan, 53.
No. Annexer 2. It has demand come show cause.
Order in original already passed. He has participated in order in adjudication and order in original.
Nothing.
Annexer 2, sir. Annexer 2.
Annexer 2, my lord.
So that because he has participated, we asked you that where you have dealt with that aspect.
Order in
I was asking the colleague pursuant to order dated 9/3/2026 into bracket annexer 2 to the writ application till the next date of hearing.
May it please your lordship. It is a 73 4B Finance Act 1994 matter, my lord. It is a covered matter. I have already given the order copy, your lordship, my lord.
Mr. Rajesh Tripathi, Diganta Das ka sangare. Acha.
My lord, my lord.
My lord, I am appealing for opposition.
Mukesh
Agarwal.
My lord, I am appealing.
Kali jone.
My lord.
Mukesh Agarwal, Junior Standing Counsel.
My lord.
Again. Dispute is supposed to.
No.
Same order.
Sign it. Supreme Court question on the
Supreme Court এটা বিচার করছেন ঠিক আছে
আজ্ঞা অবিলম্ব লর্ডস
call Mr. Adam Thai, Mr. Madhavlal Agarwal for the petitioner. Mr. Viswanand.
No, lordship, I am appearing. I am in item 5. I am appearing, your lordship.
Saurabh Tibrewal.
Yes, lordship.
My lord,
So you are standing counsels?
Additional standing counsel, your lordship.
Additional standing counsel, CGST.
Yes, lordship.
Okay.
my lord.
Oh, good, sorry. Mr. Agarwal.
Yes, my lord, I am challenging the annexer 5 of the order. They by a mistake or erroneously computing the period of limitation. I have filed the appeal within the period of limitation of by.
Yes. Mr. Tibrewal.
Yes,
Mr. Tibrewal.
Yes, your
It
lordship.
is covered by one of the orders.
Yes, your lordship. It is covered, your lordship. It is covered.
Where I was a party and I drafted that order.
Covered.
That is Rajpath. Sorry, Bharat Chandra Bhuya.
Yes, your lordship. Bharat Chandra Bhuya, your lordship.
So 15/10/2025 is the order in original. 3 months lapses on 14/1 and condonable period is 1 month thereafter.
Lordship.
So last date is 14/2/2025.
Lordship.
The appeal was filed on 13/2/2025. So that was condonable period.
Condonable period, your lordship. Yes, your lordship. Bharat Bhuya is WPC 7612 of 25, your lordship.
Though we cannot say that the appeal is filed within time, but you had opportunity or you had the power to consider whether to condone the delay or not.
Yes, your lordship.
So you have computed erroneously, I think.
Lordship. It has been done 31 days. They are saying 31 days, but it is within the condonable period, your lordship.
Page 9, I have given a tabulation. Page 9, there is a tabulation, sir.
Same order.
So we are disposing it of
with same by the coordinate bench. You are just simply following the coordinate bench.
Lordship.
Yes, this poster. The Sahoo नहीं कोई में. आप
most लक्ष्मीकांत को डाके को है ना मतलब सेटा लिखी दो भरत चंद्र क्या
Page 9, there is a
WPC 7612 of 2025.
7612 of 2025.
Disposed of on 13/5/2025.
13/5/2022. You have CJ and MS. Yes, next please.
May I please, your lordship?
ତାଙ୍କ ନାଁଟା ଲେଖିଦେବି କିଏ ତୀବ୍ର
May I please your lordship?
ଏଇଟା ବୋଧେ ଆପଣଙ୍କର ଗୋଟେ ସେ ଏଇଟା ଲିଷ୍ଟ ହେଇଥିଲା ସିଙ୍ଗଲ ବେଞ୍ଚ ରେ ହେଇଯାଇଥିଲା
ଆଜ୍ଞା।
ତ এই ଅର୍ଡରଟା ଦେଖନ୍ତୁ 26 ଅର୍ଡର
ଆଚ୍ଛା ଆଚ୍ଛା।
My lord, by virtue of that notice under Annexure 4 series, the Tahsildar has demolished the structure on 3rd.
So, so your case is that you did not encroach as directed.
No,
I mean,
my lord,
your enforcement is not part of that. Your
no, my
enforcement
case,
is not.
my case is, my lord, it is the Panchayat property. I am the Naib Sarpanch. It is the Panchayat property, and no adjudication in respect of Gram Panchayat is made in respect of that order passed by this honorable court in WPC number 4198 of 2026. Your lordship may kindly see Panchayat is not a
Unless
party.
Mr. Mahapatra, unless we review that order, we cannot entertain, and we cannot review. You
No,
may have a case. You have to take review of that order.
My lord, my humble submission before lordship is it is not a question of review.
What we can do is that we can let it be listed along with WPC 4198 of 2026 before the bench that has passed the order.
No, that's true. But by now, by that time, my lord, it has already been demolished.
Yes.
Whenever your lordship is in season of the matter.
Consequence, no, we are never in season of that matter. Because
No,
one court directs
by virtue of Annexure 4 series, it has the structures have already been demolished on 3rd.
Yes, because of WPC 4198 of 2026.
Yes, madam.
No, your lordship may kindly see for a moment the direction.
No, please don't presume that we have not seen. You are not looking at Annexure 3.
Yes, therefore, my lord, I have annexed it.
Therefore,
my lord, I have annexed it. Your lordship may kindly see.
Now you are agreed by that order in Annexure 3.
No, my lord, that is not my submission.
Mr. Hrudanand, the order was passed in the month of March.
My lord.
So you could have taken steps there.
My lord, I have not been made. It is not known to me. It is, my lord, your lordship may kindly see the.
So let it be.
Your lordship may kindly see the page 91. Your lordship may kindly see page 91.
Just kindly look at 94. The order, the notice 16/5 जोटा.
My lord.
ଆପଣ 16/5 ରେ ସେ ରିଟ୍ ପିଟିସନ କୁ ରେଫର କରୁଛନ୍ତି ଓଡିଆ ନୋଟିସ ଯୋଉଟା ଆପଣ ଦେଖିବେ 94
ହଁ ସେଟା 94 ରାଇଟ
ସେଟା 26/5 ରେ Mr. H.N. Mahapatra for the petitioner, Mr. D.K. Sahoo, additional government advocate for the opposite parties, as directed by order dated 26/2026 by the single bench. The matter is listed before this bench. The matter is listed today before the division bench. This bench now listed today before the division bench. Start. It is submitted by the learned counsel for the petitioner that pursuant to the notice dated
26/5 minute 26
ସେଟା କଣ 16 ଭଳିଆ ତ ଦେଖା ଯାଉଛି just a second
26/5/2026
16 ଭଳିଆ ଦେଖା ଯାଉଛି
ନା ଆଜ୍ଞା 26 ତାରିଖ ସବୁ ଗୁଡା 26 ତାରିଖ
notice dated 26/5
ଆଜ୍ଞା
26/5/2026 the structure mentioned in the copies of the notices at page 94, which is in Odia, 95, and 96, 97.
Up to 108, my lord.
It is up to 108.
Of,
108.
99 to 108 have been demolished.
My lord.
Para. The said notice issued by the authority Tahsildar at pages 95 and 96 refers to Puja Mandap,
And Durga Mandap.
whereas Puja Mandap, whereas from 96 to 91, 10 jete jai achi, 96 to 108 refers to
94.
shop room, godown, temporary structure for carrying out business.
Commercial structure.
व्यवसायिक ढांचा. Structure for carrying out business.
Over plot number, my lord. My lord.
It is apparent that the miscase 1 of 2026 refers to the order passed by the coordinate bench dated 18/3/2026 in WPC number 4198 of 2026, and the demolition was fixed to 3/6/2026. They submitted that the demolition has already been carried out. Stop. In considered view of this court, in view of the order of the coordinate bench, both the writ applications should be taken up together by the bench that had passed the order dated
18/3.
PC number 3. Accordingly, both the matters shall be listed before the bench that had passed the orders dated
18/3/26.
coordinate bench that had passed the order dated 18/3/2026 in the week commencing 22/6. तो अपन लिख ले पास द ऑर्डर में that है disposed of कर दे. Disposed of. Yes. Shall be listed for orders.
Sure.
Yes.
Order shall pachre rahibo aja. Admission rahilo. It may be listed for admission.
Listed for fresh
Order shall padi
admission.
paribo.
Listed for fresh admission. Accordingly to directed, the WPC number कितने number data?
17,420.
17,420 shall be listed along with the disposed of WPC number 4198 of 2026. In the week commencing 22/6/2026, liberty to mention. Yes.
Item 7.
No, item 7, my lord, I am appearing on behalf of Jitendra Samantray. I have also filed my appearance memo.
So Vishnu Prasad Pradhan for the, along with Mr. Jitendra Samantray for the petitioner. Yes, Mr. Pradhan.
Here, my lord, in this case, my lord, I have challenged the unilateral cancellation of lease deed and forceful eviction. Here,
Who
my
are
lord,
appearing for the other side?
I'm for 1 and 2, my lord.
one caveat has been filed by OP number 3.
Number 3, the Deputy Commissioner.
HPCL bench.
1 and 2, I'm appearing, my lord.
No, sir, OP number 4. Caveat has been filed by OP number 4. Maruti
1 and 2 kindly, HPCL, who is that?
Seniors man. Seniors Patnaik.
So Srinivas Patnaik for OP 1 and 2. For OP 3, Mr. SN Patnaik. State.
Mr. Vivekananda.
Mr. Naik.
You are OP3. Deputy Commissioner of Police.
काकू देना दी कॉपी दे फाइल नहीं
आगे दिया तो इच्छी कॉपी तांको पाखरे जदी नथियो आ गुटे कॉपी दे
मिस्टर विवेकानंद नायक आपण ऐसे असाइनमेंट अछि आपणकर
Assignment अछि but
हो ठीक अछि मिस्टर विवेकानंद नायक एजीए फॉर OP3 4 पे आके अपेयर करछन मैडम यू आर अपेयरिंग
I'm appearing for opposite party number 4, your lordship.
आपणकर ना आगे
Yogamaya Biswal. We are the caveat petitioner, Your Lordship.
Ms. Jogomaya Biswal for the MS Jogomaya Biswal for caveator opinion number 4. Yes, Mr. Pradhan.
Yes, I have already served copy on the caveator. Only
Yes.
here, this is a case, my lord, will find that my lease was up to 31st January 2026. That is under Annexure 2.
Okay.
Thereafter, my lord, you will also kindly see the Annexure 5.
Yes.
My lord, Annexure 3 at page 36.
Yes.
Page 36 of my brief, Annexure 3. This is the first communication from the HPCL to me, wherein, my lord, they requested me to give necessary rent schedule, to produce rent schedule under Annexure 3. They have issued this letter. Thereafter, I responded under Annexure 4.
Yes.
Thereafter, communication was made between both of us. It could not be finalized. All on a sudden, you will also kindly see Annexure 6. Annexure 6 was issued and it was extended unilaterally without my consent and without any agreement. And referring a clause, you'll also kindly see what is the extension clause in the first agreement. You'll also kindly see page
42 digitally, my lord.
Page 28, you'll also kindly see what is the clause. How it is, my lord, unilaterally, they have extended the lease period for another 10 years without obtaining consent from me, referring that extension clause in my earlier agreement.
Yes.
That is page 28, my lord, kindly have a glance. Page 28 of my brief.
Yes.
Clause D. Clause D. Let's say lease of the demised premises for the future term of 10 years from the expiration of the said term at the same rent and containing the like convenience and provisions as are herein contained. Nowhere, my lord, it has been stated that it is automatically, my lord, without any consent or without any written agreement, it will be extended for another 10 years. Clause does not speak about unilateral extension. It has to be agreement. It has to be registered on.
Any agreement, covenant regarding a immovable property has to be registered.
Yes, there is nothing has been happened. All on a sudden, you will also can see thereafter what they have done.
You are selling some product. You are
no, my land. No, it is a HPCL outlet, petrol outlet.
Pump is running, my lord.
No, it was stopped since November 2025. Petrol pump was stopped from November 2025.
And now we are prevented from entering the premises, my lord.
That you will also can see unnecessary rate. Why, my lord, why it has happened? Unnecessary rate you will also can see.
Yes, Mr. You can do Patnaik. So Patnaik, I'm sorry.
Yes, my lord.
So can you unilaterally extend that?
That is as but
it's apparently it's a private property.
Yes, my lord.
Anyway, you take notice.
Yes, my lord.
The petitioner before this court is agreed by the unilateral extension of the lease deed by letter dated
29th January 2026 at page 41, Annexure 6.
Letter dated 29th January 2026, page 41. Sorry, Annexure 6 to the writ application. The petitioner is the owner of a land belonging to him. He has leased out the said property to the Hindustan Petroleum Corporation, opposite party. But it is submitted that unilateral extension of lease is not contemplated in law. The learned counsel for the petitioner refers to the covenant relied upon covenant of the lease deed relied upon by the opposite party 1 and 2 authorities. সেটা আউথরে দেখাନ୍ତୁ
Page 28, my lord. Page 28, clause D.
Is 28 clause D. Data which is reproduced here. 28, 29 আছে, 4 ধাড়ি আছে। It starts lessee, a lease of the demised premises to contingent.
It is a precondition, my lord. We have to give a notice for further extension. Accordingly, we have complied, my lord.
But you are not referred to any provision.
That has to be read both the paragraphs.
So can it be? Can it do it contrary to law?
That is in terms of the agreement.
Because you are the occupant and you have obtained a lease.
In terms of the
you want that once a lease, always a lease. Your argument would be then once a lease, always a lease. This is a very difficult proposition in law, sir.
In terms of the agreement, I am saying.
He says that he has consented.
Agreement, where is that?
It is.
You read. We have reread those 4 lines.
Consensus
and as you know, sir, I mean, consent cannot be even free consent cannot be by agreement. One cannot sacrifice free consent, or you can say that yes, I agreed or not to give any consent or consent always, both ways.
What your lordship is saying correct, but I have to say within my terms of the agreement only I have to submit, my lord.
No, suppose to you and the learned colleague, your learned colleague standing beside you, or Mr. Pradhan, enter into agreement to occupy that courtroom. Yes, what would be your response? If you cannot occupy a courtroom where you are standing now, you cannot occupy a private property.
I have a subsistence.
Right to property, even after abolition of the constitutional provision, still resurrected. I was thinking that he's the dealer. So initially, in fact, I tried to read aloud. So, but it is rather surprising that he's only the lessor.
Yes.
His nephew is the dealer, my lord.
So you are caught in the crossfire between the nephew and the chacha bhatija ke exchange में आप पकड़े गए. Clause D, which is reproduced here. Issue notice along with this order. In view of appearance of the Lorded Counsel for the OP number 1 and 2, as well as the Lorded AGA for the OP 3, no further notice be issued. Let 2 extra copies be served on opposite parties number 1 and 2. The Lorded AGA request for an extra copy. An extra copy of the writ application shall be served on the Lorded AGA appearing for OP 3. Copy of the writ application has been served on the Lorded Counsel appearing for the OP 4. Caveat, it starts discharged. Stop. Then IA. The counter sorry. Counter?
Within 4 weeks, within 3 weeks, my lord.
Counter within 3 weeks, okay.
Yes, madam.
As stated by the Lorded Counsel for the OP number 1 and 2. Madam, apna kebe debe?
Within 3 weeks, your lordship.
As stated by the Lorded Counsel for the...
She has been appointed as an ad hoc dealer to run temporarily, my lord.
Okay, output body. Kabi yochita. 100 achi? Yes. Okay. Possible. Sure. Please one percent. Chacha. So, for the OP number 1 and 2, the counter shall be filed within 3 weeks. Counsel for OP number 1 and 2 and 4. 3 weeks. Accordingly, the counter affidavit on behalf of the OP number 1, 2 and 3. 3 per 1, 1, 2 per comma. And counter on behalf of OP3 shall be filed by 3 weeks. Say by 25 June 2026. Upon serving copy thereof on the learned counsel for the petitioner shall have liberty to file rejoinder in response thereto. The matter shall be listed for admission in the week commencing 13/7/2024 before the assigned bench. Stop. What is the IA, Mr. Pradhan?
Not to dispose. I am in possession of that land.
No, my lord. That is a question.
They have admitted that Annex 8, page 7.
That is
IA 10564 of 2026.
I be prevented from running the outlet, my lord.
Sir, that is your own creation.
Yes, that prevented means I am in possession.
Anyway,
that they are
I
admitting that.
record my objection. That will be sufficient, my lord.
No. Of course. No, I mean, it is not favoring anyone. The status order is not favoring anyone. IA 10564 of 2026. Our learned counsel for the petitioner, he reiterates his submissions as noted above. The learned counsel for the opposite parties 1 and 2. Sir, standing counsel or khali counsel likha ho?
Khali counsel.
Mr. Learned counsel oppose 1 and 2 as well as the caveator. Oppose the interim prayer. Stop. Apart from the submissions as noted above, it is submitted by the learned counsel for the petitioner that the opposite parties 1 and 2 and 3.
1 and 2 and 4.
1 and 2 and 4, sorry. 1 and 2 and 4 at Annex 8. Change submitted that Annex 8, that is letter dated 20/5/2026, issued by the OP number 1 and 2 authority to OP number 4, indicates that the petitioner is in possession of the property. It is further submitted that he being the owner of the property had entered into the lease agreement, which forms basis of the extension of the lease unilaterally by the opposite parties 1 and 2. Stop. The counsel seeks for interim relief. Stop. Para. As an interim measure, it is directed that status quo as on date regarding nature, character, possession, ownership of the property, of the subject property, shall be maintained by the parties. Mr. Pradhan, you have to also maintain.
Yes, ma'am.
No alteration.
Yes,
shall be maintained by the parties to the writ petition till the next date of hearing. We wanted to mention. Yes. Urgent certified copy likhi debe. As urgent certified copy be issued as per rules. The parties shall have liberty to act upon the copy of this order obtained from the official website. Yes. Achha.
Miller, this matter relates to admission, Miller, consequent to the granting of NOC. That is a nursing matter. Since relating to admission, it is urgency is there, Miller. Your Lordship may kindly appreciate which are the core issues of fact involved in the case. The petitioner before Lordship is an existing nursing college, Miller. Last academic session, Miller. Miller, last academic session, Miller, the petitioners, that is approval, that is extension of NOC, it was not processed for recommendation to the government, Miller, for the solitary reason that the petitioner institution did not have valid fire safety certificate, Miller. That's the last year, Miller, the petitioner institution approached your Lordship. Your Lordship is sitting together with Honorable Justice Pathak, Miller, and your Lordship under Annexure 4, Miller, was pleased to, that is a coordinated bench, Miller, pleased to direct the authorities, that is ONRC and DMET, Miller, to consider the application of the petitioners, Miller, for granting of NOC for the last year, Miller, extension of NOC, if petitioner would be complied that deficiency within that is within 24th November 2025 Miller. There unfortunately there was a delay of 2 days in providing of the that deficiency fire safety certificate, and then my application was rejected under annexure 6 Miller. You will kindly have annexure 6, that is a very small order Miller. It was rejected Miller. Page 28 Miller. On the solitary ground that I was unable to produce the fire safety certificate as per their requirement within 24th November Miller. And I was also compelled to approach your lordship through a miscase Miller, since the session was started as per the INC guideline, that was the 30th November Miller. 30th November 2025, that was the INC guideline for commencement of the session Miller. And taking into consideration of that INC guideline Miller, your lordship was pleased to extend the period for removal of deficiency by 24th November Miller. Period was over Miller. My application, that is miscellaneous application, was not considered because it was become infructuous Miller. Then the other facet of the case, your lordship may kindly appreciate Miller. Since I was a existing institution Miller, and I was not allowed, or I was denied to grant NOC for the reason that I was deficient to the extent of non-supply of the fire safety certificate. And fire safety certificate now it is with me Miller. But by the virtue of annexure 8 Miller, you lordship may kindly have a glance to annexure 8, that is page 31 Miller. I was precluded to apply for NOC for the present year, for the reason that last date for granting of for making application of NOC was 16th August 2025 Miller. But they cancelled my NOC extension of NOC on 29th November under annexure 6 Miller. When they cancelled me on 29th Miller, I have no.
So Mr. Das, kindly look at page 30 of your petition.
Miller.
It's 30 of your petition.
Miller 30 because 30 Miller. When I sought for extension of time Miller by filing of a miscase before lordship Miller, it was denied Miller. Another institution, some other institutions also there Miller. Some institutions were benefited by the virtue of lordship common order. Some institutions were denied because there was a delay.
So you want to apply again? You want to apply again?
Yes, Miller. I want to apply again. I made an application, but they are not allowed.
Mr. Mahanti.
My lord, yesterday at night, 7 o'clock, the copy has been given to me. I have gone through the once for renewal. So unless I get the instruction and everything, I cannot.
No, without if you read the Honorable Apex Court's order at page 30, permission as sought for is granted. The special petitions are accordingly dismissed as withdrawn. So dismissal. That we make it clear, if such an application for renewal is made, it shall be considered and disposed of in accordance with law and extant regulations expeditiously. We have not expressed any opinion on the merits of the matter. So this order arises out of the order dated judgment dated 26/11/2025 in WPC 33706 of 2025, Kalahandi School of Nursing. So that 26/11/2025 order is.
Miller 2020 order is I have annexed Miller the Kalahandi, and this matter stand on the same footing. I was also it is a
Kalahandi na dekhiye apan annex korcheni page kete kohntu. If you have annexed, then tell the page.
Miller page starting from 29. 29 your lordship may kindly see the Kalahandi matter is the first matter, and the second SLP is 3866.
High Court order ta hai mo apanakara Kalahandi ra court order ta kouthi ache?
High Court order ta annexure 4 ache hajur 30 page 20.
Again.
Miller page 20 I'm just reading out. That was in our table.
Sir, sunantu, Mr. Das. Now what has happened after dismissal of the SLP, 2011 SLP, 2011 25 order attains finality.
Miller.
Please appreciate. So 2011, if the Supreme Court would have intervened in 2011,
Miller.
Then it would have been different.
Miller.
So if you want that, you want to approach again, it will be at your choice. We can't.
2020.
Neither we can prevent you, nor we can compel Mr. Mahanti to do anything.
Miller.
Because Supreme Court order is very clear.
Miller.
Confirmed to 25,
I made an application. I made a representation after passing of the Supreme Court order on the next 9 Miller. They are still sitting over this matter, Miller.
They have to sit over. They have to sit over because 2011-2025 order in your case has already attained finality also.
Miller.
So in your case, whatever order was passed, you have not challenged. So Kalandia challenge, the result fate is same.
Miller, you last week I appreciate it is on a different footing, Miller. Last year,
same footing. Same footing. Footing, absolutely. Footing and shoes are also same. Everything, dress, shoe, and entire everything is same.
To last academic matter, Miller. Academic session, Miller. 25, 26.
Mr. Das, for many cases, you have also sought for direction for 26, 27.
Miller.
So 26, 27, if you have applied for 26, 27, by which annexure?
Miller
does not apply.
We made application. We are prevented to make that application because by the time of their rejection, Miller, when they rejected.
Sir, key prevent kala by forcibly by use of force.
No, prevent करके जे ताकर last date थिला 16 अगस्त 2025.
So who prevented, sir? आपण तो High Court order नहीं चलती 26-27 पे 25 रे थिला.
No, 25-26 पे थिला. सेटा
आपण टिके सुप्रीम कोर्ट ऑर्डर टा उतरे पढो. आपण टिके पेज 30 पढो तो उतरे. सुप्रीम कोर्ट ऑर्डर देखो तो सुप्रीम कोर्ट ऑर्डर कोटा कहउछ.
बिलर सुप्रीम कोर्ट कहले जे हमर ऑलरेडी 26-27 टा हम चाहू पकेबा हमर इंफ्राक्लोज हे गला सुप्रीम कोर्ट रे कारण हम 25-26 पे हजूर को ऑर्डर अगेंस्ट जाइतलु हजूर एतले हमको ऑर्डर देतले फेवर रे.
अरे नहीं आपण टिके पढिले हो ना आपण सर पेज 29 रे पेज 29 रे कलाहांडी आपण तो कलाहांडी रो आपण जे हिस्सा
रीडिंग आउट आई एम जस्ट रीडिंग आउट इन व्यू
आपण सेतिरे सुनंतु आपण 26-27 कथा पढिछि वर्तमान आपण 26-27 अप्लाई करिया को चाहउछंती कि अप्लाई करिसंती कि
नहीं अप्लाई करि पाउनी कोन संभवनांती
नहीं करि पानु माने नेबे माने कोन आपण केमति नियंती से माने मिस्टर महांती से कोन कोजो नो नांती
my lord they are supposed to apply for 26-27 the date is already over when the matter for 25-26 was pending there was no bar for them to apply for the extension.
Absolutely so that in fact that I asked that you were already before this court.
Yes.
So what was the last date for 26-27?
26-27, my lord, it is it's already June, I think. So I'm not.
Miller, last date is September 30. September 30. I have annexed that guideline, Miller, also.
My lord,
किए आपण अटकेले आपण अटकेले किए दो नांती जो कोचोंती करे दो नांती किए कोचोंती
ऑनलाइन मत अलाउ करना से मान हमर ऑफलाइन एप्लीकेशन त नो ना वी आर रेडी टू
कोठी आपण लिखले कोड रिट पिटिशन ने कोड लिखचोंती
तो लास्ट में काइंडली कम टू एनेक्सर 9 Miller.
अरे एनेक्सर 9 आपण आभरमेंट रे कोड लिखले जे आपण करे दो ना जो एप्लीकेशन करे दो ना
आई एम जस्ट प्लेसिंग इट बिफोर दैट आई एम जस्ट प्लेसिंग
जल्दी हेले होता वी आर स्पेंडिंग टाइम सर.
Yes, Miller.
Should be top of your brief.
Miller.
वो पारा रे लिखले जैसे करे दो ना बोली 26-27
पारा 7 को पारा 11 को आसन तो पेज 8. I'm just placing it for Lordship kind of this. It is relevant to mention that have Lordship got para 11 page 8 of my writ application. I'm just reading out here. It is relevant to mention that petitioner institute on 7/5/2026 made a written representation to the DMET OP number 2 stating inter alia therein that due to the unavoidable circumstances as noted above, the petitioner institute was precluded to make application to issue NOC for the academic session 26-27 Miller. As the last date for making application for the NOC for 26-27.
We cannot extend it, Mr. Das. We cannot extend. If the last date was 16th August 2025, we cannot extend it.
Miller, your last.
अरे आपण अप्लाई करि नांती आपण एप्लीकेशन ही नाही 24 मास रो
29 नवेम्बर मोर रिजेक्ट कले मु ता पूर्व केन करी मते रिजेक्ट
आपनकर 25 26 26 27 रे आपनकर जोडे रिजेक्शन नै छि देखंतु
25 29 ता योर अटलो कैन कम टू एनेक्सर 6
आपनकर से that we cannot extend, that order we cannot review.
Miller, it is their administrative order, Miller. It is their administrative within.
नहीं amount administrative no amount judicial order. हमें जोड़ा करू छु ओटा जुडिशियल ओटा एडमिनिस्ट्रेटिव नो
एनेक्सर 6 टा देखो बोलो
आपण देखो तो ठीक पेज 24 को जानतु आपण मिक्स अप हे गलानी फैक्ट गुडा पेज 24 को जानतु आपण का ब्रीफ रो पेज 24
पेज 24 आसी
हां पारा 6.1
पढुती The petition institution whose application for grant of renewal of NOC has been rejected shall comply the deficiency by 26 November 2025 if not already complied in the meantime for the academic year 25-26.
So 25-26 is very clear. So
Yeah.
now if in your this so that has nothing to do with 26-27
हजुर
यदि 26-27 रे आपनकर अगस्त थिला अगस्त 25 थिला so some of the cases say we granted time in those in prior to November वर्तमान 26 जून मासरे we can't extend time so आपनकर थाउ एबे छुट्टी अछि मिस्टर महांती इंस्ट्रक्शन नियंतु
आज्ञा
So similar matter is coming on the 10th of July. Similar matter is coming.
10th of July okay the petitioner is a petitioner institution is imparting studies in general nursing and midwifery.
Yes.
The prayer made in the writ application, the prayer made in the writ application is seeking permission for seeking no objection certificate for 60 seats in GNM for the academic session 2026-27. 2026-27. The learned counsel for the petitioner is heard at length. He submitted that he has been prevented from applying for the NOC. On being asked, what are the reasons for such prevention or who has prevented, the learned counsel for the petitioner submits that ଆପଣ inadvertence ନା କଣ କହିବେ ନା ସେଟାକୁ ଆଉ କହିବେନି ରିପିଟ୍ କରିବେ ଆପଣ କାଇଁ ଆପ୍ଲାଏ କରିନାହାନ୍ତି କିଛି ତ ଲେଖା ହେଇନି କଣ submits that due to some unavoidable reasons the institution could not apply. It is stated in the writ application that the last date for application for NOC, last date for seeking NOC for the academic session 2026-27 was
16th August. 16 August.
September, August 25, May 25.
16th August.
16th August 2025. Stop.
Okay.
Para. So notice along with this order, Mr. Rajani Chandra Mahanti, learned counsel, who usually appears for the opposite party number 2 and 3, ONM Odisha, ONM RC 2 and 3, being present in VC, appears and waves notice. He shall be served with 2 extra copies of the petition within 2 working days.
Yes, madam.
To enable him to obtain instruction. Mr. Vivekananda Nayak, learned counsel, learned AG appears for OP number 1. The learned AG shall obtain instruction. It is submitted by the learned counsel for the OP number 2 and 3 that similar matters have been posted to 10th of July 2026 before the assigned bench. Accordingly, the matters shall be listed before the assigned bench on 10th of July 2026. The response of the opposite parties shall be filed by 30/6/2026.
Yes, ma'am. Obliged.
Okay.
Upon serving copy thereof, the learned counsel for the petitioner. Yes. Item 9. Mr. Raut. Mr. Gajendranath Raut for the petitioner. Mr. Surya Narayan Patnaik for the
opposite partner 1, 2.
1, 2, and 5.
1, 2, and 5.
Number 1, 2, and 5. 3, 4 blank. Yes, Mr. Raut.
The petitioners are street vendors issued with the identity card to do their vending activities in the Konark NH area. Now the executive officer Konark NH has issued public notice for eviction, giving 7 days time to vacate the premises without any show cause and in exercise of power under section 254 of Municipal Act.
Street vending on drains? Street vending on drains and roads, which provision of that Street Vending Act, Mr. Rao?
Yes, provision.
Which provision enables you
vendors-
to vend for vending on drain and road?
Street vending act.
Because street vending, if you see, that is a concept is that you start vending in available space. But confusion is that encroachment of road. Everywhere street vendors are saying that we'll encroach the road.
No, here there is no specification.
So perhaps the literal interpretation has been given that street vending means
Lordship
vending right on the road, obstructing the road.
Lordship have a glance to the notice.
नहीं notice नो अपना provision में पचारुची who provision ने अपना drain और road obstruct करिवे so that we are with you. You are street vendors.
Yes.
We are with you. You should not be evicted. But the problem is that when street vendors can, because public right to clean drain, free flow of rainwater, storm water, as well as unobstructed access to road is a public right.
Yes.
ଆପଣ ଅଛନ୍ତି 30 ଜଣ କିନ୍ତୁ maybe if you count it will be in the 3 crore or 3 lakh or 3,000, nobody knows. The right of individual diffuse social right.
My case is that we have never encroached street or road.
कोटी कहले कोटी authority कहके लेखिक देले.
Yes,
because we are not removing you.
They have
so
not
where you have written to the authority? Where you have written to the authority?
They have not asked
Giving
for
the
so
details.
much. They have not asked for so much.
It is. Notice is a so cause.
No,
Mr. Raut,
to the notice.
Mr. Raut, you are adding that line that no so cause will be accepted. That is not there.
The notice is to
ଆପଣଙ୍କୁ eviction କରିବା ପାଇଁ କୁହାଗଲା ଆପଣ ଯଦି ସେଠି ନାହାନ୍ତି ଆପଣ ତ କହିବେ ନା ଆଉ ମୁଁ ସେଠି ନାହିଁ ବୋଲି
ତାକୁ ସେ ସ୍କୋପ ଦିଆ
ନହେଲେ you are arguing against yourself, then you do not apprehend anything also.
No, we apprehend
Mr. Raut,
anytime
what you are arguing as a double-edged, it is cuts both ways.
No,
if we say that you are not obstructing, then you are not threatened. We cannot direct them.
Yes, my prayer before this honorable
So
court,
at least in the writ application, you have stated that you are not obstructing any drain or not obstructing road.
Yes.
Where?
And I have also prayed in my prayer, let
The
an
problem
inquiry
is-
be done. If you
Sir,
are
anyway,
approaching,
sir, not
then
by
we-
High Court, not by High Court. Don't reduce us to municipality.
Yes.
You have to first advise your client to approach the authority that you are not, because you kindly read that in Odia. You are a student of Odia, just read it. The allegations are very serious.
Madam. ଏତଦ୍ୱାରା ଜଣାଯାଉଛି ଆପଣ ପରିଷଦର ବିନା ଅନୁମତିରେ ବେଆଇନ ଭାବେ ରାସ୍ତା ଓ ଡ୍ରେନକୁ ଅବରୋଧ କରି ଦୋକାନ ଗୃହ ଓ କ୍ୟାବିନ
Paper slowly ପଢନ୍ତୁ ସେତିକି ହଁ. Because this at least I don't know, single bench or division bench, I have observed that you have no right to encroach or
No, we have no right. I admit we have no right. But
no. You have a right to vend for vending. But encroaching road, obstructing drain, and causing traffic hazard, no right.
That is not my right. But Lordship said notice says.
So you approach the authority. The problem is, Mr. Raut, is that now we do not have anything for you to show that you have approached the authority stating that we are not there.
That is the
and the other problem is that you are not the noticee. It's a public proclamation.
Yes.
So in a public proclamation, who has not occupied road or drain, why he will be feeling threatened?
That the apprehension, only the apprehension. Only
The
I apprehend.
apprehensive reads cannot be issued. That's the problem.
Earlier there was a direction. Earlier there was a mic announcement, and some of the vendors approached this honorable court. This honorable court passed order. I have annexed that order.
You see, disposal orders in limine there are no precedents.
No.
And obviously, we are asking. These are the pertinent questions, and we have already, since you may be thinking that we are cutting you, sir, but since you are dearth of time, so these are to be answered. If you have anything to show that you have approached the authority, or you want to approach the authority, then you approach.
Yes,
they will dispose it of.
We want to approach the authority, but no scope given. But no scope given. That is the difficulty.
Sir,
scope given. Apana seda add କରୁଛନ୍ତି.
Sir, it is said that within 7 days,
yes,
you should vacate. Otherwise, they will take action. So within that 7 days, have you approached the authority saying that we have never encroached, or it is apprehended that you may evict us from the place from where we
And the
carry
problem
on.
is that it's a general proclamation.
7 days time given to vacate, Lordship, not to file so much.
So,
sir, it is not, you are not there. No? You are saying that you are not encroached. 7 days given to persons, those who have encroached.
Yes.
You are not encroachers, you are saying.
Yes, ma'am. I have
So
not
why you are
encroached.
threatening? You are not threatening.
But only apprehension is any time.
Apprehension
authority can.
apprehension
This is a public notice.
Public right cannot be prevented by 31 encroachers.
Since it
Must
is a
understand that.
public notice.
Mr. Raut, you are not answering our question. You don't have that answer.
No, I want to approach the
You
authority.
don't have the answer, sir. You answer.
My Lordship.
So if you are not encroacher, feel free. If you are encroacher, go and approach the authority.
Yes, Lordship, with that observation,
The petitioners
if we
have stated, themselves have stated that.
Epote na sepote. Epote nebe na sepote nebe.
Lordship, if we encroach, we may be evicted.
Mr. Raut, epote nebe na sepote nebe. Aji sorry you are na.
ନାଇଁ ଆଜି ସାରି ଦିଅନ୍ତୁ ଲର୍ଡସିପ ଆଜି ସାରି ଦିଅନ୍ତୁ
କେତେ ଦିନରେ ଯିବେ ଅଥରିଟି କେତେ ଦିନରେ ଯିବେ କାଲି ଯିବେ ଇଲେକ୍ସନ ଡେଟ୍ କୋଉ ଦିନ ଥିଲା
ସିଏ ଥିଲା ଲର୍ଡସିପ 13/5 ରେ ଦେଇଥିଲେ ନୋଟିସ
ତାହେଲେ ତ ବହୁତ ଦିନ
ସରିଗଲାଣି
କିଛି କରିହବନି the petitioners have stated themselves to be members of a ବ୍ୟବସାୟୀ ସଂଘ 31 in number and have stated that they are street vendors under the definition of the street vendors into bracket protection of livelihood and regulation of street vending bracket closed act 2014 they have approached this court apprehending eviction pursuant to the public notice annexed to the writ application marked as annexure 7 dated 13/5/2026 the public notice in Odia, if translated to English, states thus: it is notified that those who have obstructed road and drain and have constructed a shop room, public cabin, leading to traffic hazard and accidents, also preventing cleaning of the drain. Stop. It is further stated in the said, it is further indicated in the said notice that, it is further indicated in the said notice that such obstruction and as well as encroachment violates sections 254 of Orissa Municipal Act 1950 and such encroachers are directed to remove the encroachment from road and drain within 7 days. Since the notice is general in nature issued by the opposite party number 3 NSE, the learned counsel for the petitioner was asked whether the petitioners have encroached road and drain as indicated in the notice for removal. He submits that the petitioners have not encroached any road, public road, nor have constructed any cabin over drain. He submitted that the structures, public cabins made by the petitioner is not obstructing road or not preventing removal of, not interfering cleaning of drains. Stop. In the writ application, no such document is annexed, indicating that the petitioners have approached the authority, stating that they are not encroaching upon road and have not constructed any structure, public cabin, over drain. Stop. It is submitted by the learned counsel for the petitioner that petitioner shall approach the authority if granted some further time. The learned AG appearing for the opposite parties 1, 2, and 5 submits that if the petitioners approach the appropriate authority, decision in accordance with law shall be taken by the authority. In view of the limited nature of submissions made on behalf of the petitioner and a limited green order, those approach we have said that you approach the authority by 15/6/2026. Correct. Highlighting that you are not encroaching road nor obstructing drain. The authority shall take a decision strictly in accordance with law, particularly in view of your contention that you are not obstructing or highlighting. And decision shall be taken by 25/6. Status quo as on date regarding nature, character, possession, ownership shall be maintained till 30/6.
Yes. Okay.
Mr. Gajendra Raut, you are a smart counsel, you must understand. By the next date, they should remove and settle at a new place.
Yes.
So that gives them a fresh lease of life.
Deeply.
But please don't obstruct road that tells upon our.
That should not.
No, because in public we are being rather as a community we should not be, because it's a tourist place.
Yes, they have right of relocation. Yes, that should be.
But don't, because this what you are arguing, it cuts both the ways. Apply kar diyo, jaha kare karantu. Jaldi karantu. Yes. Item 10.
May I please, Your Lordship?
Yes, please.
The portion to government notification, my land was acquired by the government for the industrial purpose.
Yes,
yes. And in the meantime, my lord, they have not taken the position.
So you have kindly look at your prayer at page 6. Just go through it, because we lost time again for disruption also.
Yes, my lord. My limited grievance before Lordship. My repentance is pending for the.
So there you see, it has unlimited consequence. Because this if you read go through the scheme of Land Acquisition Act, there is no such concept of consideration of representation. So they have to file counter.
My lord, one thing, Your Lordship kindly say as for section 24, in the meantime 16 years already passed, and also my lord, and it is
Mr. Mohanty, we cannot exercise the power of Land Acquisition Authority.
Only my
we have also read 4, 6. All these things are there. What you are saying may be correct, but after 16 years, we cannot direct disposal of representation. Let them file their response.
Then acquisition proceedings are deemed to have been left as per section 24.
Sir, that they have to respond. We cannot. It is not a that will.
No.
Notice never na nebeni. Notice never na nebeni.
Hari gote the representation disposal order ta kordele.
No. Representation disposal. You see, you have to some respect for law. Who is that authority who will take up a land acquisition proceeding representation?
Or compensation response are देना दे.
Say act re section re achi representation ta.
Mr. Bhanti, what about opposite party number 4? You have to take notice.
But only move compensation by
So, Mr. Mohanty, apanako land kebe jodi acquire heitibo, apan kodi dekhibe. It is a fact. What you are saying may be correct.
Yes.
But the reasons are different. The reasons are their perception. It is their perception. Ame jodi tilu seiti achu. So there are so many things. In a land acquisition matter, there are so many things. The petitioner in the writ application claims to be a land hostee. Pursuant to the notification published in the year 2010 in LA case number 14 of 2010 by the appropriate authority, oblique state government. It is submitted by the learned counsel for the petitioner that the petitioner's land has not been acquired. He has not been paid any compensation and remains in possession of the said property. Stop. The prayer made is for restoration of the land to the petitioner.
Sir, main thing is, sir,
in considered opinion of this court, such prayer can be adjudicated in accordance with the provisions of the LA Act, Land Acquisition Act, so and so, so and so. But is to notice along with this order, Mr. Subhavikas Panda, learned AG, appears on behalf of the opposite parties 1, 2, and 3. Notice to OP number 4 by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 3 working days. The opposite parties shall file their counter by 3/7/2024 upon serving copy thereof on the learned counsel for the petitioner. Petitioner shall have liberty. Status quo after 16 years. We have to reject it. If you insist, we have to reject it.
But pendants of the writ application, the shall not be barred to dispose of my application.
No repentation. Repentation we cannot. You must understand that.
Pendants of the writ.
Once a student of law, always a student of law. So we can't just start repentation everywhere. Like matrimonial matters, repentation by husband to wife. Somebody suggested. On the counsel for the petitioner shall have right to file, shall file the rejoinder if so advised within 7 days thereafter. Within 2 weeks, the matter shall be listed for orders in the week commencing. Week commencing 20/7/2024 before the assigned bench.
Any Indian model lordship?
It has to be rejected. The IA prayer made in the IA is for maintaining. Anyway, that is gone to it. The IA shall lie over.
Status only that.
No. Status quo 16 years for it.
High
Court should not interfere.
Actually,
check karibe 4 re kon hechi 6 re kon hechi both things such.
Nahi sir 24 অনুসারে
সেটা সে কহিবে লাস্ট করথিবো we cannot say. They have to respond to that.
For a purpose kahi mu file korchi actually eta
Mr. Mohanty, there is no presumption after 16 years we will presume. And High Court should presume. That is no provision.
Actually more new background sir mu pai bhalo compensation pai paribi. That is why my representation disposal. Seita sei
purpose ta ame bhabi noti bole apun kim jane. That also we must think our response buji jaitibe. So let us not enter upon the one side pipe and let them respond. সেটা ওরালি কইলে হবনি আপন কোজন সে করি নাকি মিস্টার পন্ডা এন্ড দ্য জেএসপিএল শুড সেড আমি কিছু করিনু has Mr. Panda said আমি কিছু করনু বলি they have to concede. Where is the presumption that when the writ application filed the other party concedes?
Only actually যেহেতু ল্যাবস করিও যে status quo today be maintained.
No status quo. If you insist, we can reject, but purposefully we are not rejecting it.
As you lost.
Yes.
Same. All are same. All are same.
11 is same.
Subatom for same.
Subatom same, right. Cortical आवाज नहीं किसी सुनी पढ़ लें अच्छी
Mr. Panda, sub-items are same. Mr. Suraj Mahanti's case,
party number 5
sub-items are same
same
or similar.
opposite party number 5 is different. that opposite is Jindal.
yes,
সেটা
yes.
সে স্টেট পাই হ্যাঁ অ্যাপিয়ার করেছে
State
ওটাকে
Notice
চেঞ্জ করুন নর মতে দেখিলা পরে
notice টা করুন requisites
Mr. Siddhartha Das for the petitioner. Let us
on behalf of
for the petitioner.
here, my lord, this is bank matter.
हाँ surface है देखो तो इतने high court रो किसी jurisdiction नहीं है.
Yes, my lord, it's a
The
very
Supreme Court has come down heavily.
true, my lord. True, my lord. I understand.
Thanks,
Here,
my lord.
fact
And it is true that we remain as high court also. What have Alex of to Mr. Das?
Lordship, kindly have to grant
The bank has initiated a recovery proceeding under securitization and reconstruction.
That already got. I only need 6 weeks time because my agreement is still exists 2030, my lord.
So you ask
So
Mr.
we
Bala,
need to
Mr.
restructure
Balakrishna
this.
may say
So,
Mr. Bala,
Lordship, kindly have a class annexure 4.
Mr. Das,
Annexure
Mr. Das kindly just don't mind because we have to court short the proceeding because already we are running behind the schedule. So Mr. Do you agree for 6 weeks, Mr. Balakrishna?
6 weeks is too long, my lord.
Okay. खरा दिन 6 weeks कौन too long?
Then again, it is on 18th.
Mr. Das ଆପଣ କାଇଁ long weeks କାଇଁ ନଉଛନ୍ତି ଆପଣ ତ ଏତେ ଦିନ ହେଲା ପକେଇ ରଖିଛନ୍ତି
18 ତାରିଖ DRT ରେ fix ଅଛି for appearance of the petitioners. Let him.
ସେଇଦିନ କହିବେ ସେଇଦିନ କହିବେ ତାହେଲେ 18 ଯାଏ କିଛି ହଉନି ତ
ନା 18 ଯାଏ କିଛି ହଉନି
ହଉ ଠିକ ଅଛି Art Mr. Siddhartha Das लिखिले Mr. P.B. Balakrishna, Learned Counsel, upon instruction appears on behalf of the opposite party. Wakalatnama on behalf of the opposite Wakalatnama executed by the opposite party in favor of the Mr. P.B. Balakrishna shall be accepted. Stop. The writ application has been filed with filed inter alia with the following prayer. MP following prayer लिखंतु with a prayer for passing the order dated 22/5/2026 and allow the and with a further direction and seeking further direction to enable the petitioner to file OTS application for one-time settlement. Perusal of Annexure 4 indicates that the said order dated 22/5/2026 has been initiated, has been issued, directing the petitioner for vacation / peaceful possession of the property in a proceeding, in a recovery proceeding initiated under the Securitization and Reconstruction of Financial Assets and Enforcement of Security - Interest Act, 2002. देखिए लिख पहले just 20 days. The period of notice is given for 15 days to the petitioner. Stop. It is submitted by the Learned Counsel, Mr. P.B. Balakrishna, upon instruction that the matter is posted before DRT. Mr. Balakrishna, can you hear us?
Yes, madam. Yes, ma'am.
Yes, before DRT, the matter is posted to
18th of
June 026. Stop.
In OA number 94 of 26.
94 OA number 4.8 number 94 of 2026. In our considered view, no purpose should be served in the matter if the matter is kept pending before this court, more particularly when it involves adjudication of a recovery proceeding under the Surface Act 2002. Stop. The petitioner shall have liberty to raise all the contentions before the DRT. Mr. Balakrishna, can you direct status quo till 18 as on date?
I assure that nothing will happen until 18th. This is my assurance.
Okay. Okay.
This is my personal.
The petitioner shall appear on the on the date the matter is taken up, that is 18/6/2026. With the aforesaid observation, the writ application is disposed of.
Oh, pleasure.
Yes.
Till 18 they have stated that may be recorded. Nothing will happen.
I'm giving
record calling will be
personal listing.
record କରିବାଟା ଠିକ ନୁହଁ you are appearing for bank ଆପଣ ବ୍ୟାଙ୍କ ରେ appear କଲେ you are एकदम ପୁରା କିଛି ଛାଡୁନାହାନ୍ତି so ସେଟା ଯଦି ଆମେ status quo ଦବୁ ତାହେଲେ ରେକର୍ଡ କରିବୁନି ତାଙ୍କର ଏଟା
ସେଥିରେ status quo ଥାଉ
ଠିକ ଅଛି 18 ଯାଏ ଯେ ହବନି କାରଣ ଆପଣ ତ ଏଟା eviction notice ଟା yes
Item
Mr. Sukanta Kumar Dole for the petitioner. Yes, please.
Let's in this matter, let's say, in fact, the petitioner earlier had approached this honorable court, challenging an illegal construction over Gochal land, which is prohibitory under the Lordship OGLS Act. And
So just look at, just since we are running short of time, you straight away go to page 41.
Lordship, grateful, Lordship. Lordship.
So third subpara.
Lordship.
The third no set up 1, 2, 3, 4, 5, 6 paragraph. So table division. Whereas the Tahsildar Konasa has assessed the Gochara land and has reported that surplus Gochara land is available in the said village.
Lordship.
So that is the principle.
No, Lordship, kindly come to state and Lordship come to page.
Building is for Health and Family Welfare Department sub-center.
No, Lordship, kindly come to page 31.
Yes,
It cannot be against rule of law. Lordship, please come to page 31.
So you take notice. Beyond that,
Lordship, for a moment, let come to page 31. 1 minute.
No, we must, Mr. Dole, because we have to start.
But I want an entry order. That's why.
The entry order can it be granted?
No, Lordship, please.
Status quo as on date. Status quo as on date.
Status quo as on date. Grateful, Lordship. Status quo as on date.
You have to record that. The petitioner is before this court for the second time. The third time.
It is second time petition.
ଆପଣ ପାଖକୁ କଣ 3-4 ଥର ଥରକରେ କାର ହଉନି
ସରକାର ବାରମ୍ବାର ବାଧ୍ୟ କରୁଛନ୍ତି ଆସିବା ପାଇଁ
ନାଇଁ ମୋ ସେମିତି କଣ
ସରକାର ଆମକୁ ବାଧ୍ୟ କରୁଛନ୍ତି
ଆପଣ ଯୋଉ ଆପିୟର କରୁଥିଲେ ମୁଁ ଆପଣ ଫୋନ କରି କହିଲି ମୁଁ କୋଉଠି ଆପଣ ଆପିୟର କରୁଛନ୍ତି ଆସନ୍ତୁ ଗୋଟେ ଜାଗାକୁ ଆପଣ ସାଙ୍ଗେ ସାଙ୍ଗେ ମୋ କଥା ମାନିକି ଯାଇ ବସିଲେ ଆପଣ ପୁରା ୟେସ୍ ମିଷ୍ଟର ଦାସ ଆପଣ ବାଧ୍ୟ କରୁଛନ୍ତି ତାଙ୍କୁ ଯୋଉ ସବୁ କେସ୍ 4 ଥର ଗୋଟେ ଗୋଟେ ପିଟିସନର ଆସୁଛନ୍ତି ତାଙ୍କର ବହୁତ ଅସୁବିଧା ହଉଛି ମିଷ୍ଟର ଦଳେଙ୍କର Mr. Sasso, ଏଥିରେ Mr. Tripathi, sorry, Mr. Tripathi ଆପଣ ବହୁତ ହଇରାଣ କରୁଛନ୍ତି ସବୁ କେସ୍ ତ 4 ଥର ଫାଇଲ କରୁଛନ୍ତି ମିଷ୍ଟର ଦଳେ
Earlier, he has filed the writ application. It is
ହଁ
pending.
ମିଷ୍ଟର ଲେଖ ଆଉ ଗୋଟେ ସ୍କ୍ରିନ୍ ଦରକାର ନା ଆପଣ ତ ସରି ସେ ଛିଡ଼ା ହେଇକି ଦେଖୁଛନ୍ତି କିଏ ଆପିୟର କରୁଛି actually since court master is sitting that side he is standing up to look who is appearing on that side it is actually visible. Mr. Sukanta Kumar Dole for the petitioner, Mr. Tripathi, Aurobindo, Mr. Aurobindo Tripathi, AG, sorry, Mr. Aurobindo Tripathi, AG for the opposite parties. The petitioner before this court is for the second time after the earlier writ application was disposed of.
No, that is pending with the operation of interim order.
Yes, sir.
Sir, construction is Lordship. Earlier writ application pending with the operation of interim order.
Upon declaration ta nahi
Lordship, I have quoted the order, Lordship.
अच्छा हाँ नहीं अच्छी तोरबर होती ना declaration अच्छी page 3 रे अच्छी वो पूरे पाव नथि
Lordship.
Second, earlier writ application WPC number 196120 of 202624 still pending adjudication. Essentially, the petitioner challenges the order at Annexure 2 passed by the collector Puri dated 25/9/2025. Stop. It is submitted by the Lorded Counsel for the petitioner that the Gochara land at Goda Balabhadrapur under the Konasa Tahsil in the district of Puri has been reserved for construction, which is not in accordance with law. Yes, Mr. Tripathi, you were saying something?
Well, it is the government land and the government has tried to construct the land, building.
It is submitted in response, sir. It is submitted by the
EGA for that the land is government land of Kisam Rakhita Anavati. That is for future development. And due process has been followed for de-reservation of the Gochara Kisam. De-reservation of land of Gochara Kisam. Stop. Issue notice along with this order. The learned AG upon advance copy served appeals and waves notice. We shall file counter by 36.
Mild.
By 36/2026. Alright. Upon serving copy thereof from the learned counsel for the petitioner, the petitioner shall have the liberty to file rejoinder if so advised within 2 weeks. The matter shall be listed for orders in the week commencing. Commencing 6/7/2026. Within 10 days, 10 days, 6/7. Construction chalichi na karo city.
No, construction stay ହେଇଛି lordship. Construction stay.
Acha, IA 10611 of 2026. It is submitted by the learned counsel for the petitioner that as per the interim order passed by the coordinate bench. So a single bench or division bench?
Single lordship, that is division bench lordship.
Coordinate bench.
Coordinate bench lordship.
WPC number 8. I got provide WPC. Hello.
I have no instruction whether the building was constructed or not.
Okay. Construction has been stayed. Construction has been stopped. Stop. So they have a WPC 19612 of 2024. Order date?
Order 28/8/2024 lordship. August, 28 August.
Stop. But as an interim measure, they will issue notice as above. The learned AGS shall obtain instruction and file response of the opposite parties. As an interim measure, it is directed status quo as on date regarding nature, character, possession, ownership of the property of the subject property regarding which dereservation order has been passed by the collector Puri shall be maintained by the parties to the writ application till 14/7/2026. Subject certificate copy as per rules. Parties shall have liberty to sentence complete. Act upon. Yes. Yes, next please.
Item 30.
Lordship, next item, lordship, very limited prayer, lordship. Perhaps Honorable Justice, lordship, Raman has had this matter with you, Honorable Justice, Chief Justice. Matter is kept for orders, lordship. And perhaps a positive has been taken. But in the meantime, lordship, kindly come to para 30 and 37, page 17. Now they have, lordship, selected OP number 5 and they have, lordship, obtained for, they have recommended for approval. So that is the lordship, because none of the applicants are, as per their recommendation, are qualified. And this entire tender will go, lordship, and it has to be, lordship, come to the fresh tender. And views have already taken by this honorable court, and matter was kept for orders, but it could not be, lordship, taken up before vacation. Now they are going to, lordship, award the contract to OP number 5. That's why the second date application, lordship.
Mr. Das, you are appearing.
Yes, my lord. I am appearing. My lord, the present writ application.
Just 1 second, I dictate the Mr. Sukanto Kumar Dolai for the petitioner, Mr. Saswat Das, AGA for the opposite parties, 1, TO2, 4. Hello. OP5, anyone appearing or blank?
I will notice the 5.
It's a fresh matter. The OP5 blank. Yes, Mr. Das.
My lord, the present writ application, identical prayer, exact verbatim prayer made in the present writ application, which is similar to the writ petition which was filed as WPC number 13582 of 2026.
Yes.
If your lordship will find at page 24, page 24, the present prayer C for cat, and E for elephant, E. Both are similar to the prayer made in the previous writ petition, that is B and D.
Yes. I mean, in that petition, A to F, they have been now that is in reverse order. F to A.
Yes.
That is your submission. Yes.
Yes, my lord. But two identical prayer, but that is one of the submission, my lord. And moreover, the finalization of tender and opening of the lottery, but everything has been brought to the notice of the Honorable Court on 6/5 in the previous writ application. Thereafter, the matter has been last adjourned on 8/5/26 to 13th May 2026.
For orders.
But for orders. And in the meantime, no orders has been passed. And this has been brought to the notice of the Honorable Court that the L1 bidder has been selected.
Just
Now,
what best can be done? Both to be listed.
But this writ petition should be outrightly rejected, because this writ petition should be outrightly rejected because identical prayer. That is only by submission. Your lordship may keep it.
Mr. Das, the process, that writ application will be infructuous and this application will be rejected. Then where will he go?
But that was brought to the notice of the Honorable Court. But
Mr. Das is saying that it was intimated to the court regarding the further development as pointed in the present writ application, intimated on
it produced in the shape of instruction before the Honorable Court, my lord.
Okay. The petitioner in the present writ application has approached for the second time during pendency of his earlier writ application, WPC number 13582 of 2026. The said application is still pending disposal by this court. The petitioner was a competing bidder for the work, competing bidder and participated in the tender process pursuant to the notice inviting tender for bridge works in Odisha dated 8/12/2025 into bracket annexure 1. It is submitted by the learned counsel for the petitioner that during pendency of the writ application, the subsequent developments have happened. That is, shortlisting of successful bidders have been made.
Lordship, they have selected OP5 and sent it for approval, Lordship, during pendency.
The OP number 5, se party thile na nothile setire?
No, Lordship. The tender
party nothile, but instruction that produce itala.
Right. So OP number 5 in the present writ application has been selected, and his selection has been sent for approval to the appropriate authority. Stop. The learned AG upon advance copy served and submits that the development as the further development as contained in the present writ application is correct, but the said aspect has already been apprised to the court.
No, Lordship, did not apprise. Only they had made Lordship only appraisal of lottery, not to the selection. Lordship, they made a statement lottery is going on, but no.
Are apna submit karantuni mor kaso hochi na jauni.
Lordship, sorry then, sorry, Lordship.
We have only informed
Sorry,
L1
it's a
bidder has
matter-
been selected.
Submission. I am not recording. This is submitted. This submitted by Mr. Das, not duty. Mr. Das upon advance copy should appears and submits. What is it? Further development as stated in the presented application and contended by the learned counsel for the petitioner has been already brought to the notice of the coordinate bench when the bench was in season of the matter on 6-5-2024. The matter was listed on 8-5-2024 and was adjourned to 31-5-2024.
No, 13-5, Lordship, for orders.
13-5.
13-5 notice for orders.
সেটা কো মু উল্টে দিয়েছি, I'm sorry. जो লিখিছি 13-31 লিখ দিয়েছি।
13-5 for orders.
I posted to 13-5-2026 for orders as the matter could not reach attain finality. Stop. In considered in view of the aforesaid in the aforesaid facts and circumstances, we are of the considered view that both the next data janchandi. 13-5 पर date janchandi.
No, that part for date in Lordship.
Date 26 पर के बिल्कुल के 26
नहीं सर सदर कुछ ऑर्डर पास है नहीं
Connected.
In the person since insurance is
That both the writ applications, that is the earlier writ application, the pending WPC number 13582 of 2026, as well as the present writ application WPC 17688 of 2026 shall be listed for the coordinate bench in the week commencing 29/6/2024.
So,
notice be issued to the
number 5.
Notice be issued to the OP number 5 by speed post with registration and proof of delivery. Requisites for issuance of notice filed within 2 working days.
Lordship.
Better you do it today.
Today, Lordship.
Because returnable date will be sought actually.
Lordship, today.
It is in your interest. Yes.
Today, Lordship.
Within 2 working days. Fixing returnable date to 23/6/2024.
Lordship. In the meantime, they should not proceed, Lordship. Final kar debe this such, Lordship. They should not
This is already notice no chanti apan.
No, Lordship,
entry model lekhantu that IA 10723 of 2026 and Learned Counsel for the petitioner. He reiterates his submissions as noted above. Stop. The Learned AG again refers to his submissions. The Learned AG also refers to his submissions as noted above. Stop. It is directed that any action taken during pendency of the writ application 17 should have 17 no.
No, sir.
Any action taken by the authorities during pendency of the WPC number 13582 of 2026,
Lordship,
as well as the WPC number 17688 of 2026, shall abide by the result of the writ application and shall be subject to further orders to be passed by this.
Grateful, Lordship. Grateful.
Agent certificate copy as follows. The party shall have liberty to act upon the copy of the order obtained from the official website. Yes, next please.
May please, Lordship, my lord.
Mr. Misra. Satyanarayan Misra for the petitioner. Yes, Mr. Misra.
Madam, my minor daughter having heart problem has been kidnapped from 16 to 26. By the
State to नांदी ट्रेनिंग काउंसिल अछंती कि देखिन खोजिले एजीए की एससी कोन लेखन बुझंतु
Devraj
मिस्टर महांती
My lord.
मिस्टर देवराज महांती मिस्टर तपन कुमार दास यू आर विजिबल इन वीसी
My lord.
एटा कहार आइटम सर
Ita
14 टा
Tapan Kumar Das.
ठीक अछि तपन दास एजीए भी अछंती बोधे हां अछंती
My lord, my lord.
अछंती यस यस पड़ी गले
My
सर
lord,
हिजोस तापस रे भी आपन को खोजिया पड़छि तो
my lord, it is first time I am sitting in VC, my lord.
Bueno, never. Mr. Satyanarayan Mishra for the petitioner, Mr. Tapan Kumar Das AGA for the opposite party. The petitioner seeks interference of this court by filing the writ application for rescue and production of the minor daughter of the petitioner who has been allegedly kidnapped by the opposite parties 4 and 6.
4 to 6.
4 to 6. Stop. FIR has been lodged before the concerned police station. That is Naikanidhi. Naikanidhi in the district of Bhadrak. Stop. The learned AG upon advance copy short appears and waves notice. He shall obtain instruction. Status report shall be produced. All out efforts should be made to rescue the minor girl. Stop. Upon rescue of the minor girl, her statement shall be recorded immediately by following due procedure. Stop. The matter shall be listed for order of fresh admission.
Also fresh admission.
Listed for fresh admission in the week commencing.
Continue.
Until 6/2024.
Date allotment weekly once internal matter would be tax matter.
Better होची weekly so that date fiscal problem है जो आपको yes Mr. Das instruct them to act upon. Yes. Starting council asible.
Yes, ma'am. Item number 15.
Mr. Dilip Kumar Rai for the petition.
My lord, the petitioner has filed this matter to release his girl child from the custody of the opposite party number 4 to 9, my lord.
I mean, see, you are alleging she is missing or she is in illegal custody, illegal confinement.
My lord, she is in the custody of the mother and the the maternal parents of the mother, my lord.
So illegal havani.
Mother is living in.
But my lord, the mother is living in Bhubaneswar. She is not even taking care of the child, and there has been an ad regarding the sale of the child, my lord.
नाटा कर देना थी मिसेस केमती ना बाबू मिसेस सब पवित्र गिरी कोण ना अरे तर नाटा देबे नी पार्टी नोटिस केमती हो
As per the judgment of the Supreme Court, the register those who are stamp reporter, they compelled to not to mention the name of.
It will be given, but it will be redacted.
But reduction of the माने alleged ये पर girl child देबे नी
The girl child they compelled us not to give anything with regard to the lady for which is that it has been stated the mother of the victim and so also the grandmother of
the आपण custody file करिया कथा आपण माने झियोटा माइनर गर्लटा अछि का पाखरे मा पाखरे अछि तो
the मा पाखरे वर्तमान मा she is living at Bhubaneswar and living that
से जोटी रोज आज्ञा से भुवनेश्वर की जब ट्रैवल करंतु अमेरिका सेटा दैट्स नॉट द इशू
मालूम है काइंडली
you should not have. You are aggravating the situation only. Why you involve police and all that?
Mala 21 page 21 में काइंडली see on Facebook.
Facebook आपण देखछन बोली कोन कोड देखिबे की
फेसबुक रो किछि नाही आज्ञा नाही सेतरे जातुनी सेटा कंप्लीटली inadmissible in evidence
ଆପଣ କେସଟା ଅଲଗା ଜାଗାରେ ସାର୍
she has given advertisement
purpose ନୁହଁ କଷ୍ଟଡିଟା ଅଲଗା ଜାଗାରେ ଅଛି ଅଲଗା ଆଇନ ଅନୁସାରେ ହବ
ଆପଣ କରିଛନ୍ତି ଠିକ ଅଛି ମାନେ ବଟ ଆପଣ ମଦର ର କଷ୍ଟଡି କହିବେ ଇଲିଗାଲ କଷ୍ଟଡି କେମିତି ହବ and that way minor child
the mother has left
ଠିକ ଅଛି ନୋଟିସ ଆରେ ମଦର has left ସେଟା ଆପଣ କହିବେ କେମିତି she can have she will be working a working lady how she will carry the child so her family will support her
and I have not been intimated. I have not been allowed to meet her.
fact, he must approach the family
I guess again, parents fighting over custody and not allowed is a common happening nowadays. That is not an but this is not a solution.
But it cannot be a case under habeas corpus.
Mr. Mahanti were appearing. Can I look?
For the state file, yes.
Mr. देखो दिलीप कुमार राय
ମାନେ କିଛି ନ ଲେଖିକିରି सर्टिफिकेट ତାଙ୍କ ନାଁ ବି ଲେଖି ଦେଇଛନ୍ତି
ଆଜ୍ଞା କପିଟା ବି ଦେଇନାହାନ୍ତି ମୂଳରୁ ସେ ଖାଲି ତାଙ୍କ ସବମିଶନ ରୁ ଜାଣିଲି କପି
ଆପଣ ଚକୋଲେଟ ଚାରିଟା ନେଇଛନ୍ତି ତାଠୁ କ୍ୟାଡବରି
LMS ରେ ବି ଆମେ ଡାଉନଲୋଡ କରିପାରିଲୁ LMS ରେ ବି ଆମେ ତାଙ୍କ ରିପ୍ରେଜେଣ୍ଟ କପିଟା ଡାଉନଲୋଡ କରିପାରନୁ ମାନେ LMS ରେ
Lorded Council appearing
my daughter's name may kindly be mentioned
ନା ସେଟା ପଚାରୁଛି ଭୁଲିଗଲେ
Sai Sangeeta Rai, my lord. That's right.
Miss Sai Sangeeta Rai for the petitioner Mr. Standing Counsel Gyanaloko Mahanti for opposite parties 1, 2 and 3 4 to 7 blank. The petitioner is the father of a toddler. Kebe janma hoitala?
Birth certificate is given
of a minor girl child.
Birth certificate is at M.S.RAMAN.
Is it about 2.5 years?
2.5 years, man.
The statements made in the writ application indicate that the matter is in the nature of custody. The prayer is in the nature of seeking custody of the girl child by the father. There being a possibility of mediation between the parties without expressing any opinion on the merits of the contentions raised in the writ application, notice we issued on the question of admission to the opposite parties. Learned Standing Counsel upon advance copy served appears and bears notice on behalf of opposite parties 1, 2 and 3. He requests for one extra copy of the writ application. One extra copy of the writ application. Notice be issued to the parties, opposite parties 4 to 7, whose name has been redacted, whose names has been redacted in their appropriate address, indicating that the matter is likely to be disposed of at the stage of admission.
As indicated at
the learned Standing Counsel is also requested to obtain instruction. ଆପଣ କାହା ଥ୍ରୁ ଆଣିଲେ ହବ ୱିଦାଉଟ୍ ପୋଲିସ ନା କାହା ଥ୍ରୁ ଆଣିବେ
ପୋଲିସ ଯାକ ପାର୍ଟି ମୋ ପାଖେ ଦେଖି ପାରୁନି
opposite parties authorities without any way taking any coercive measures regarding the present situation of the minor child. The learned Standing Counsel shall also apprise the authorities that this is a matter of custody, and at present custody is alleged to be with the natural guardian, that is mother. Stop. The matter shall be listed for fresh admission. Sir. We commencing 6/7/2026. Yes. Yes, next. Yes.
May I please, your lordships?
Yes.
My lords, this matter, if your lordships would just see the earlier
notice.
order dated 15/1/26.
You take.
Now, there is already notice which has been issued earlier.
Okay.
But a liberty was granted that if any coercive measure is taken, then we can reapproach the court.
Yes.
In the meantime, even after the notice was issued, after that, a second contempt has been filed. Earlier contempt, first application was filed, which was disposed of.
Mr. Rudra Prasad Nanda, senior advocate, along with Mr. Sanjay Das for the petitioner. The learned senior counsel refers to the order dated 15/1/2026 issued by the coordinate bench, which indicates which is reproduced here. Stop. After the notices have been issued by the coordinate bench granting liberty to the appellate to approach the court in case of any coercive action is taken for implementation of the impugned order, it is submitted that a contempt application has been filed for the second time.
Second
time amendment Contest of Court Act second third filed for the second time.
I filed for the second time actually. We can't say second contempt because
second contempt first contempt.
It will be presumed that there is a contempt.
The Contemptuous Act is condoned actually.
Yes.
So the contempt application has been filed for the second time. Did I mention it?
Line 65.
Yes. WPC Act along with IA 1935 of 2026. That Gotagare order cover that is CUNTC number 965 of 2026, wherein notices have been issued fixing date of appearance
on 22nd June.
Yes, 22nd June 2026. Copy of the said notice has been annexed to the writ appeal to the IA marked as Annex 3. Stop. And accordingly, in view of the above development, it is directed that the order impugned in the writ appeal dated 21/11/2023, passed in WPC number 37169 of 2023. 24/2025, passed in WPC number 11986 of 2024, shall not be given effect to until further orders. The matter shall be listed before the assigned bench as directed by order dated 15/1/2026.
There is no direction actually, any date. It said after service of notice. So it has not. So any subject to your lordships.
Okay, shall be listed before the assigned bench in the week commencing 13.
13/7/2026.
So issue notice to the opposite party. Requisites for issuance of notice by speed post with registration and proof of delivery will be filed within
3 working days.
3 working days. Supper in the interim it is done.
Oblige.
Yes.
At 17, what she could kindly consider. I filed one
IA. Kumar Ratha, senior advocate, along with Mr. Saibrat Ratha for the petitioner, Mr.
Deepak sir.
My lord, I beg pardon, my lord. In this case, my lord, we have not been served with a copy of the repetition. We have for the open number 4.
State, State, Mr. Devaraj Mahanti, AGA for opposite parties. 1, 2, and 3.
My lord.
P4, DSGI, so PK Padi Senior Advocate, DSGI along with Mr. Deepak Gochaya, CGC. It is submitted by the CGC that he may be provided with copy of the application.
We have no grievance with CGC, madam.
Yes.
I have also not received the copy of the amendment petitions.
But amendment I am not pressing. Your Lordship may kindly consider for the immediate urgency. Why I have mentioned and got it listed. Lordship will kindly see, not just one thing. Pursuant to the common cause case, there was a demand raised against me. And the demand, though was challenged before the regional authority, we considered that we will pay the demand. And thereafter, despite though that order should not have been challenged on consent that was passed, but it was a writ petition was filed. But this Honorable Court also gave us liberty to deposit the entire amount. Before the direction was passed, we have deposited the entire 2,72,79,111. It's a small iron ore mines of 11.537 hectare. We have deposited the entire government dues. Lordship would kindly see one just page 31. Kindly see one. Page 31. Kindly see. Their own deputy director, their own director of mines writes to the government. Kindly see, my lord. Payment of compensation for so and so. Page 31, Annexure 7. In reference to the subject, let's got it, my lord.
This is para capital B.
Exactly.
Capital B at page 32.
Exactly. So these two paragraphs, para A and B, as such, presently no compensation demand amount is due against the lessee in respect of the said mine. After fully payment of the compensation demand.
So what is the remaining issue then?
Then after this amount was paid, in fact, they should have reconsidered it and restored my lease back. But this letter was written by the director of mines to the government, and matter is still pending with the government. Since 2024, the government is yet to take a call on the question of recalling the termination order and restoration of my lease. The matter is still sub judice before the government. Now it is at this stage, my lord, I must bring one fact to my lord's notice. The order which was passed by the coordinate bench of this Honorable Court earlier, that was also challenged before the Honorable Supreme Court, and Supreme Court dismissed it. But matter did not rest there. Thereafter, one more writ petition was filed, page 38. If your lordship would kindly see page 39, the Honorable Coordinate Bench, para 5, granted liberty to the petitioner to raise his contention before the appropriate forum. The same is legally available to him. That means he could have raised it before the secretary for restoration of the lease because he has paid the entire dues. Mr. Mahanti will agree over there. He is fair enough to see all these things. I have paid. There is not a single due pending against me. But despite all this, a letter is issued to me, take over possession of my lease. The leasehold mines only 11.537 hectares, and that's the only source of livelihood. Kindly see Annexure 1, 20th of May 2026. But IA, to my IA today, 10127 of 26. If I can, I'm so sorry. What I'm trying to suggest.
Regarding that amendment, you do not want to proceed with amendment.
No more amendment is necessary, my lord. Now that I will be suggesting and requesting my lords to direct the government to take a decision on the director of mines letter dated of 2024.
I will file a counter, Millers.
So till that date, at least
they have paid all the amounts, Millers. I have taken instruction, Millers. I am not disputing that amount. But lease has been, Millers, lapses under 22A from 2011, Millers.
No, 2018.
It has been drawn off, Millers, termination of the mining. Termination is surviving now, Millers. The termination is goes, Millers. So mining cannot even survive.
Lapsing date Mr. Mahanti, lapsing date apna kebe kochoti?
Lapsing, Millers, from Millers till Millers 10/9/2009. Yes, continuing operation. After 2 years, Millers, 10/9/2009 lapsed, Millers.
It can't be.
That is the proceeding, Millard, under section, Millard, there is.
So is there any order regarding that, or you are relying
Yes,
on?
yes, Millard. Annexure 2.
Annexure 2,
kindly see. Yes.
There is a termination of the order, Millard.
Yes. Kindly see. Only for non-payment of this due which I have already paid. Kindly see, madam.
It is lapses, Millard. 21 months.
Where is the question? Lapsing is different. Termination.
1210 of the.
Yes, Mr. Mann.
There is a termination, Millard.
So after this,
unless until termination is revived, Millard, by the government, so Millard, it cannot be Millard. So therefore, I will file a counter and take instruction.
No. The earlier writ application, this order was challenged.
Yeah, not this order was challenged in the revision.
Yes.
Now the revisional authority's order, would your lordship kindly see?
So they say that they will not interfere.
No, I'm sorry. The revisional authority, we considered that we will pay the entire amount. Having considered over this, that is at least 19 months.
Thereafter, Millard, one minute.
Just Mr. Mahanti, just wait. Overlap is just voice is overlap.
Yes, ma'am. So this was
19.
Millard, there was a notice of termination and demand and the final termination order. Both these notice and termination were challenged in two separate revisions. Page 19, your lordship may see. A common order was passed, para 1, where we ourselves considered that we will pay by 28/2/2022. Kindly see, Millard, page 19.
Yes, page 20 is that giving time till 28/2.
Yes. Millard, this order was challenged in the writ petition. Now,
so when did you pay?
Millard, we have paid at different points of time, my lord. We have paid on 23/8/2020.
So you have challenged the 28/2 order?
Yes, before this honorable court. Page 21, my lords may kindly see. This honorable court permitted me to deposit, Lord, page 26, my lords may kindly see. The order was passed on 11/9/2023.
आपनकर revisional order पे कितने की? 11 दिन 22 हां ठीक है
सर
28 दिन 11 दिन 22
सर तापर 11/9/2023
right no yes we got that
right now I have deposited before the even High Court's honorable court's order.
Yes.
He has deposited. Not.
I mean, Mr. Mahanti, have you challenged this High Court's order before the Supreme Court?
No.
No, Millard. The lordship see thereafter.
Mr. Ratha, which order was challenged in Supreme Court?
We rather, Millard, we should not have challenged. We rather challenged this order before the Supreme Court, and our SLP is dismissed.
Your SLP has been dismissed. Okay.
Yes.
Hard not a senior advocate for the petition.
Millard, 1 minute, Millard. Thereafter,
order ta sunantu. We are running really short of time now.
And again, he has preferred revision. Revision has been returned back. That has not been decided here.
So whatever he has deposited, sir.
Deposited.
We cannot say that because he challenged in SLP, he cannot comply the order. So that
thereafter prefer a revision, Millard.
Correct. But once he deposits means
your lordship see the page 40.
Not only deposited.
We say that he has not challenged. We are not on that. We are not on that point.
Revision has been returned back.
4,58,58
Page 40, your lordship see that.
Yes, it is there. But we are looking at the. We have to look at the order passed by the.
Page 40, you have not seen that page 40, annexure 9.
No, there cannot be any presumption regarding we not looking at the pages. Correct. So.
No, Millard, I am sorry for that.
There cannot be any presumption. We are on a different point, discussing a different point. So I try to concentrate. It's not a so we are on a we wanted to know how the things have progressed till now. Who are challenged and what was the order?
Yes.
Whether we'll look the other way if the subordinate bench order is placed before us, the division bench order where one of my even the brother is also party. Whether I'll look the other way? No, I'll not look at that order. But lawyers have this advantage; they will not look at orders.
I have seen.
Yes. The Lord Senior Counsel referred to the order passed by the coordinate bench, dated 24/3/2026, wherein the petitioner was granted time, wherein the petitioner's prayer to serve copies was allowed,
and copies of IN number 19463 of 2025 and WPC number 14566 of 2025 were directed to be served on the directed to be served on state and the Learned Council appearing for the Union. It is submitted by the Learned AGA that he has not received any copy of the IE. The Learned CGC also submits that he has not received copy of the IAs. The Learned Senior Advocate submits that for the timing, he does not praise the IAs and wants to argue the matter on merits in view of the urgency.
Right.
Stuff. He refers to the demand notice dated 13/12/2027 13/12/2017 issued by the Deputy Director Mines, Joda Circle, demanding rupees 17,66,660 to be paid as quote revised compensation.
Yes.
Into bracket देखिए Annex 1. Thereafter, by judgment dated 2/8/17 ତା ପୂର୍ବରୁ ଲେଖିବାକୁ ପଡୁଥିଲା.
May I just interrupt, Lord? Annex 2, page 15, my Lord. Lordship will find the total demand is 2,72,79.
Thereafter, are directed by the Honorable Supreme Court in judgment dated 2/8/17 in WPC number 114 of 2014.
Correct.
The citation टा अच्छी actually. Would judgment be deliver करछ.
Common
cause है citation. अच्छी है. Batch of cases there with judgment.
2016
बस इतने लिखते हुए directing compensation under section 21(5) of the MMDR Act.
Correct.
To be paid by 31/12/2017. MMDR Act stop. पर comma कर दो. MMDR Act comma. Sentence ठीक है ला पड़ेगा.
Directing compensation under section 21 of the MMDR Act.
To be paid by different lessees. Notice dated 20/9/2018 was issued by the Government of Orissa Steel and Mines Department under the caption subject quote page 15 disposal of notice under Rule 12 into bracket 10 of MC Rules, 2016 issued to the petitioner. By the said notice issued on 20/9/2018, the amount of rupees
2 crore, page 15, third line from the bottom. 2 crore.
2 crore. Page 15 rupees 2,72,79, 111.43
with 14%
into bracket with 14% interest per annum. So the संख्या को अक्षर में लिखते हैं. तापर लिखने ना. कौन सेटा challenge कले?
We challenged it in the revision, Lord. Page 19.
The said notice was challenged in revision. Before the revisional authority, Government of India, in
Yes.
revision application number 22/95/2018/RC-1 and revision application number 22/96/2018/RC-1 by final order number 21/2022 and 22/2022 dated 11/3/22. The revisions were dismissed. However, noting the contention that the petitioner, the revisionist, as present petitioner, shall pay the entire dues as demanded.
Stop. Thereafter, the order passed by the revisional authority was challenged in WPC number. ये जो revisional order लिखी नहीं bracket रे लिखी दियो तो annexer देखा जाओगे?
Sir, that is annexure. Annexure 3. Annexure
3. Annexure 3. Annexure 3. Thereafter, the petitioner challenged the order passed by the revisional authority by filing WPC number
11407 of 22.
11407 of 2022, which was disposed of by a coordinate bench in which one of us into bracket Justice Raman as a member without interfering with the order passed by the revisional authority. Paragraphs 8 and 9 of the said order are reproduced here. That is annexure 4. Page 25 or 26 8 and 9. Thereafter, the order passed by this court. Thereafter, the order of the coordinate bench was challenged by filing SLP.
Yes. SLP number.
SLP ta annexure kete?
Sir, seta mo screen share kar doche order ta.
By SLP ete, SLP dash.
Screen share kar.
SLP dash, which was dismissed by order dated.
Order dated.
Dismissed or withdrawn hai
Withdrawn, dismissed as withdrawn.
3-5. So dismissed as withdrawn by order dated
3-5-2024.
3-5-2024.
SLP civil diary number 14009 of 24.
SLP civil diary number
14009 of 2024.
14009 of 2024.
If the order counsel for the petitioner states that he will wish to withdrawal of the SLP in order to move the High Court. In terms of the request, the special petitioner is dismissed as withdrawn without this court expressing an opinion on the remedy which the petitioner intends to follow. Then the petitioner approached this honorable court again.
Oh, should I edit application?
No, I would set up page annexure 8, page 35. Either liberty appropriate authority ka approach karo.
35 re.
Page 38.
Pursuant to the liberty 38.
Right.
8 the order.
Pursuant to the liberty granted by the Honorable Apex Court, as sought for by the petitioner, he approached High Court again in WPC number 19332 of 2024, which was disposed of by another coordinate bench. With the following observation, 3-4-5, page 39.
Exactly.
Thereafter, the petitioner has approached the authority.
In fact, the authority
has observed again.
Themselves have written by 2024.
Sorry?
Annexure 7, page 31. The authorities themselves have written to the government to restore kindly Simon. Page 31, 22-3-24.
High Court order ta hoche 5-10.
Sir,
annexure 9. Annexure 9 tak.
Revision file.
The petitioner has thereafter approached the revisional authority again.
Right.
By revision application dated 17/12/2024.
Okay.
Which was returned by the revisional authority, Government of India, Ministry of Mines, by letter dated 27, by office letter dated 27/2025. Stop. In the meanwhile, ଆପଣ ତାପରେ ଚ୍ୟାଲେଞ୍ଜ କଲେ ଏଇ ଅର୍ଡରଟା କୁ ଏରିଟ୍ରେ
ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି, ଫର୍ମାଲି ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି।
The order dated, the letter dated 27/2025 has been challenged in the present writ application, which is pending adjudication. Okay. The learned senior counsel refers to the letter dated 22/3/2024 issued by the
Director of Mines and Geology to the Additional Chief Secretary to Government, Department of Steel and Mines for the government, for the Government of Odisha, which indicates thus. Now the lessees, due to non-payment of such compensation, page 32 ରେ ଅଛି ଦେଖିବେ, which indicates thus କରିକି 32 page ରେ ଅଛି ଗୋଟେ ଲେଖିବେ first of all, due to non-payment of such compensation up to, this is for your kind information and necessary action. Yes, sir. The Lord Senior Counsel, relying on the said intimation, submits that apart from non-payment of the amount demanded under Section 21(5) of the MMDR Act, there was no other default on part of the petitioner that would result in lapsing of the proceeding, lapsing of the lease, not proceeding, lapsing of the lease or any other proceeding against the petitioner for determination of the lease. Stop. It is submitted that having the petitioner having complied in full the demand along with the interest as directed, and the matter having been litigated till date, though at the instance of the petitioner, still the petitioner is entitled for continuance of the lease. Stop. That was granted in his favor. Stop. You should notice along with this order, the learned AG upon advance copy sought appears and waives notice. He shall obtain instruction and file counter. Mr. Mahanti?
Second week of July, my lord.
Second week. Shall obtain and file counter by 10th July 2026 upon serving copy thereof for the learned counsel for the learned instructing counsel for the petitioner. The petitioner shall have liberty to file rejoinder within a period of 2 weeks, Mr. Ratha. Period of 2 weeks, the matter shall be listed for orders in the week commencing 27/7/2026 before the assigned bench. Stop.
Millard, may I submit one thing, Millard?
Yes, please.
Millard's lapsing is not for the payment of amount. Lapsing is non-operation of mining. That is there. Two things is distinct, Millard.
ठीक अछि आपण सेटा दियंतु
आगे
सुनतो आपण जदी डिसाइड करिबा
continuous नकला lapsing अब
we have at least I am sure that I have not passed any judgment or order.
Millard,
I am confident. I have recorded the submissions. I am confident that I have not passed any order, or my brother has suggested also any order to be passed.
It's the language of status for period.
Whatever, sir, you file.
Yes.
I still continue to be a student of law, no difficulty there. I have also learned that without being instructed, I will not, appraised by the Law Council, I will not observe anything.
Okay.
And also, we have to be diligent in reproducing the submission. At least factually, we have to follow the what went on. Maybe lengthy orders, but at least we are satisfied that we have reproduced the facts.
Everything is reproduced.
Yes. And there is with my experience, I do not purposefully record the submissions of the opposite party because that creates problem for the opposite party.
Without instruction,
because you never know what sort of counter they will file.
Right.
When the authority will come, what instruction they will get, in fact.
You never know. And today morning only, when it was argued that on the date of sale, the tax was imposed.
Yes.
Almost half an hour was spent in finding out the date of sale.
Right. Correct.
So, it has to be in the context of the adjudication. I could have file
IA number 10127 of 26.
IA 10127 of 2026. The hard learned senior advocate for the petitioner, he reiterates his submissions as noted above. The Lord AGA submits opposes the prayer for any interim order to be passed at this stage, or having had the learned counsel for the parties, learned senior counsel for the petitioner and the learned AGA. In the interim, it is directed that status quo as on date regarding the lease. So that lease description ta koti mili?
Lease deed they nothing.
Lease deed tam they lease deed was valid up to 2020.
He has rightly filed amendment along with the lease deed. From the court.
But lease is up to 2048.
It's a containing 97 pages.
Amendment in section 8A, it is valid till 2048.
Lease description ta koti mili kali?
Only a lordship say that let's start.
अच्छा हाँ अच्छी मिलिबो 1912 रे देखंतु 1912 रे पाइबे respect to status quo as on date regarding the mining lease for iron ore village Deochar comma Champua subdivision of Keonjhar मु जल्दी देख दोछ फिर अपन देखि लिखिबे Keonjhar district over an area of 11.533 hectares
7 hectares
next 12 9 open
एटा तो अच्छी इतरे
एटा से बोधे amendment रे थिबो बोधे सेटा इससे
अच्छा हाँ annex 10 annex 12 तो चाहिए रे
amendment रे अछि
आपण पेपरलेस यूज करनांती अच्छा एटा शेयर करी हो
पेपरलेस नाही हमरो ये रे
नहीं सॉरी आपण कोर्ट रे रहले सेडा होतला सेडा हे परिबो
नहीं वो वेरीफाई करते
I understand your difficulty Mr. Man.
From Annex 2, this is Deoghar iron ore mines 11.537 hectares in the district of Keonjhar. Page 15.
ठीक अछि 2 ରୁ लेखिबो नले को 2 रे को जारे पढुछोनी
Sir, I am reading second paragraph, fourth line.
ठीक अछि से अरे से आपण 12 ରୁ लेखि थालु 537 खाली कर दे बट मते लागो जेटा 533 हेतिबो 37 is a mistake typographical error anyway
कहि दोछि एग्जैक्ट टेक्निक थे 28.50 acres 11.533 hectares
हेक्टर्स ठीक अछि मु हेक्टर्स ही डाकि छी
28.50 acres
जहां मिस्टर महांती कहबे मु राजी अछि
नहीं सेटा मु इंस्ट्रक्शन न कहू नॉट दैट आउट ऑफ
से नहीं सेटा को से हेक्टर
टा लिखो आगे हेक्टर टा लिखो कंफ्यूजन रेफर इन एवरीवेयर
your authority has said hectares, let us confirm to
it से हेक्टर्स अठाउ तो ना 533 है मोस्ट लाइक anyway ठीक है स्टार्ट 537 सेटा लिखि देबे shall be maintained till the next date of hearing
right great
object certified copy as per rules we should as per rules अपन लिखिबे the parties shall have the liberty to act upon the copy of this order obtained from the official website of this court yes
अपन जोटा लिखिबे ना कमन का जजमेंट जोटा
अच्छी
हां कमन का जजमेंट सेटा WPC 114 रो जोटा लिखा
साइटेशन ता अच्छी
साइटेशन हम 2017
the maintain law against willers
1313
and every mining foot on
bracket रा होची 2017 bracket close 13 SCR
नहीं
361 मैं SC कंफर्म 361
नहीं ACC दियो SCC ता अच्छी देखिए एयरपोर्ट अच्छी
कारण तो 16 रे गोटे बार 17 रे भी दिटा
सेटा चेक करा है मु सेट पाई कहले सेटा देखि
माने एटा होची जजमेंट डेटेड
2017 एससी रा 22/5 रे जज इची जजमेंट और हां गवर्नमेंट बाबू को नहीं
ग्रेट
यस कॉमन कॉज बहुत उड़े बहुत उड़े
नहीं तार भी सेही थरे बहुत उड़े ऑर्डर उड़े अछि एटा होची 28/2017 सेटा मु बार करथि सेटा 2017 13 एससी 260
माइंस ऑक्शन को जाउ सब माइंस ऑक्शन को जाउ छै लॉ चेंज
एससीटा संगे संगे मिलुछ तो सत्य हम एससीटा करू
आगे
ये विथ द अथॉरिटी ऑफ सुप्रीम ऑनरेबल सुप्रीम कोर्ट
यस एक कितना बैच
पंचोटा
सारी दबा विल कंटिन्यू
यस एटा सर्जी होदे कम
subject to
next call
proposal by the bar
एटा कंटिन्यू कर बोल
बेटा सिंगल बेंच पे आपण
आगे
It is manner this is amendment in persons to direction of the Honorable Apex Court. that income tax
Yes.
filing in 148.
Sir,
Already my lord has passed the
say order today ହେଇଛି ଆଗରୁ
29 ରେ order ଦେଇଛି ମୁଁ ଦେଇଛି ସେଟା
ହଁ ସେଟା ଦେଇଛି
29
ଦେଇନାହାନ୍ତି ସେ କୋର୍ଟ ମାଷ୍ଟର ପାଖରେ ନାହିଁ
ନା ମୁଁ ଡାକିଦେବି ସେଟା କର
WPC number 23691 of 2025 23691
of
2025
23691 of 2025 order dated
29/5/26 এই ভ্যাকেশন মোটরে আপন গল
26 Justice KR Mahapatra हाँ ସେଇଥିରେ ସେଇଟା ଫଲୋ ହେଇଛି ଜଷ୍ଟିସ ଚିଫ ଜଷ୍ଟିସ ଦ୍ୱାରା ଜଷ୍ଟିସ ଅମର ଦେନ୍ କୋଡ଼ିଏ
ସେ ଆରଟା ବି ସେମ୍
ରିମେନିଂ ନୋଟାରୀ ଫିଟା ଦେଇନାହାନ୍ତି 29 rupees ନୋଟାରୀ ଫି ଦେଇଦେବେ defective
ଦେଇଦେବି ସାର୍
the learned counsel for the petitioner submits that due to inadvertence the amount of notarial fee could not be paid which shall be paid within
Monday ଦେଇଦେବି
which shall be paid within 3 working days the IA रे order କରୁଛନ୍ତି IA 1036 of 2026 तापर से ऑर्डर करतो पे जोटा से जोटा सिमिलर ऑर्डर yes next
time same
item 20 IA 10415 of 2026 amendment तर appearance से लिखियो पड़ियो नै कि सबुतरे 19 से लिखंतु so प्रणय किशोर हरिचंदन 19 for the petitioner Mr. Subhash Chandra Mahanti, SC Mahanti for the opposite parties 1 to 4 goods and services रे की अछंती
एटा इनकम टैक्स रे ओनली स्टैंडिंग खाली इनकम टैक्स
आपण किंतु 5 कर देले डायरेक्टर जनरल ऑफ गुड्स एंड सर्विस टैक्स
कॉपी पेस्ट
भूल कोन कर दिथु
आपनकर डायरेक्टर जनरल ऑफ डायरेक्टर इन्वेस्टिगेशन आगे
हां डीजी ना डीजी अथने गोपाल डीजी दैट इज द केडीआर मे बी फॉर दैट गोपाल सेकंड केस रे डायरेक्टर जनरल अछि
महापात्र यू आर appearing
my lords I have an item 20 my lords for me I'll inform the department my lords item
DGGI
I can appear for DGGI my lords
okay Mr. Prasajit Mahapatra
sir copy on Mr. Prasajit Mahapatra
copy of the writ petition as well as the IE along with all annexes shall be served on Mr. Prasajit Mahapatra learned senior standing counsel CGST
well amendment petition may be served
आपण भी पाइना थी
नहीं amendment
अच्छा ठीक है Mr. Mahanti Mr. SC Mahanti for senior standing counsel for income tax and Mr. Sili copy जो सर्व करिवे नी सब अथर कर दियो Mr. Harchandan kindly instruct your associate to serve copy Mr. Mahanti said he has not received we did not ask him but he says that he has not received
consolidated
the challenge जो देश में
consolidated file
party का union of India party है what distinct brother Raman is saying that maybe you have to make union also a party if virus is challenged
well that I have to incorporate in the
हाँ आपनकर 20 रे अछंती 19 रे नथिले कि I think 19 रे के ना
हाय ठीक है छोड़
ना union ना I had checked that so that 20 लिखंतु सेम ऑर्डर हो आइए रे अमेंडमेंट अलाउड जोटा से जो कवर्ड ऑर्डर जोटा ऑर्डर रेफर कले हरिचंदन सर सो ऑर्डर टा जोटा कवर्ड जो से 2369 आगो कहि देला परे कोन प्रॉब्लम होला सेटा अपेरेशन बैक ए ऑर्डर ता कि साथ दी
प्रिंट करें धरे आपण नोट कर एटीन आपनकर अमेंडमेंट 19 में अमेंडमेंट मिस्टर हरिचंदन कारण अदर सेट नंबर कॉपी नाही से डिफिकल्ट है 18 भी कॉपी नाही कहउछंती
मिस्टर महादेव कॉपीटा पठेइथिली
मिस्टर महांती 18 भी कॉपी नाही
No, I have not received my lord the amendment petition.
ठीक अछि आप देबे सबुतरे 18 भी कॉपी
outside the state, so I have provided it through WhatsApp.
Mr. Harichandran, when you are challenging virus pursuant to direction of Honorable Supreme Court,
My lord.
then you make parties also, correct?
My lord, because I was out of station, officer.
Because Honorable Supreme Court has said that only virus has to be challenged appropriately, amendment has to be made. Right. So you have to make them party also, appropriate parties, unless you make.
You make it up. You have to take steps.
In consolidated कर देबे सेटा.
हाँ, अपन you have to file that application actually. Then 2020, what is the again amendment?
No, 20 is not mine.
Okay. Yes, 20.
Item 20, I am appearing, my lords. Will please your lordships. Lords, this matter, the Petroleum and Natural Gas Regulatory Board issued an order on me, Gas Authority of India Limited, for laying, building, operating and expanding natural gas pipelines for Mumbai, Nagpur and Jharsuguda natural gas pipeline sector. Accordingly, I lay down pipeline for these projects, and on this pipeline, I transfer natural gas to households. I do not have any factory or any business premises, anything inside Odisha, only laying of pipes. Now, whether the question before a lordship says, whether cross-country pipeline for transmission of natural gas is an immovable property, and secondly is whether cross-country pipeline is plant and machinery. Lords, I was not getting the benefit of availing ITC, so I approached the authority for advance ruling. The authority decided the matter. Against that, I approached the appellate authority for advance ruling. And against the order of the appellate authority for advance ruling, I am before your lordships. Now the issue before here is that I lay down pipes, which is basically a immovable property, but these pipelines can be shifted from one place to another. The immovable component is that these pipelines use gas, which is being transported at very high pressure points. Although these are embedded into the earth, this may not require any concreting or anything, but concreting is used for safety purposes, that tomorrow, suppose the gas pipeline comes out of the earth and hits someone, then the person gets injured or anyone public gets injured. So these are the ways how I operate. Even tomorrow, the government may ask me to remove the pipeline and put it up in a separate place. So I have to remove that pipeline, that same pipeline, and put it in a separate place.
This is against appellate authority.
Against the appellate authority's order, I have come.
Sure.
Before the first appellate authority as well as before the authority for advance ruling, I had filed a judgment of the Delhi High Court in my own case, which decided that plant and machinery, these pipelines should be plant and machinery. Both the authorities did not go into the judgment at all and decided the matter against me.
You have to take notice and they have to respond.
My lords, I am screenshot the judgment now. The lordships can also go through that.
The citation is first page. Citation is
online. My lords, I'll take your lordships to page 109.
Mr. Mahathi.
See, online, just a second. Just one second.
My lords.
We are noting down the citation.
My lords.
Kindly show the page of citation page.
My lords. Lords, the citation is at page
The ARH.
93, my lords.
But the print is SEC print.
My lords.
My lords, I'll share, my lords, that he is relying on. That is earlier under the earlier regime, not under the GST. I'm sharing the citation. That is AIR 1999, Delhi 210, my lords.
210, yes, we have marked that. We have marked that, but ILR.
ILR is 1999, 1 Delhi 93, volume 1.
ILR 199. Yes.
1999, year 99, volume 1, Delhi 93, my lords.
My lords, at page
ILR 99 is volume 2. ILR 99, 2 Delhi. Okay, AIR is there, yes.
My lord, the relevant para is at page para 46 at page 111.
These pipelines are in furtherance of business.
My lord. My lord, page 111.
In furtherance of supply of goods.
My lord.
Scroll down. 46 is a little below, so just scroll down a little. Scroll up, scroll down a bit. In view of the above, yes. Stop there.
In view of the above, we are of the view that the pipeline being a plant, the petitioner would not be liable for tax merely on the ground that the same has been laid within the municipal limits of Delhi by virtue of arrangement with the private owners, railway and government, all those things. So, my lord, Delhi High Court has held that pipelines are basically plant and machinery. So, I'll get the benefit, my lords. And secondly, my lords, here the appellate authority has gone into my website and taken out certain facts, certain information from the website and used it against me. But the said appellate authority has not confronted those materials to me, my lords. And here the appellate authorities have taken into account that these website details belongs to a manufacturing company. If I take your lordships
So they have on the basis of that extract from the website, they have treated it to be a manufactured good.
My lords, they are treating it to be, my things are being treated as a factory.
Okay.
This they have never confronted to me, my lords. My lords, I'll take your lordships into that page. Page 41, my lords. Page 41 of the
Mr. Mahanti, is it your basic case is that what we understood is GAIL is supplier of this pipe?
No, my lord. My lord, GAIL's purpose is supplying of gas.
While supplying gas, you use this pipeline. So you are basically this supply of goods, you are not manufacturing these goods.
No, my lord.
That
who all are appearing here?
Lords, I'm appearing for the authority for the respondent number 3 and 4.
Yes.
Well, this
Mr. Prasanjit,
yes,
Mr. Prasanjit, these goods cannot be supplied, like certain goods which cannot be supplied without the container.
My lords, I'll explain, my lords. My learned senior has not yet come to his claim, my lords, his claim.
Respond, I mean, it's a good point to be.
Yes, my lords, what has happened is here, he is claiming ITC towards laying of the cross-country pipelines. Now, this has been particularly prohibited under Section 17(5), and he is saying that 17(5) is governed under Section 16, whereas 17(5) is a non-obstante clause. And laying of pipelines outside the factory, my lords, is clearly prohibited.
So these are not the manufacturers.
17(5) of the CGST Act.
CGST Act, my lords. CGST Act. My lords, may I have 17(5) for a moment?
Yes.
Well, his contention, I'll say how it is falling outside the purview. That is why the authority of advanced rulings and the appellate authority have concurrently held
So,
And here it is on his
Mahapatra, Delhi High Court has considered 17.5.
my lord, Delhi High Court has been 99 judgment prior to GST regime. 2007. Yes,
So
99 judgment on.
So perimeter provision was not there.
No, my lords, no perimeter, nothing.
Property tax, my lords.
Property tax, my lords. That was property tax express provision under 17.5. 17.5D, my lords may see, and 17.6 expressly, my lords may see this particular provision.
So, Mr. Mahapatra, accepting your contention,
yes, my lords.
If laying a pipeline outside the factory premises is prohibited.
No, my lords. They will have to prohibited from claiming ITC, my lords. In that case.
Correct.
Yes,
prohibited not as a ex face factually.
Yes, my lords.
That's not the point. Is prohibited as far as you are saying that since it is 17.5 bars such a contention. Or can you take us through 17.5?
Yes, my lords. For a moment. My lords, 17.5 lords.
Tax credits shall not be available in respect of following, namely.
My lords, 17.5D, my lords may have D.
D
is goods or services both received by a taxable for construction of a immovable property other than plant or machinery on his own account, including when such goods or services or both are used in the course of furtherance of business. My lord, he is saying this is a plant. This is a plant, and it is not, even if it is attached to the ground.
Yeah.
So it's a plant or machinery. It is not a machinery. It is a plant. In the meanwhile, my lord, Safari Retreat judgment
so D is the exception, and plant and machinery is exception further to D.
Yes, my lords. And my lords, my lords may have 17.6 for a moment. 17.6 thereafter. Explanation. My lords may have the explanation.
The government may prescribe the manner in which the credit referred to in subsection 1 and 2 may be attributed.
Explanation, my lords. Purpose of chapter 6, the expression plant and machinery means apparatus, equipment, machinery fixed to earth by foundation or structural support that are used for making outward supply of goods or services of both and includes as foundation and structural supports, but excludes land, building, or any other civil structures, telecommunication towers, and pipelines laid outside the factory premises. What they do is they transmit gas from gas factory. They have this regasification. They send it to the customer and send it back. There is a regasification. There is a definition of factory.
But Mr. Mahapatra, if you say that, then how the gas will be transmitted?
Well, it will be. Well, there is a regasification that happens in the factory.
Because perhaps if you make it so specific, any pipeline, I mean so generic rather, not specific, so generic. Any pipeline laid outside the factory premises is to be excluded. Then in case of a gas or a liquid which requires transmission, then how do
they will transmit, but benefit of ITC they will not get.
Mr. Mahapatra,
yes, an point.
Yeah, if it is
and the other aspect is that para 45 of Delhi High Court.
My lord, the question is,
if you look at,
sir, if it is LPG cylinder,
yes.
So can you segregate? Without cylinder, without container, the gas cannot be supplied.
Yes, my lord, the question is,
that is as simple as that. See, Mr. Mahapatra, he is not a manufacturer. He has to supply the goods.
Yes,
without the container, this supply of goods cannot be completed. He cannot. He is not transferring the property.
Yes, my lord, that's right.
Transferring the property and goods. That is the fundamental thing.
My lord, here the question, my lord,
not transferring the pipe.
My lord, here the question is whether the pipe constitutes.
Your point is well made, Mr. Mahapatra. I mean,
the pipe is a plant or machinery.
17.6 explanation and 17.5D is well taken, but that would be, too generalized a statement. That any pipeline, irrespective of this context, because then gas. How do you contemplate transmission of gas? Because perhaps that is what persuaded the Delhi High Court.
What has happened is in Delhi High Court, they were laying down the pipeline and they were saying that they are liable to pay property tax on the places.
No. I mean, para 45 doesn't refer to property tax. Para 45
is probably under the municipal MCD tax.
Correct. I mean, you are saying the levy. Whether levy can be made as a property tax, it is a property or not, that's a different thing.
Here the question is,
the finding is, pipeline is used for the purpose of transportation of gas from the bowls to the earth, ultimately to Haryana and UP.
Yes,
unlike the functional test applied for the aforementioned cases. At the most, the pipelines which have been laid beneath the land will have to be treated as a plant.
Yes, my lords. Here the question, my lords, here plant and machinery have been specifically excluded under the ambit of section 17.5 and 17.6. Therefore, he is not eligible for ITC. Well, ITC, my lords, knows TVS and AD automotive is not a matter of right.
You have to respond to that. We are not deciding.
My lords, issue notice, I'll respond. I'll file my counter. This is a point I have decided. But no interim relief, my lords, he is claiming that he may be permitted to take ITC. In the teeth of the provision of 17.5, 17.6, my lords, he cannot take ITC as of now. It will be tantamount to deciding the writ petition at this initial stage.
So you are saying that no, maybe yes, you may be correct that claiming ITC as of now, maybe. But that
once will if she will collect it and deposit, then it will be in process sometime.
So, my lords, here, my lords, if he is not, if ITC is collected.
Mr.
If I'm not claiming the ITC now, if I'm not claiming the ITC now, and it is, I treat it as a capital goods, and if I claim the depreciation, I can never claim the ITC at all. So if Mr. Mahapatra can say that even after the writ petition is finally decided in my favor at a later point of time, I can still claim the ITC, I don't have any objection.
Well, this is an allotment of the year 2021. We are in 2026. My lords, he on his own asking, he has gone to the authority for advance ruling. Let
that statement be recorded that I can claim the ITC at a later point of time.
No, my lords, on my statement, my lords, I cannot make a statement against the law, my lords. Whether he can make a claim, my lords, at this stage, when after, my lords, on his own asking, he has approached the authority for advance rulings.
If I claim it today, you always have the option of revoking it.
Maybe both.
No, asking for cannot be. I mean, asking for advance ruling cannot be taken exception to by the taxing authority if goes in favor of the taxation and against the assessee.
Well, on his own asking, this is not an assessment.
There is no adjudication as of now. There is no adjudication as of now.
He wanted clarity, so he approached my lord. So now he can't say, I will permit to take ITC.
In both the tiers,
no, he may not be taking ITC as on date, but the point is that whether you will allow him to take ITC, if at all it is favor. Suppose now the advance ruling authority would have decided in his favor and you would have come up in challenge, in writ petition, then what would be your prayer?
Well, in that case, my lords, he can anyway claim debt because it's a capital. He's capitalizing the tax.
You have to place your logic in the mirror. Yes, suppose the advance ruling would have, decided in his favor, or in every advance ruling, you would expect that it will go in favor of the, revenue.
No, my lords, that's
so please answer that.
My lords, there is a specific. My lords, in that case,
there has to be equitable consideration.
My lords, in that case, my lords.
And gas authority will not run away with all these pipes and gases.
No, my lords, the difficulty will be, my lords, once he takes ITC today, tomorrow it will be difficult to reverse it. As of
No. Mr. Mahanti's submission is that he is not taking it. He is not taking it. But what would happen if he is not giving ITC?
My lords may see his IA for a moment. My lords may see, I'll explain, my lords, what I'm trying to say. He's asking relief.
That order.
Yes,
we are not. We are with you. We are not passing that order. But you have to make a submission to that extent that if he is not taking ITC or not granted ITC today, whether consequences can be reversed. That's the point he's raising.
My lords, he has not been taking so far, my lords. Suddenly, during the vacation, my lords, it suddenly arises that he will be required to ITC. When he has,
of course, vacation, ITC is well within our roster. For that,
I'm not saying that it is not within. No, I'm not.
The advance ruling every time decides in your favor. The High Court is making a roster including everything.
Well, I'm not a man. 15/1/2026 order, my lords. He is saying
that. Mr. Mahapatra.
Yes, my lords.
Who is the authority? Who is it the authority?
Authority for advance rulings, my lords.
Is it a taxable person other than the government?
The statutory, my lords, the statutory authority, my lords, it is clothed with the statutory power, my lords. My lords knows.
Is it?
My lords knows more than.
This gas authority.
ITC is not a matter of right, my lords. That is the.
So if the advance ruling authority decides in against you, then what would be the interim prayer for you?
My lords, kindly see for a moment the IA.
So you have to balance the equities. So there should not be a situation where the revenue cannot recover it.
This is a preemptive application. My lords, unfortunately, this is a preemptive application. He is praying that the proper officer may not act on the basis of the advance ruling authority. Because he is precluding, my lords. That is the problem.
We are not allowing that sort of a prayer, but we are asking you something else.
Yes,
suppose now you are not. Suppose now if he is ultimately granted the benefit of ICT by result of the writ petition, then what would happen? Can he be, I mean,
My
granted
lords can
that?
always grant status quo ante relief, my lord. That can always be allowed, my lord.
So status quo ante, as far as deposit is concerned, how?
Well, if he's entitled to something,
as
he's
far
right.
as taxation, taxes already recovered, ICT not granted. How to do that?
Well, my lords, it will be adjusted. My lord, if it is a right under law, my lords, that his property is right under right to property. My lords, when finally decides a writ petition, that can always revert back to him.
One thing. So, Mr. Mahanti, if you are not granted ICT now,
my lords,
then what would be the liability?
My lords, I will not be able to take it. Even if your lordships at a later point of time decide the matter, I will not be able to take it because the law will be against me.
So
Mr. Mahapatra cannot give an undertaking to that effect also today.
Return period would be over.
My lords, Mr. Mahapatra will not be able to give an undertaking to that effect today.
No, I cannot give
an undertaking.
I mean, obviously, he will not. He will not.
The law permits or not, I'll take it.
My lords may see the IA for a moment. An application praying for stay that no action will be initiated by the proper officer under CGST Act. He's precluding an assessment, basically that assessing officer will not proceed against him on the basis of an interim order passed by this Honorable Court, which is in the teeth, my lords, which I humbly submit, which will be in the teeth of section 17.576.
Lords, I'm making a prayer in IA number 1041.
You have said that 5 times and I have answered you 5 times, but you are stopping it thereafter. After I tell you that what would be your interim prayer, then you are stopping there.
No, I have
no. Because then very fairly says that you have to give that order to think that yes, you will allow that ICT after.
My lords, I can always say that all.
Because you see, you can't put the adjudication or the determination in the limbo that way.
My lords, if the writ is allowed, my lords, you will be entitled to all consequential relief. My lords may record that to that extent. Generic statement, I can always make that statement, my lords. I cannot make a specific statement that in this particular case you'll be entitled to ITC. I can always say
specific. We can't be generic.
My lords, if the writ petition is allowed,
like pipelines. Like pipelines, and wherever it is laid, so it is so that kind of.
It has wide implications.
Then our order should make sense and it should be fair to both the sides. Yes, suppose if you are saying that you will be facing difficulty in collecting the tax, then we have to ask him. But that you are not saying.
What I'm saying is that, kindly consider Maharashtra, Chhattisgarh, there are multiple authority for advanced rulings with respect to cost country pipelines. They've all held that they're not eligible for ITC. And in case, my lord, this is a case where he's saying that subsequently he will succeed the writ petition. My lord, he'll be entitled to all consequential reliefs that is otherwise entitled to him.
Consequences, Mr. Mahapatra.
But
that will be adjusted against his tax.
Mr. Mahapatra.
Yes, my lord.
After return period is over, he will not be allowed to claim that ITC in the returns after some time when suppose High Court or Honorable Supreme Court grants him the relief. Then how will he claim that? Will you?
He need not file that, my lord. That will be subject.
Will you allow him?
Pursuant to the lordship's direction, that will be.
Suppose he loses, he can pay you the money.
My lords may consider the implication. My lords,
every time interested for the tax.
My lords may consider what to buy.
But implication you should have it ready with the answer. Actually, you have not been briefed regarding that. This is the problem. You are only reiterating that prayer is not tenable. But if we cannot grant ICT, if we cannot grant ICT, you are not sure. Then how we will protect him?
My lords, may kindly consider every time
can this High Court? So this is for the last time we are asking Mr. Mahapatra. Yes, we will direct grant of ICT.
ITC.
ITC. It's not ICT. Anyway, input tax credit. Let us use the full form. This court will be able to grant ITC or maybe at the latter stage after he wins or at the stage of.
Manoj, that is exactly what has happened in the Safari Retreat judgment is relying on. Their matter went to Supreme Court. Supreme Court has sent it back to the High Court to decide whether they falls within the functional test led on the Supreme Court. If a consequential relief is available to him, obviously,
Mr. Mahapatra, your argument cuts both the ways.
I'm saying,
because if we can't direct
I'm clarifying.
No, Mr. Mahapatra, it is like this. So just can you listen, then you answer.
Yes, Malad.
If we can direct ITC to be given at the future whenever the final judgment is passed, fine. But there you are not answering that. You are saying that consequential relief. But our observation, as you have heard, my esteemed brother, that statute does not permit so. Your argument is that statute does not permit for ITC.
Well, date of filing of return has nothing to do with that ITC amount which will be available to him under assessment. If tomorrow he is assessed to
Mr.
tax,
Mahapatra,
he has not
perhaps
been
you have not, perhaps you have not seen the rigors of non-claim in the returns.
well, if you will claim, my lord, assessing officer may proceed according to law.
Mr. Mahapatra,
Today he is trying to hold the hands of
you
the
have not
assessing officer.
studied that part. You have
16.4,
not
my lord, is
studied
referring to
that part
16.
of returns.
Referring to
If
16.4.
it is not claimed in return, subsequently it cannot be.
16.4 and my lords talking about returns under 39 and 40, my lords. I'm aware, my lords, that I'm conscious. But my only problem, my lords, is that if tomorrow, my lords, this is a case of AAR, my lords. This is not a case of assessment. That is the difference. Today, my lords, before even the assessment has started, he is saying that he wants to claim ITC, then that he should be protected under the law.
You advocate.
So can he? So we can ensure that we can direct that he, in case of he does not succeed, he will pay the entire ITC benefit claim. But he was stopping short of answering that. For the last about half an hour, you are stopping for answering that. If we can ensure his payment, what would happen to you? The revenue? Can he claim the ITC? You are saying that because there is a bar in the statute, he cannot claim. Once he misses for all the time.
My lords, if I cannot give a concession against statute, that's my limit.
That is the problem. That is the problem. We cannot pass a statute order against the statute.
Yes,
we can direct definitely that the petitioner undertakes that he will satisfy the demand of tax if ultimately the claim of ITC is rejected. That we can direct. But what about you? If you do not direct, can he claim? That's not saying that no, the court has to observe that all consequential benefits. No, it's not a question of consequence. It's a question of statute where ITC benefit is to be claimed, and if it is ultimately granted, then what would be the consequence? That can be a consequential order that can be granted.
He is seeking relief in the interim relief, which is more than even this final relief is concerned, my lords. That is the difficulty, my lords. His interim relief goes much beyond the final relief.
Whether it is
that was the ground when this advanced ruling authority considered this.
Just pure question of law now.
There has to be question. If we decide that a pipeline he cannot get ITC because of 17.6 proviso, enough
explanation.
17.6 17.6
5 and 6, my lords. There is also a 55 amendment which replaces that Safari judgment and goes back to the substitution amendment has come in 17.5.
No, because Mr. Mahapatra, all your efforts not to answer that whether you will be able to claim a benefit is not impressing us. Because if you are not saying that he can,
I'll have to specifically regarding. I'll have to take instructions regarding that.
We cannot act as if we are not looking at the future. Whatever may be the consequence, we will not
allow me to take instructions regarding that particular thing, whether that ITC can be reversed subsequent.
No. Today it should have been there. Because you are raising that issue, that he is claiming more than the main prayer. If he's granted ITC, we can say that if he is ultimately he fails, he has to pay the entire tax claim towards ITC. That much we can definitely will bind him by that.
I am agreeable to that point.
Hard senior Mr. Vivekananda Mahanti, senior advocate, along with Mr. Ashish Kumar Samal for the petitioner.
Ashish nahi. Syed Kumar.
Yes. SS Ali. SS Ali for the petitioner. Mr. DSGI, Mr. PK Padi DSGI, along with Mr.
Satyanarayan Patnaik.
Suryanarayan Patnaik CGC. Satyanarayan Patnaik CGC. For OP1, Mr. Sachidananda Nayak, Additional Standing Counsel for OP2. Mr. Prasenjit Mahapatra, Senior Standing Counsel, CGST, for OP3 and 4. Hard learned Senior Advocate for the petitioner. The petitioner is a Government of India undertaking. It's a statutory corporation or Government of India undertaking? A Government of India enterprise.
Government of India undertaking.
M.S. Gale India Limited, represented by its Chief General Manager,
and authorized officer has approached this court challenging the order dated 15/1/2026 passed by the appellate authority for advance ruling Odisha in order number so and so. The number so and so. Affirming the order number so and so dated 23/7/2025. Constitutional validity of the order passed by the advance ruling authority, that is Odisha State Appellate Authority, is also under challenge in the present writ application. So, is submitted by the learned counsel for the learned senior counsel, referring to the facts of the case that the petitioner transmits natural gas through pipeline. The work being Bombay, Nagpur, Jharsuguda gas pipeline. The advance ruling authority was approached regarding whether the petitioner company would get input tax credit into bracket ITC hereinafter for short bracket closed on the by application of section 17 into bracket 5 into bracket small d of the CGST Act, 2017. The AAR full form
The Authority for Advance Ruling.
The Authority for Advance Ruling gave a ruling. The page page 30, para 1.4. Video order number 06 up to CGST Act 2017. 1.4, page 30, order number 06 to jeti 4-5 lines लिखते हो. Thereafter, the petitioner approached the State Appellate Authority for Advance Ruling. Stop. Before the Appellate Authority, you had cited this Delhi judgment before the.
Yes, my lord. Yes, my lord.
The petitioner has relied on decision of the Delhi High Court in AIR 99 Delhi 210. Colon ILR 1999, volume Roman 2 Delhi, para 45, which is reproduced herein. It is submitted that in view of the categorical finding of the Delhi High Court that the pipelines laid by the Gas Authority of India Limited is a plant and machinery. It would come in the category of plant and machinery. Into bracket लिखिए para 46 of SCC print. The petitioner should get input tax credit as claimed. We find in our considered view, the petitioner has argued case for issuance of notice. Accordingly, notice be issued along with this order. In view of appearance of the learned counsel for the opposite parties, upon advance copy served
no further notice be issued. Adequate number of extra copies shall be served, forwarded to the learned counsel for the opposite parties. The counter affidavit on behalf of the opposite parties shall be filed within by how much time, Mr. Mahapatra?
That's 3 weeks.
Will be filed by 30/6/2026 upon serving copy thereof on the learned instructing counsel for the petitioner. The petitioner shall have liberty to file rejoinder in response thereto within 2 weeks thereafter. The matter shall be listed for admission in the week commencing. Shall be in the week commencing 27 तारीख अधिक टाइम दे दियो काउंटर बाय दियंतु 6/7 rejoinder by 20/7 shall be listed in the week commencing 27/7. आइए 3867 Mr. Mahanti. Who I had a place coach?
10415.
6221, my lords.
6221 of 2026. The application has been filed seeking interim direction. Regarding the eligibility and availment of input tax credit in respect of GST paid on goods and services used in the laying of cross-country natural gas pipeline starting from Maharashtra up to Jharsuguda in Orissa. Starting from Hon'Ble in Maharashtra up to Jharsuguda in Orissa. It is submitted that the ITC involved in the present case is approximately 290 crores, including approximately 74 crores in the state of Odisha for the financial year 2022-23 up to December 2025. The said ITC is reflected in the capital works in progress in the book of account of the petitioner. It is submitted that the availment of ITC is a one-time event as per the prescribed rules under the CGST. Once it is not availed, it cannot be availed later on. Stop. The learned senior standing counsel for the revenue vehemently opposes the prayer for interim order, stating that such prayer would amount to granting more than the relief sought for in the writ application. To support his submission, it is submitted that it is further submitted that all the consequential benefit can be granted if the petitioner is ultimately gets the benefit of availing ITC as a result of the order passed in the writ application. Stop. In response thereto, the learned counsel for the revenue is also apprised of the fact that as per provisions of law, if the petitioner is unable or not granted ITC, then there is a limitation imposed by the statute for availing the same, claiming the same in future. He seeks further time to obtain instruction regarding the said aspect. The said instruction shall be filed along with the counter affidavit to be filed in the writ application. Stop. In the interim, it is directed that. What interim order, Mr. Mahapatra, then?
Well, I'm only saying this is not an assessment, it's an AR order.
It is submitted that the counsel for the revenue also submits that the present issue does not involve an assessment, and it is only a
authority decision of the authority for advance routing.
It is only a challenge to the order of the appellate authority of the advance ruling authority. Therefore, no interim order need be passed.
Yes, madam.
Having having heard the learned senior counsel for the petitioner and the learned senior standing counsel for the UP 3 and 4, as well as the learned CGC and the learned AC, we direct that the petitioner, suppose Mr. Mahanti, if you are allowed to if you are allowed to avail ITC after the returnable date.
Not 16.4 limitation. 16.4 limitation will automatically come, madams.
16.4 when the period ends. 16.4 period.
Not 16.4 period, but not 16.4. Over after my balance sheet is fine.
Every financial next financial is November to November.
Sorry, Subilanity.
My lords, after every financial year, my lords, I'll not be able to claim it. Once
so can you suggest the date?
My lords,
30th November, 30th next finance.
Sir, written under section 39.
My lords. Okay. The registered person 16.4, my lords. A registered person shall not be entitled to take input tax credit in respect of an invoice or debit note for supply of goods or services or both after the 30th day of November following the end of the financial year to which such invoice or debit note pertains.
So we can simply say no coercive action till the next date.
No, my lord, there is no question, no coercive action is not there, my lord. There is no demand at all.
Yes, time, my lord, 30th November.
Okay.
There's no urgency, my
lord. 30th November is already left.
Till the next date of hearing, the order passed by the AAR. AAR confirmed by the appellate authority of AAR shall not be given effect to without leave of this court. Yes. So Mr. Mahapatra is mighty happy.
My lord, that would have been his time, my lord. 30th November, he said that section 39.
Yes. So we have definitely fixed the matter only in July.
And that his contention regarding claiming depreciation, if it is capitalizing the goods, he cannot claim depreciation under Income Tax Act as well as claim ITC under this act.
We are awaiting our response.
We will be awaiting. I mean, it's a
yes, it's certainly an arguable topic, but not for an interim order, my lord. That's why contention.
No, so obviously we have not passed an interim order.
Deeply
because this is a unique interim order when both the sides are very happy. Till July, the next date is Satish. Will come Satish.
Deeply grateful, my lord.
Item 21.
So Patra search kali.
Yes.
So Patra unmute. Next call karantu pass over. 24, 22. Item 22.
My lords, may it please your lordship.
Yes, please.
My lord, this is a matter where the order of assessment has to be annulled on the basis of a judgment of your lordships, full bench judgment of your lordships in the case of M.S.RAMAN Private Limited. My lords, my dispute before the assessing authority was that I was a sick industry and I used to get some benefits from the BIFR. The government did not grant the benefits. I approached this honorable court for those benefits, for grant of those benefits, and this honorable court directed me to approach the BIFR for implementation of its order. I approached the BIFR for implementation of that order. By that time, the SICA Act was repealed and I was directed under the saving clause. I approached the NCLT, National Company Law Tribunal. And then the NCLT also decided the matter against me, against which I approached the NCLAT. Now, as far as my assessment was concerned, a demand was raised. The BIFR benefit was not given to me. A demand was raised. I approached the first appellate authority on the grounds of jurisdiction that under Section 10, since there was no assessment under Section 9 and the assessment was not communicated to me, the same could not have been made. So under Section 10 of the Orissa Entry Tax Act, no assessment could have been made at all. The first appellate authority decided the matter against me as there was a judgment of this Honorable Court in the case of Nilachal, which was against me. After the first
referred to larger bench. That was referred to larger bench, and that was when in the larger bench.
No, that was there, my lords. Then I approached the first after the first appellate authority's order. I approached the tribunal, Odisha Sales Tax Tribunal. During the pendency of the matter before the tribunal, the full bench of the Orissa High Court decided the matter of ECMAS regimes. And on the basis of the ECMAS regimes case, the assessment has to be annulled. Assessment has to be annulled because there was a return. My returns were accepted by an order by the assessing authority, but the said order was not communicated to me at all. So I was covered under ECMAS judgment. When I approached the tribunal heard the matter, and when I submitted all these things, the tribunal said that since the matter before the NCLAT is pending, we will not decide this jurisdiction issue. My lord, the issue before the tribunal was only the question of jurisdiction. Tribunal could not have done the BIFR issue at all. Before the NCLAT cannot go into the jurisdiction issue. NCLAT can only decide whether I am entitled to the BIFR benefits or not. So both the authorities had two separate jurisdictions, and this was informed to the tribunal. But still the tribunal said that we will await what the NCLAT will do finally. So this is my case before your lordships.
So the matter is still pending. Matter is still pending before the tribunal.
My lords.
Not tribe. Mr. Mahanti, what I understood,
my lord,
that before the tribunal, whether the assessing authority had the jurisdiction to adjudicate the subject matter. Before the NCLAT, whether your claim on merit of the matter is pending. So if on jurisdiction point, the assessment itself, the tribunal decides, it will have no bearing neither this way or that way. That is what I think. So tribunal should have decided this matter in second appeal.
Jurisdiction issue.
Then, in the second appeal, tribunal without waiting for the decision of NCLAT should have decided whether the assessing authority under the Entry Tax Act. It is under Entry Tax Act.
Yes, my lord.
So whether the assessing authority under the Entry Tax Act had at all jurisdiction to proceed with the assessment or not. That should have been decided by the tribunal.
Yes, Mr. Tribunal, you are there.
Yes, Your Lordship. I have two submissions, Your Lordship. First, I have to take instruction whether the what my learned senior is saying that this is covered under the ECMAS judgment or not, Your Lordship. And second, Your Lordship.
We are not on whether ECMAS is applicable or not.
Lordship.
We are on the issue.
Lordship.
This is a writ application against the order of the tribunal saying that keep the second appeal hearing pending till NCLAT decides.
Your Lordship, NCLAT is already decided. Your Lordship, NCLAT is already decided after passing of the order of the tribunal.
Mr. Tribunal, you are not hearing.
Lordship.
The appeal, NCLAT, I am saying. Tribunal, what the tribunal has said now, why didn't it decide the issue of jurisdiction in second appeal, which is raised? It has to confine it to the grounds of appeal. How can they go beyond that? What if, suppose
Mr. Tribunal, can you just look at, if you have a copy of that, you have a copy?
Lordship.
Look at the last operative portion.
Lordship.
Page 36.
Lordship.
Can you read it aloud? The fundamental issue of jurisdiction of
The
assessment.
fundamental issue of jurisdiction of assessment to invoke reassessment under Section 10 of the OAT Act is a question to be decided by this tribunal, and in the event of such question is decided pending the appeal before the NCLT, we are of the considered opinion that it will render the issues before the NCLT OTOs and also beyond the judicial discipline. That is
So
the.
how is it? So that I think that observation should not have been there.
Your Lordship,
Now,
just a small submission.
What kind of judicial discipline we can infer or you infer from between NCLT and the tribunal, because both are operating in completely maybe what you call complementary, but it is completely disjoint sets.
Your Lordship, I have just two small submissions, Your Lordship.
Yes. No,
Just a small submission. Just a small submission.
No, kindly just appreciate. We always, your point is well taken. Ultimately, tribunal will decide that ECMAS regime is not applicable. That is not the submission actually. What, as my Lord Father was pointing out, that maybe the tribunal will decide that. But tribunal waiting itself till NCLT decides. Suppose now, then the other problem would be Mr. Tibrawal. Then the tribunal would not be subject matter of this NCLT.
Your Lordship, just a small submission. Your Lordship, with respect, after passing of this order by the tribunal, the NCLT has already decided the issue, Your Lordship. The judgment was passed on 18/5, Your Lordship. So there is no difficulty for the tribunal to decide the matter further, Your
So we
Lordship.
are sitting at the side and sending it for the tribunal to take up and
Yes,
the
Your
hearing in the second appeal.
No, you need not set aside also, because that condition is not there also.
Condition is also
Same.
not there, Your Lordship, and NCLT
Condition
has
is not.
decided. On 18/5, the NCLT has rendered
No,
its judgment, Your Lordship.
The Annexure 5 is dated when? The recall application was dated. Tarikota kete?
Your Lordship, the recall was.
Mr. Mahanti, recall has not been considered.
Well, the recall application have been considered and they have disposed it off also.
But
And,
thereafter,
Mr.
NCLT
Tibrawal
has
says
decided.
18/5, it has been that condition of the tribunal is also now no more there.
NCLT has disposed of the matter.
So, Mr. Mahanti, is it your submission that the tribunal should go ahead without being influenced by the observation of the NCLT?
But now the tribunal has to go into the issue of jurisdiction under Section 10. That's all.
So, Mr. Tibrawal, should you keep it pending or will you dispose it off?
Your Lordship, I will have to take instruction, Your Lordship, what is the present status of the case.
No, present status definitely pending. I mean, Mr. Mahanti
Pending, but what has happened after the NCLT order, I don't have the instructions, Your Lordship.
Vivek Mahanti. Mr. Vivek Mahanti. We record the submission of Mr. Tibrawal saying that NCLT has already decided the matter which was pending before it on 18/5/2026. So on that basis, the ground on which the appellate tribunal, sales tax tribunal has stayed its hands from hearing the second appeal itself.
Is no more available.
So we will direct the tribunal to take up the second appeal for hearing on its own merits, including the issue of jurisdiction which you are raising.
Yes, my lord.
So on that basis, which can be disposed of.
So that order, because since I have already 3 days now, it will be dictated later.
So this is what the tentative.
That is the order.
Tentative order.
That is fair to.
So in case any difficulty, we will post it. We will record this. So I think there won't be any problem.
NCLT's order has also been filed before your lordships.
Yeah, the order is on record, your lordship.
Order has also been filed before your lordships by the petitioner.
In the IA, the order is on record, your lordship. Yes.
In the IA,
actually, we are of the prima facie view that the tribunal should not have detained itself.
my lords.
Because if that is so, then tribunal should have given the reasons also that why it is
My
detained.
lords.
Appearance like Mr. Vivekananda Mahanti, senior counsel, along with Mr. S.S. Ali for the petitioner.
Yes, Sajib.
S.S. Ali, number 2-3.
Yes, sorry. Sajib. Assistant.
S.S. Alibar.
S. Sajib. S. Sajib Alibar. 2-3-4 होचंती Mr. Tibrewal. Order to be dictated. Sanko order
Palesu. Mo dekhibu so.
Okay, काकुल देखते हैं. Given available with you upon dictated. Next.
Your lordship, item number 21 may be allowed. Item number 21 may be allowed.
हाँ सेटा अच्छी
हाँ
सर हाँ हमें सेटा करते हैं
Item number 21.
हाँ 21 आपण आसिलेनी बोली हम एक्चुअली पास ओवर करू कोन
म्यूट टिके लेट हेला तो सर काइंडली एक्सक्यूज
अब बैंक मैटर है सरफेस मैटर है हम इंटरफेयर करूनु
आज्ञा
आपण बैंक रो जदी कि वकील थिबे ताको आनंतु जेंति आर मैटर रे थिले सो वी सेड से कहले जे ना किछि एक्शन निया जीवनी त को नोटिस रे आछंती
हमें सर स्टे करे पे हम इंटरेस्ट दे दबो मूल पैसा तो रिस्पेक्ट कर देला
सर सुप्रीम कोर्ट रे जजमेंट बडा पढा पढी करंतु बहुत गुडे जजमेंट हे गेलेनी से बर्तन बहुत गाली देलेनी माने जीव इंटरफेयर करछंती
साउथ इंडियन बैंक देखो तो 2023 पीएचआर इन 2024
सत्यवती टंडन बहुत गुडे अछि से even they have observed that still high court are interfering.
High court
because understand that these are the nature of recovery proceedings. Recovery execution there is very limited scope. That is the film bare short
I am ready to
छुट्टी पर आसु हम तो किछ ऑर्डर करिबुनु सो छुट्टी पर आसु हैला
yes sir yes
सिंपली डेट कर दियो केबे चाहौ छथि कोबे डेट अपन मेंशन कर
22/6 सर कर दियंतु
ई कमेंसिंग कर दियंतु
2206
आपण 26 कंप्यूटर रे कर देबे
आज्ञा
ऑर्डर किछ हबन हैला लेट अस सेव टाइम नेक्स्ट 23
this is a matter of a PG medical admission 2025.
Kindly speak to the microphone, sir. Court रे जो अछंती सर ते कोर्ट माइक्रोफोन रे कोंतु
This matter.
आपण माइक्रोफोन पाखु पळांतु हां हां कोंतु
My lord, actually this is a matter of this PG medical admission 2025. Due to non-registration of the third round stray vacancy of PG admission to
आपनकर गोटे you must know that counseling रो गोटे schedule था so से schedule रे court cannot interfere. Supreme Court has time and again said so let them obtain instruction अपन notice नियंतु जा करंतु
in this already they have received the notice. Already they have the copy has already handed over to them.
सेटा को notice कहा जाय नि सेटा advance copy कहा जाय notice आमे दबो आमे तो देइनु आपण देछथि मु तो दे none of us
has already received the
first time
copy नीति receive करे our high court rules रछ सेटा actually आमे इंसिस्ट करछु मिस्टर महांती ओदा टू एक्सपेडिट सेमति आपण नेबे रेजिस्टर्ड
कोर्ट actually this class is already started and after getting the
सुनंतु आपण जोटा आर्ग्यू करछन आज इफ वी डू नॉट नो द सब्जेक्ट सेमति करंतुनी पीजी मेडिकल एडमिशन हैज इट्स ओन टाइमलाइन again and again highlighted that Supreme Court we cannot say that आकु दियंतु ताकु दियंतु आपनकर जदी पाइबार थिबो ताले you let the authority respond.
I was a party to that judgment.
Yes, I was a from this honorable court. We have approved them,
which is rendered by
and all the papers.
Division bench.
ଆପଣ ଅଛନ୍ତି ସମସ୍ତେ ତ ପିଜି କରିବା ପାଇଁ ଇଣ୍ଟରେଷ୍ଟେଡ ପିଜି କରିବା ପାଇଁ ସମସ୍ତେ ଇଣ୍ଟରେଷ୍ଟେଡ ସମସ୍ତ 2025 ରେ ଫିଜିଓଲୋଜି ରେ ବହୁତ ଜଣ କରିବେ let them take instruction.
My lord, actually there is a vacancy after received the vacancy letter.
Transfer posting no admission जे कोनसी वैकेंसी रे जे कोनसी पिला चाहिबो करिवो सेमति हेई परिबोनी आपनकर ऊपर के जण पिला थिले केते राउंड रो काउंसलिंग हेलानी आपण आगरु कोन पाइथिले आगरु पाड़ी की छाड़ी चंदी कि नाही देयर आर सो मेनी इश्यूज you cannot treat the subject as so naively vacancy अछि एडमिशन नबु सेटा नो Even आपणकर undergraduate admission आजिकली हेगलानी on basis of entrance. The petitioner is the applicant and
position देखिए कि
see both कथा the petitioner is the writ application has been filed with the following prayer. Stop. The petitioner is a candidate who had applied and participated in the admission and selection process for PG in medical PG in
PG medical course
2025-26. Issue notice.
Participate.
The learned additional standing counsel, Mr. Nayak appears and waves notice on behalf of OP number 1. Mr. Rajani Chandra Mahanti, learned counsel, who usually appears for OP number 2 and 3, shall appear and obtain instruction. He shall file wakalatnama within 7 working days.
Yes, ma'am.
Name of Mr. Mahanti shall be reflected in the cost list as well as the case brief. The matter shall be listed before the assigned bench in the week commencing 29/6. Mahanti, Mr. Nayak.
My lord. पूर्व भी चले better.
Urgent stay.
पूर्व टे केले better.
2200
ଆଣନ୍ତୁ
ଆଜ୍ଞା
ଯଦି କିଛି possibility ହବ please ଯଦି କିଛି possibility ଥାଏ admission ର please ensure that you can mention it.
Yes,
that you have to rise to the occasion. We do not know. ଆପଣ ଯଦି ମାନେ instruction ଆସିବ ଯେ admission ନେବେ please intimate him.
yes
24 ସେଟା clarify କରିଦେବୁ pendency of the case shall not be a bar.
ସେଟା କରିଦો ନା
pendency of the writ application shall not be bar in any manner for the authorities to act in accordance with law as far as the prayer made in the writ application is concerned. 24 Ms. Mahanti. 24 Ms. Mahanti. So Baijayanti Mahanti was the petitioner.
Am I audible, Lottie? Am I audible?
ebe asila kontu ebe subila kontu.
In this present writ application, the petitioner has challenged the illegal construction of Gammo Hato over a Gochoro land, my lord. My lord,
ଗାଈ ପାଇଁ ଦାନା ବିକ୍ରି ହବ ସେ ବି ଖାଇବେ so ସେଇଟା not an issue. ଆପଣ
Gochoro land ରେ
ଆପଣ ଡି ରିଜର୍ଭେସନ କୁ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି କି? Did you challenge the de reservation of Gochoro land? Rule 4.
No, your lords, I have not challenged the reservation. Okay.
Sorry.
I ଗୋଟେ ଅଛି construction stay ପାଇଁ ମାନ
ସେଟା କରିହବନି
construction କରିଦେବେ ଆଜ୍ଞା
ଗୋରୁ ପାଇଁ ଖାଦ୍ୟ ଆଉ କୁଣ୍ଡା ମିଳିବ
ଗୋରୁ ଆଜ୍ଞା ସେଥିରେ ଗୋଟେ ସେଇ particular plot ଉପରେ ଗୋଟେ
ଆପଣ ଯୋଉ ଗାଈ ଚରେଇବା ପାଇଁ ଚାହୁଁଛନ୍ତି ସେ ଗାଈ ମାନେ ନାହାନ୍ତି ଆଉ
not only that, my lordship, another ground is there.
Surprised one has to carry milk to village.
My lord, I believe that
is not available.
That has been developed, my lord.
There is a public purpose for constructing a gramo hato. Eta to gote personal bi kichi no. Kiye kale hospital hobani apun kale gramo hato hobani.
ନାଇଁ ଆଜ୍ଞା ମୁଁ ସେଠି ନାହିଁ ଆଜ୍ଞା ମୋର କହୁଛି ସେ particular that plot ଉପରେ another ଗୋଟେ ଦୋଳ ମଣ୍ଡପ ଅଛି ଯୋଉଠି କି entire function ତାଙ୍କର
ଆଜ୍ଞା ସେମାନେ ଗାଈ ମାନଙ୍କର
ରହିଯାଇଛି ସେଠି
କୃଷ୍ଣଙ୍କର ସବୁଠୁ ପ୍ରିୟ ହେଲେ ଗାଈ
ଆଜ୍ଞା
ସେ କୃଷ୍ଣ always will find them with the ଗାଈ so ଗାଈ ମାନଙ୍କ ପାଇଁ କରାଯାଇଛି କିଛି ଅସୁବିଧା ନାହିଁ JK Khandayatra additional standing counsel for the
all opposite parties, my lord.
For the opposite parties, the petitioners are the villagers of village Andhipalli in the district of Bhadrak. They have approached this court raising a grievance regarding construction of Gramo Hatta on a particular patch of land. Dolo Julana ya jodi ne seti hei paribo.
Seti already construction heichi seti tankara enter gaar so function ho jayega.
Dana bikri hobo.
Again enter gaar dolo mandap agya jura heichi tankara enter
gaar dolo mandap nahi seti. ସେପଟେ ଦୋଳମଣ୍ଡପ କନସେପ୍ଟଟା ସେପଟେ ବିମାନ କନସେପ୍ଟ ଅଛି
ଅଛି ଆଜ୍ଞା
ଆପଣଙ୍କ ଯଦି ଲୋକାଲ ନଲେଜ ଥିବ ଦୋଳମଣ୍ଡପ କନସେପ୍ଟଟା as you travel towards south of Orissa
ତାର କିଛି ମେଲଣ ମଣ୍ଡପ ଲେଖା ହେଇଛି ହେଲା ହେଲା ଜୟ ରାଧା କୃଷ୍ଣ ମେଲଣ ମଣ୍ଡପ ସେଟା particular that
so that is exactly the description. It is a ପଡିଆ ଦୋଳ ମେଲଣ ସେଠି ହୁଏ
Podia ache se
Instruction by Gramo. The Lord Additional Standing Counsel shall obtain instruction in the matter in response to the writ petition. The matter shall be listed in the week commencing.
22nd asu sage.
Second week re.
22nd reopening day.
नहीं सब जगह में केमिति हो एडमिशन भी होगा हेबियस कॉर्पस
आज
week commencing 6-7-2026
till then
आइए the Lord Additional Standing Counsel shall obtain instruction आइए होची
9550
9550
till then construction may be stayed.
आइए गाय माने कर खाए दवा पड़ो it has to be sold in a particular place.
My lord, authorized by the next day.
पशु आहार गाय माने गाय चोरू नांती पशु आहार चुनी चोकड़ खाइबे 25 कोटे सिमिलर ऑर्डर थिला
रिप्रेजेंट इनफ्रक्चर से जो है
नहीं से किछि गाय माने तो चलिबा कोन गोचर रहले कोन हो जे अर्जेंसी भी नाही एते 25 कोटे विड्रॉल ऑर्डर कोटे थिला हमर
May it please the court. Your Lordship, I am appearing in
Siddhanta Solanki for the petitioner.
Yes,
we are actually not inclined to entertain, but we are passing a order. Either government counsel Mr. Khandatre or Mr. CORAM.
25 रे की अछन
Khandatre, please kindly unmute करो.
Lordship, 25 is not allotted to me, my lord.
Mr. Government Advocate Mr. CORAM कर दे. से order भी थी. Withdrawal कोटे order ही थिला गोटे. से बाहर कर देबे 50 withdrawal. Yes.
Lordship.
So thank you for your time.
आइए देइछन
आइए हां आइए 102030 of 2026 along with WPC 12604. So withdrawal order is the same exact format रे कर. Mr. CORAM government प्रयास करो. So we'll be resuming the single bench at Chatta Pandra because none of them have gone for any food and anything there.
Lordship.
Yes.
My lord, may pardon me to make a mention. Your lordship may kindly pardon me to make a mention. My lord, on 1st of May, 1st of June, I had given 4 memos.
Yes, Mr. Boss, can you hear me?
Yes, my lord.
Yes.
Am I audible, my lord?
Yes, now you're audible.
Yes. My lord, on 2nd of May, I had mentioned 4 memos.
Yes.
2 CMPs and 2 MSs.
Yes.
2 CMPs have been listed. My lord has been kind enough, it has been listed. 1
Yes.
MSA, the entire case will be infructuous on Monday because in the Orient court, my exemption application for payment of 30% deposit, which is there under as per section 33, I had sought a waiver. That was rejected. Against that, I had filed a writ. Writ was withdrawn with a liberty to file a MSA. MSA has been filed. My lord, he has posted the matter to Monday for dismissal of the appeal unless I pay, which order is under challenge before your lordship. My lord, can it be as the last case MSA 26 of 26?
Other MSA, I'm not worried because that is on 10th.
Miscellaneous second appeal.
Yes, my lord.
No, I think miscellaneous second appeal actually is not in the roster. There is another problem there. It is being listed before Honorable the Chief Justice.
My lord, now vacation.
So I understand. I understand. So for that, actually, you should have informed the Deputy Registrar that he should have.
I had informed him. He had memo was allowed on 2nd.
Memo he has to accept. Actually, he can't select.
No. My lord, I had mentioned.
But I was checking. As I was checking, I found that these are not in the roster.
But
so then there is a difficulty.
My lord, 8th it will become infructuous. That is my entire problem. The entire exercise will become odious because the appeal will be dismissed.
So I mean, nothing can be done now, Mr. Bose.
My lord,
hopefully status quo and ante can be restored by the.
My lord, once the appeal is dismissed, unless I challenge that appellate order again, my lord, this MSA becomes.
Maybe perhaps that is the only way out. That you have to after it is dismissed, you challenge and it will be restored again.
My lord,
I understand what you are. Yes.
My lord, there the court fee will be. I have to pay that court fee. That this is an interim order. I need not pay court fee. There I have to pay 50%.
Maybe you have to seek extension till the reopening of the court.
My lord, that much if your lordship may give me that, I'll file an application.
No, there is a issue regarding the listing of the matter. Actually, it is not in the roster.
But now it's a vacation court. My lord can take up.
I understand. But since it is not in the available roster, you will find that it is not available in the roster for the entire all the courts.
My lord, now it is.
Perhaps it was taken up as an exclusive whatever matters they were taken because like any other assignment.
Yes, my lord, being a vacuum state now, my lord, I only pray as a last case your lordship may accommodate me, or else 8th I will be infructuous, my lord.
Infructuous in the sense you have to seek extension there. If they do not get granted, then I don't know what would happen.
My lord, they had granted me extension on 2nd and posted the matter on 8th because I have filed an application that I have mentioned and my mention memo has been allowed to 5th. That is the reason I'm mentioning, or else, my lord, I would not have mentioned.
No, there will be difficulty for me in taking up. There's no point in listing that matter. You have to leave it there.
My lord, I only pray your lordship may grant me that liberty to make an adjournment. Unless there is an order by your lordship, he will not grant me that liberty.
No, at least since you have moved the High Court, then they should.
My lord, already I have availed one.
On that ground, you have to challenge that order. If they pass any order, you have to challenge that.
My lord, I have already moved the authorities, and that is the reason he has posted on 8th. Or else, my lord, I would not have disturbed your lordship's board. I know it is not in the roster. I have checked up, my lord. It is on the roster of Honorable Chief Justice because any other assignment is in the roster of the. But now, my lord, Honorable Chief Justice not being in session, your lordship being the vacation court and the Honorable Single Judge, that is the reason I am mentioning, my lord.
I understand, but I think for that, that instruction has to be sought for. Because there was a dilemma on that, so let us see.
My lord, I am giving the number if your lordship may kindly accommodate as last case. I just request.
No, in fact, I am not listing that. I will not be listing that.
My lord, my predicament
because while checking up the listings yesterday, I found that it is not in the roster. So that is how it was not there.
But my lord, this is the problem now.
I understand.
My lord, on 8th it is dismissed. If on 8th it is dismissed.
For restoration, you have to move again.
No, he will dismiss it for on merit, on non-payment of court fees. He is not dismissed on merit.
One thing you can do, you file your application for adjournment till since the matter is not listed, because it's a fact that the matter is not listed before this court and it can only be listed after reopening in the week commencing 22nd. So mention that you file that application, let him pass the order, let the learned court pass any order. At least that may save you.
My lord, he has already passed an order on my petition on 2nd.
I understand. But understand, since this is the High Court is not in. High Court could not take up the matter. So it can only be taken up in reopening. That mentioned, you have to file that application. Let us see how the court is responding. I mean, in the sense from your side, I cannot see, but hopefully that will give you a lease of life to the case.
I don't think so, my lord. I don't think so because many things I cannot say.
Suppose they pass the order. Suppose they pass the order, it can be challenged on that ground. Because the court was made aware that the matter could not be listed.
Well, that much of a liberty, if your lordship make pass in my application, that will also do, my lord.
No, I'm not. I did not list those matters by checking the roster, so I will not do it. Yes.
My lord, if I may make a mention, my lord, there is emergency.
To make a small mention, my lord. Under
Yes, Mr. Misra.
Under peculiar circumstances, I am mentioning, my lord. I have tried.
Sir, if you are listing on Tuesday, on the next day, the mentioning is 8th. I cannot direct listing on 9th. You must understand. Because now the open court mentioning is instead of it is now available to everyone by filing memo in the DR box.
I did that, my lord, but it was not listed. Today's bench.
This week what has happened, actually the same division bench and same single bench. So they have a difficulty in managing the day actually. Even if suppose I like to sit till midnight, so but the staff has to be available, everything has to be made available.
No,
and you know as we are so you can only make a mention on Monday for the 9th. If you have an impression that I can direct listing on Tuesday, this bench is for today only. Now it is over. For this week it was there. So please make a mention on Monday. Okay, and whenever you are filing memo, my suggestion is that if you have filed it earlier, then also mention that earlier mention, so that can be taken note of. Yes. No point, because I cannot list it. As you have heard, Mr. Bose, I cannot list it now. Yes. Yes, Mr. Roy, item 1.
Item 1. At the outset, I make a submission. In this item 1, I have entered appearance today. Only in the first hour, my Boklatnama is there, my learned friend is there, available in the court, but we cannot file it. It is there in the court. I am appearing for the sole opposite party. In fact, in the last date, the petition, the opposite party himself appeared online, and it was directed to serve him in the copy. He collected the copy, but as it was handed over to me in the today morning, I have also prepared a preliminary objection, and that is there. My learned friend is there in the court itself, because we cannot pass
Mr.
I will serve a copy if my learned senior Mr. Das is also there online. If any learned friend will be there, serve him a copy.
It has compromised on the entire discipline of the bank, my lord.
No, that on merit I have a submission, but today the difficulty I am just placing to the court.
No, my lord,
they have come against the interlocutory order.
Mr. Das, actually, I mean senior Mr. Das. Senior Mr. Das, I am saying that younger Mr. Das is not seeking for adjournment. He says that he doesn't have a copy, so he requests for till Tuesday.
No, copy, my lord, I have.
He admits.
I have. I have filed the objection also. My objection.
What objection, my lord?
My learned friend, Mr.
Ray, so Mr. Das, you do not require any copy, but you want time till Tuesday.
Tuesday, yes, my lord. I can. In the meantime, I can serve him with a copy. Today, I will also file in the registry my Boklatnama.
So what I am doing, since passing an order will be putting difficulty for Mr. Rajit Ray and Mr. Senior Mr. Das, because there may be a problem in listing. Let it be simply adjourned. So you complete and you have to, Mr. Ray, you have to move it on Monday. File the memo on Monday.
My lord,
today I am filing in the registry, my lord.
My lord, may
I will file in the registry.
My lord, may kindly see my lord's my lord Justice Mahapatra's order.
It is not that urgent.
It is very urgent.
Yes. Merit my senior will place.
Younger Mr. Das, now once you say that you want it on Tuesday, why you are arguing on merits with your senior? So if you let him complete, he's saying urgent, let us hear him. Yes, Mr. Das, Senior Mr. Das.
Lord, I am only requesting, my lord, the previous order was that I was given leave to serve copy on the other side, my lord, and on the very same day. My lord, this is a case.
He said that. Yes. The petitioner appeared in person and has received the copy.
I have one request, my lord. In the last occasion, my lord, an order was passed, my lord, which is saying that it will be before my lord's bench. My lord, may kindly see my lord Justice Directed to get it listed on so and so date.
Next vacation code. Okay.
Yes. So therefore,
Okay.
I'm requesting it, let it be on 9th.
So-
I don't know, pass an order because only
So when he wants to argue and he seeks time, so to that extent, 1 day time is not difficult, Mr.
No. Yes.
So let it be on Tuesday.
Yes. I'm all right.
So only problem is that if I start dictating order and pass any order, there will be difficulty in listing the matter. So what you do, you move a memo on Monday.
My lord, see, difficulty is, my lord, if my lord Justice K.R. Mahapatra also, I requested for this reason that, my lord, it is creating an anarchy, my lord. This is a bank, my lord, where a person says, which is determinable on the face of it, my lord, the appointment letter which he has given, he has to be given 1 month's notice in lieu of 1 month's salary, he can go. That is his employment, my lord. And an injunction has been granted ex parte, totally flagrant violation of 39(3), my lord. And of this, and 14 and 41 of the Specific Relief Act, my lord. It's a contract of service, my lord.
So now if he start argues without the copy being served, then that will be difficulty. So what you do, you again get it listed on.
My lord, give me that leave to mention. My lord,
it will be better. It would be better if no order is passed, so that you have the freedom to list it again.
My lord, I'll have difficulty.
I have no problem in passing an order. In fact, I'm not hesitant to pass an order also. But since the next bench is not my bench, that may create a problem.
No, my lord. In fact, my lord Justice K.R. Mahapatra exactly did that because of the fact, the seriousness of the matter, my lord. My lord, to me kindly visualize that the seriousness of the matter is that because it's not listed, my lord. We are Order 39, Rule 3, my lord. We are suffering someone that I have to give him an employment of what the nature he wants, my lord. How is it possible?
So then shall I pass the order or not? That is your choice.
No, I'm leaving it to my lord's discretion, my lord.
I have no difficulty. I have no difficulty noting the order of Mr. Samir Das. Sorry, request of Samir Das for adjourning the matter to the next state.
Yes, my lord. That is all.
I am bringing to your notice that may create a problem because next date is not my court. Please appreciate.
It will help us, my lord. It will help us, my lord.
Okay, then I'm passing that order. No difficulty.
My lord, we pass that order.
Mr. Jaswant Das, here advocate, along with Mr. Rajit Rai for the petitioner. Mr. Samir Kumar Das, advocate for the opposite party. The learned counsel for the opposite party submits that he has appeared on behalf of the opposite party on
today, my lord. Today I am filing the.
Okay, he has instructions to appear. He has instructions to appear on behalf of the opposite party.
I file today, my lord. It is there.
He shall file wakalatnama duly executed by the opposite party. Today to aji hoy paribani.
Monday. It is there.
By Monday.
My lord.
By Monday. The Lord Senior Advocate appearing for the petitioners refers to the earlier order passed by the coordinate bench dated 29/5/2026 when the coordinate bench had directed to seek had granted liberty to move the next vacation court for listing of the matter. The petitioner has liberty to move the next vacation court for listing as requested by the learned counsel for appearing for the opposite party. He shall file his wakalatnama by Monday. It is further submitted by Mr. S.K. Das, learned counsel, that he has filed an objection.
Yes,
now you will file.
Along with the wakalatnama, I will
the petition, the opposite party shall file objection to the petition, copy of which shall be served on the instructing counsel, Mr. Ray, by Monday. Yes.
Much of that.
Last
Grateful, my lord.
Yes, anything else? Yes.
I'm sorry for bothering, my lord.
No, not at all.
No. Obliged.
Item to Soumik Prasad goes for the petitioner. Yes, Mr. Bush.
My lord, here the opposite parties are the decree holders who as plaintiffs filed the suit for a declaration title and other ancillary reliefs.
Yes.
This suit was decreed ex parte.
Yes.
After the ex parte it was decreed,
Yes.
execution proceeding was filed.
Yes.
In the execution, when execution notice came to me, we filed an application under Order 9, Rule 13 to set aside the ex parte judgment. That is pending. That is under annexure. My lord may kindly turn to annexure.
Order 913 is pending.
Yes. Order
Yes.
9,
Noted.
Order 9 Rule 13 is pending.
Okay.
In the execution petition, I filed a petition to stay the execution case till Order 9 Rule 13 is concerned, because the executing court and the court which has passed the decree and Order 9 Rule 13 is pending is the self-same court.
Okay.
That application having been rejected, I am before your lordship. My only prayer is, my lord, that Order 9 Rule 13 be targeted because the parties have appeared. It may be disposed of within 3 months, and after disposal, the execution may proceed. If I fail in Order 9 Rule 13, the execution will proceed.
Okay, you take notice. Let the other side appear. That order can be passed. Yes, that order can be passed, but after they appear.
Yes, ma'am.
The petitioner in the application is the judgment debtor in CS number 69 of 2018, disposed of by the learned senior civil judge Jaipur, ex parte,
on 21/12/22.
on 21/12/2022. The said judgment and decree being put to execution has been registered as E.P. 12 of 2023.
Yes.
Arising out of CS number 69 of 2018, pending before the self-same court of learned senior civil judge Jaipur. It is further submitted that CMA number 23 of 2024 under Order 9 Rule 13 of the CPC has been filed by the petitioner hearing for setting aside the ex parte judgment and decree, which is pending adjudication before the learned civil judge senior division Jaipur. Before this court, in the present petition, the impugned order is at
Annexure 1.
24 the petition at 24/4/2026. Before this present petition, under challenge is the order dated 24/4/2026, rejecting the petition filed by the judgment debtor for deferment of the proceeding, deferment/stay of the execution proceeding on the Order 21 Rule 26. Stop. The said application seeking deferment/stay of execution proceeding has been rejected, hence the challenge. The learned senior civil judge has relied on Periyamal versus V.V. Rajaman while rejecting the application seeking deferment of the execution petition. It is submitted by the learned counsel for the petitioner that unless the execution is stayed, the application under Order 9 Rule 13 shall be rendered infructuous. But issue notice along with this order. Issue notice to the opposite parties along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. Returnable date be fixed to returnable date be fixed to 3 July 2026.
Matter shall be listed for orders before the assigned bench in the week commencing 6 July 2026. तीनटा को एक करते हैं 1 जुलाई को गैप करते हैं 1 जुलाई shall be listed for the assigned bench on 6 July 2026. Stop. IA 1039-2026 had lawyer counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above, accept one set of process fee as well as postal requisites. Hello. The returnable date as well as the next date of listing shall be as directed above. Stop. As an interim measure, it is directed that the further proceeding in the EP number 12 of 2023 arising out of CS number
69 of 18, madam.
69 of 2018, pending before the Honorable Judge, Senior Civil Judge Jaipur, shall be adjourned to a date beyond 13/7/2026 upon a prayer being made for the said purpose. To adjourn to a date to a date as would be convenient to the learned court in season of the matter, then comma, then upon a prayer being made for the same. Yes. Object certified copy as per rules. Copy of the parties shall have liberty to act upon the sentence of the complete court. Official website.
Great.
Yes.
Grateful.
Yes.
Item 3.
My lord, the plaintiff is before your lordship. Plaintiff filed the suit for declaration and permanent injunction.
Yes.
Along with that plaint, an IA was filed. Initially, Order 39, Rule 3 application was allowed, status was granted. Then, in the final result in the IA, the interim application was dismissed.
Yes.
That is under Annexure 2, my lord. Challenging that 39, 1 and 2 under Order 43,
Yes, sir. After 10/3/2026?
my lord, after it was dismissed, I filed FAO challenging the dismissal of injunction application. In the
Yes.
FAO, notice was issued and I filed 2 IAs for taking up the matter ex parte as the vacations are there and there is a threat of demolition. The notices in IAs were issued. I was asked to take by special messenger and service affidavit was also filed along with the same. But now after the service affidavit was filed, as the opposite parties did not appear, the matter has been posted to reopening.
Yes.
It has been posted to 24/6/2026. My averment, your lordship may kindly see at paragraph 9 of the petition. The first appellate court, without considering the situation of the case and nature of the petition for interim injunction, without going to the end, appeared before the court without considering the interim petition and answer, posted the matter to 24/6/2026, in which period every chance the opposite parties may be evict the petitioners any moment. My lord, my entire grievance is...
So it's a declaratory relief against private individuals?
No, it is a government. It's a general administration. My lord, your lordship will see.
State, my lord.
Bhubaneswar Municipal Corporation, Bhubaneswar Development Authority and GA Department.
Okay. Yes, Mr. Lenka, you are appearing.
Yes, I am for OP1, my lord.
Yes.
Yes. And the state is a formal party here.
My lord, GA Department, there is no threat of eviction. Eviction is from BD and BMC.
Notice to go.
Yes. Mr. Amit Prasad Bose for the petitioner to D. Lenka AG for OP number 1, OP 2 and 3 blank. The application has been, the petition has been filed. for grant of interim order that was refused to be granted by the learned Civil Judge Junior Division Bhubaneswar in IA number 495 of 2008, arising out of CS number 397 of 2008.
It was
They submitted that the IA 495 of 2008 was finally disposed of by order dated 10/3/2026, rejecting the prior under Order 9, Order 39, Rule 1 and 2, made with Section 151 of the CPC, to restrain the opposite parties from entering into the suit scheduled land and to deal with the same in any manner till disposal of the suit. They submitted that after rejection of the interim prayer by order dated 10/3/2026, FAO has been filed before the District and Session Judge Buddha in by FAO number 34 of 2026. The said FAO has been in the said FAO order, notices have been issued.
Yes, notice has been issued. Notice is sufficient by service affidavit.
Notice has been issued and notice is sufficient by service affidavit. However, the learned appellate court has not passed any interim order protecting the interest of the present petitioners who are the plaintiffs in the suit. That is CS number, suit, CS number 397 of 2006. So, submitted that due to the non-availability of courts during the ensuing summer vacation, the petitioner will be highly prejudiced. The petitioners will be highly prejudiced if interim order is not granted. Stop. Para issue notice along with this order, not granted as prayed for. So notice along with this order, Mr. D.N. Lekal, learned AG, upon advance copy served, appears and waives notice on behalf of OP1. Issue notice to OP2 and 3 by speed post with registration and proof of delivery. Requisites for issuance of notice shall be filed within 3 working days, fixing returnable date to 24/6/2026. The matter shall be listed in the week commencing on 30/6/2026. Hard learned counsel for the petitioner. Stop. He reiterates his submissions as noted above. Issue notice as above, accept one set of process fee as well as postal requisites along with the petition. The returnable date as well as the next date of listing shall be as directed above. Next date of listing is actually returnable date the matter shall be listed for orders in the week commencing on 30/6/2026 before the assigned bench. Set super as directed above. In the interim, it is directed that the status quo as on date regarding nature, character, ownership, and possession of the property, of the subject property, which is the subject matter in the suit as well as the FAO, shall be maintained by the parties to the petition till the next date of hearing. Urgent certified copy as per rules. Parties shall have liberty to issue.
My lord, I have mentioned the schedule in the IA also.
IA schedule property, subject matter, and schedule A mentioned in the IA.
Great.
Yes. Madam, Mr. Pati.
My lord, may I please?
Yes.
In this case, the petitioner is claiming that stoppage of the commuted value of pension, which has been deducted from his pension since 14/4/2016.
Yes.
My lord, it has been 10 years has been completed on 14/4/2026. My lord. My lord, Annex 9 is the similar matter, and the coordinate wise also passed several order for adjudication. And
I mean, you mean this bench? This bench has passed order.
my lord, all other bench also.
Annex 9 is by this bench.
My lord,
by the honorable court, ma'am.
by the
नहीं आपण से जो डेट गुडा को एथरे कोन देछन करेक्शन करी
हां सर सेटा सर 14/4/2026 सर प्रेयर रे मोर लिखा है
अरे नाइ मो सेटा मो कहनी आपण जदी सेटा जो टाइम शॉर्टेज थाए तो एटी आपण एफर्ट करिवे ना ठीक अछि इट इज सबमिटेड बाय द मिस्टर मानस कुमार
कॉपी आई विल सर सेंड यू आई विल करेक्टेड कॉपी आई विल सेंड यू
आपण केते बेला देबे तो 5टा बजल
सर आई विल कोर्ट मास्टर को एट दे दे
ठीक अछि मो डिक्टेट कर दोछि से ये रे
sir.
Mr. Manas Kumar Pati for the petitioner, Mr. Jayanta Kumar Bala AG for opposite parties 1, 2, 3 and 5.
Sir, only 1, 2, 1, 2, 3, 1, 2 and
no,
4.
Sorry, 1, 2 and 4. 1,
Sir.
2 and 4.
I will serve copy to
Patra. Mr. Patra standing counsel.
Patra.
1, 2. I am for
So,
1.
Sudhir Patra standing counsel for OP3.
My lord. 1, 2, 4.
Appearance completed. It is submitted by the hand-learned counsel for the petitioner. It is submitted by the learned counsel for the petitioner that the last date of deduction of the amount towards commuted value of pension withdrawn by the petitioner, comma, a retired employee. Annex 9 is what is. Starting with केबे आरंभ भेले?
Sir, 14/4/2016.
14/4/2016 is
14/4/2026.
14/4/2026 after completion of 10 years. It is submitted that even after 14/4/2026, the amount is deducted from the pension of the petitioner. Stop. Para issue notice along with this order to the opposite parties. Sri J.K. Bodal on a DGA appears and waives notice on behalf of the
1, 2, 4.
opposite parties stately. Late one extra copy be served on the extra copy be served. Upon serve question Patra.
No, sir. I will serve it.
Let 2 extra copies be served on Mr. Sudhir Kumar Patra, not at standing counsel, for appearing for the accountant general A and D. तो लिखो तो the matter shall be listed in the week commencing 13/7/2026 before the assigned bench. The opposite parties shall file their counter by 1/7/2026 upon serving copy thereof on the learned counsel for the petitioner. Para IE 1035020226. Hard learned counsel for the petitioner, he reiterates his submissions as noted above. Issue notice as above. Having heard the learned counsel for the petitioner as well as the learned AG, as an interim measure, it is directed that no further recovery shall be made from the pension of the petitioner towards commuted value of pension. The recovery made till date shall be subject to the result of the writ petition. Stop. The petitioner also undertakes to abide by further directions that would be made by this court regarding his liability for payment of the installment towards commuted value of pension. The IE is disposed of. Upon इतने गोटे ये रहे इशू रहे Mr. Pati that you have to pay it again. Deduct हेगले सेमाने फेरी दे पारिबे. I don't know how far that suits you, but because upon notice नहीं कि परे भी they would have refunded the amount.
Sir.
They have to. But here, if you are now stopping to pay, then obviously you have to pay it again. Because the interim order has to be equitable also. Or else how it, mention they are paying and how it will be protected. Yes. What's next?
Sir, item 12 also similar, sir. Item 12 also similar.
12 ରେ ମିଷ୍ଟର ବଳ କିଏ ଅଛନ୍ତି?
Bar 12 my lord, I am appearing. Pick करे.
प्रदीप कुमार राय. ଆପଣ ଆଙ୍କୁ ଆକାଉଣ୍ଟାଣ୍ଟ ଜେନେରାଲ କୁ ପାର୍ଟି କରିଛନ୍ତି?
ହଁ ସାର୍ ସେମ୍
1/12 ରେ ସମାନ ଅର୍ଡର ହେଇନି। ଆଉ ଡେଟ୍ ଗୁଡା କାହିଁକି?
ମୁଁ ଡେଟ୍ ଗୁଡା ସାର୍ ପ୍ରେୟାରରେ ଅଛି ସାର୍ ମୁଁ ଦେଇଦେବି ସାର୍ କପି ସର୍ଟ
12 ରେ ପ୍ରେୟାର କହୁନାହାନ୍ତି ଡେଟ୍ କହିବେ ତ ଖାଲି ଆପଣ।
ହଁ ସାର୍ ସେଟା ହଉଛି ସାର୍
ଷ୍ଟାର୍ଟିଂ ଡେଟ୍ କେବେ ଲାଷ୍ଟ ଡେଟ୍ କେବେ ଦେଖି ତ ଦିଟା କଥା କହିବେ।
ହଁ ସାର୍ 28/2/2014 ସାର୍।
12 लिखंतु मानस कुमार पति मिस्टर प्रवीर कुमार राय एडिशनल गवर्नमेंट एडवोकेट तो सुधीर कुमार पात्र स्टैंडिंग काउंसिल अकाउंटेंट जनरल को भाई स्टार्टिंग डेट हबो केते कहउछंती आतरे कोंतु
28/2/2014
28/2/2014
एंड होची 28/2/2024 सर
आफ्टर कंप्लीशन ऑफ 10 इयर्स
28/2/2024
28/2/2024 even after 28/2/24 it has been deducted as it data. Yes.
Publish.
Item. Yes.
Miller, item number 5 Miller make
Yes.
resolution.
Yes.
But here is a case, the action of the executive officer, Dekanal municipality Miller is under challenge Miller. What happened Miller?
So Rajesh Ranjan Sahoo for the petitioner. Still 5 re Mr. G you are there?
My lord.
Five, Mr. Bolo, you are there?
My lord, 5, my lord. I am appearing.
Mr. Jayanta Kumar Bolo.
Mr. Bolo is there.
Mr. Jayanta Kumar Bolo, AGA for the opposite party. 2, then TO2. 2 to 5. Hello? Yes.
Lord, what happened? Initially, Annexure 3 was issued to the petitioner Miller. It was a notice to show cause Miller. The petitioner was physically appeared with No, Miller. There is no road encroachment, no drainage was there. I was occupying the land since 50 years. Now the municipality Miller come up with the action. He want to summarily evicted the petitioner from his possessed land Miller. I have been occupied the land Miller since 40 years. And the state government Miller acknowledged my acquisition. Initially in the Miller the Basti settlement, I was given the Basti Basinda Pramanapatra Miller that I will file in the meanwhile Miller. And now in the meantime, Annexure 4 was issued. It is a general proclamation notice. Kindly, yes Miller.
ଆପଣଙ୍କ ନାଁଟା ଯୋଉ ଅକୁପାଣ୍ଟ ଙ୍କ ନାଁଟା କୁହନ୍ତୁ ରଜନୀ ନାୟକ
ରଜନୀ ନାୟକ Miller.
କୋଉଠି ଅଛି ତାଙ୍କର?
I have mentioned the schedule.
ଆପଣଙ୍କ ନାଁ ତ ନାହିଁ ROR ରେ ବେଆଇନ ଦଖଲ ଆପଣଙ୍କ ନାଁ ତ ନାହିଁ ROR କଲମ 12 ଦେଖିବେ
No, Miller. My name is not there in the ROR Miller. But I have
ଆପଣ କଣ ଯୋଉ କିଣି ଦେଇଛନ୍ତି କି ଯୋଉ ସବୁ ବିକିକି ଯାଆନ୍ତି ଜବରଦଖଲ ଜାଗା ବିକୁଛନ୍ତି ସେମିତି କରୁଛନ୍ତି ନା କଣ?
No, Miller. My case is that No, Miller.
The notice is very clear, my lord. That notice is that you have produced the documents, original document for the authority. He has not produced that documents, my lord.
Let me submit my case. I request my lordship.
अरे सुनंतु आपण जो सबमिट करिवे आपण 5:05 रे घंटे भी सबमिट करले कोन हो अल्टीमेटली बिना कोन तो उत्तर दे पारु ना कॉलम 12 रे मंतव्य रे आपण के ना एंट्री अछि की नाही जदी भी फिर तो आगु जीवा ना अटकी सेट रहिले हम आ विचार होबनी सइला कथा
My case is that
आपण ना नाही हला ठीक अछि तापर कोन हला आपण केमती आसिले आपण जदी आरओआर रे रिलाय करछंती आरओआर रे आपणकर बेन दखल नाही आपण काउंट किनिछंती ना कोन
Miller, my predecessor was came to the land. They were occupied the land.
Predecessor माने किए predecessor माने किए आपण predecessor तो गवर्नमेंट
Miller, my father-in-law
ଆପଣଙ୍କର ଯୋଉ ପର୍ସନାଲ ପ୍ରପର୍ଟି ଅଛି ମିଷ୍ଟର ସାହୁ ତାର ପ୍ରିଡିସେସର ଇନ ଇଣ୍ଟରେଷ୍ଟ କିଏ?
My grandfather, thereafter Miller, my father, and thereafter Miller.
ସେଟା ଆପଣଙ୍କର କୋପାର୍ସନାରୀ ପ୍ରପର୍ଟି। ପ୍ରିଡିସେସର ମାନେ ଆପଣଙ୍କ ଭେଣ୍ଡର ସେଲର କି କଣ ଗିଫ୍ଟ ରହିଥିବ। ଏଥିରେ ତ ଆପଣ ନିଜେ ରଖିତ ଅନାବାଦୀ ଭିତରେ ପ୍ରିଡିସେସର କଣ ହବ? ଯେତେବେଳେ that is the difference between a common man who is coming to telling you and what you are submitting before the court.
Now, my submission is that this is the government land. There is no dispute that my name is not there in the.
ଆଜ୍ଞା ଆପଣ ଯଦି କିଛି ଆପ୍ଲାଏ କରିଥାନ୍ତେ କିଛି କ୍ଲେମ କରୁଥାନ୍ତେ whatever ଆପଣ ସେଟା ରିଟ୍ ରେ ଆଣିଥାନ୍ତେ। ଆପଣ ତ ସିଧା ଆସିଲେ କହିଲେ ଚ୍ୟାଲେଞ୍ଜ କଲେ ଏଭିକ୍ସନ ନୋଟିସ କୁ। ଏଭିକ୍ସନ ନୋଟିସ ପାଇଁ କହିଲେ ଆରଓଆର ଦେଖନ୍ତୁ। ଆରଓଆର ରେ ଆପଣଙ୍କ ନାଁ ବିଲକୁଲ ନାହିଁ। ଆପଣ 40 ବର୍ଷ ହେଲା ରହୁଛନ୍ତି ଆପଣଙ୍କର 40 ବର୍ଷ ହେଲା ରହୁଛନ୍ତି ଆପଣ ଦେଖିଛନ୍ତି ଆରଓଆର କେବେ ପବ୍ଲିଶ ହେଇଛି? ଡେଟ୍ କେତେ?
Yes, Miller.
Yes, Miller ଟା ଗୋଟେ ଡେଟ୍।
1986, 37, 1986, the final arrow is published.
ଆପଣଙ୍କ ନାଁ ନାହିଁ।
Even if Miller accepting the fact that my name is not there in the remarks column, Miller.
So how, what even if? ତାହେଲେ ଆପଣଙ୍କର ଯୋଉ ପ୍ରପର୍ଟିର କଣ ଭ୍ୟାଲ୍ୟୁ ତାହେଲେ କଣ ରହିଲା? ଯିଏ ଯେତେବେଳେ ଯୋଉଠି ରହିବ ସେଟା ତା ପ୍ରପର୍ଟି ହେଇଯିବ।
No, Miller. My stand is that.
ଆପଣ ଶୁଣନ୍ତୁ you leave it there. So ଆପଣଙ୍କର पण ଏଇ କଥା ଯୋଉ କହୁଛନ୍ତି ଯେ I may submit ଆପଣ ତ କିଛି ସବମିଟ କରୁନାହାନ୍ତି। So let us not spend time on this. ଆପଣ ନୋଟିସ ନିଅନ୍ତୁ ହେଲା।
While the matter is pending for pending before the executive officer, the annexure 4, the general
executive officer କଣ କରିବ? executive officer କଣ pending ଅଛି? while the matter ମାନେ କଣ? ସର୍ବନାମରେ ସବୁ ଜିନିଷ ହେଇପାରିବ କି? ସେ କେସଟା ସେଠି ପେଣ୍ଡିଂ ଅଛି କଣ ତାର ଅର୍ଥ କିଛି ହବ? କୋଉ କେସ?
ନୋଟିସ ଟୁ ଶୋକଜ ଦେଲେ ଆମେ ଆପିୟର କଲୁ ଫାଇଲ କଲୁ।
ଆଜ୍ଞା ଏଟା ଏଭିକ୍ସନ ନୋଟିସ ରେ ଶୋକଜ ଯୋଉ କହୁଛନ୍ତି ଆପଣଙ୍କ ସେଟା ତାଙ୍କର କ୍ୟାପାସିଟି ଅଛି ଏଭିକ୍ଟ କରିବା ପାଇଁ। ଆପଣଙ୍କର ଯଦି କିଛି କେସ୍ ପେଣ୍ଡିଂ ଅଛି କୋଉ କେସ୍ କୋଉଠି ପେଣ୍ଡିଂ ଅଛି କହିବେ ନା ନାଇଁ? ଯୋଉ ସେଠି ପେଣ୍ଡିଂ ଅଛି କହିବେ କୋଉ କେସ୍? ଏକ୍ଜିକ୍ୟୁଟିଭ ଅଫିସର ପାଖରେ କଣ କେସ୍ ତାଙ୍କର ପାୱାର କଣ ଅଛି?
ସେ ଯୋଉ ନୋଟିସ ଟୁ ଶୋକଜ ଦେଲେ thereafter we appear before the executive officer.
ତାଙ୍କ ପାଖରେ ସେ ଅଥରିଟି ନାହିଁ।
Now my stand is that
like evicting authority ଧରନ୍ତୁ ବିଡିଆର ଏନଫୋର୍ସମେଣ୍ଟ ସ୍କ୍ୱାଡ ଅଛି।
ଆଜ୍ଞା
କରିଛନ୍ତି ସେମାନେ ଧରନ୍ତୁ ଭାଙ୍ଗିବେ। ସେମାନେ ଯିଏ ଏଭିକ୍ସନ ହବ ତାଙ୍କ ପାଖରେ did you hear the other matter where he says that there is a suit pending?
ଆଜ୍ଞା
so ସେମିତି ଯଦି କିଛି ଥିବ ତାହେଲେ କହିବେ ନା ନାଇଁ ଏଭିକ୍ସନ ରେ ଆପଣଙ୍କର କଣ ପ୍ରୋସିଡିଂ ହବ?
my only stand is that
ଆଜ୍ଞା ଅନଥରାଇଜଡ ମାନେ ଅକୁପେସନ ରେ ଆପଣଙ୍କର କଣ ଆର୍ଗ୍ୟୁ କରିବେ କଣ କରିବେ that you have to decide. Let us not spend time. You take notice. The petitioner is before this court. Under threat of eviction. କୋଉ ଖାତାରୁ ଆପଣଙ୍କର କୋଉ ଜାଗାରେ ଅଛନ୍ତି ସେଟା ବି ଲେଖି ନଥିବେ।
Yes, Miller. I have written that. Plot number 20 by
20/224 ଖାତା ନମ୍ବର 108। କେତେ ଏରିଆ କେତେ?
Area Miller 0.05 decimal. I have written that in my schedule.
ମୌଜା ଶ୍ୟାମଚନ୍ଦ୍ରପୁର ତହସିଲ ଡିଷ୍ଟ୍ରିକ୍ଟ ଢେଙ୍କାନାଳ ଏରିଆ ଏକର 0.054 decimals. Appearance section. Mr. J.K. Bala, OP 225 lectures. Out of total area?
Out of total area.
କେତେ କହିଲେ ଏରିଆ 0.14 ନାଇଁ out of total area of
0.14 decimal Miller.
0.14 decimal ଏକର 0.05 4 ତ ନାହିଁ ଆପଣଙ୍କର ପାରାଗ୍ରାଫ 0.05 decimal out of total area of 0.014 decimal. The learned counsel for the petitioner on being asked whether any other proceeding is pending, as the petitioner claims he is entitled for settlement of the land, submits an instruction that he has no such instruction. Stop. Issue notice along with this order. Requisites for issuance of notice to OP number 1 shall be filed by speed post. Requisites for issuance of notice to OP number 1 by speed post with registration and proof of delivery shall be filed within 3 working days. The Learned AG upon advance copy served appears and waives notice on behalf of opposite parties to TO2 file. No further notice being issued. The Learned AG shall obtain instruction in the matter. So, the matter shall be listed, the returnable date be fixed to 1/7/2026. The matter shall be listed for orders in the week commencing 6/7/2026. I 10346 of 2026. Hard Learned Counsel for the petitioner. Issue notice as above. Accept one set of process fee as well as postal requisites. The Learned AG shall obtain instruction from the opposite parties to TO25. As an interim measure, it is directed that status quo as on date regarding
My lord, I am opposing the interim order, my lord, because that is the government land. He is not the owner of that land, my lord.
So if
I am opposing the interim order, my lord.
Yes. The Learned AG opposes the prayer for interim relief. The status quo as on date, Mr. Bala.
My lord, because my lord, he has no land, my lord. He is not the, that is the government land. If this type of people will occupy the government land, development will be held up, my lord, by the government.
But the problem is that it is a removal by 254 municipality.
Yes, Miller.
That notice is a very clear, my lord. Notice says that he has to produce the documents, my lord.
Problem is the kitchen dekhi na. So I am noting your objection. The Learned Counsel for the petitioner.
He has to produce the documents.
Opposes the prayer for objection, though the notice of eviction is issued by the municipality. As an having heard Learned Counsel for the petitioner at the Learned AG for the opposite parties 2 to 5. Status quo as on date regarding nature, character, ownership, and possession of the property shall be maintained by the parties to the writ application till 10/7/2026. Mr. Sahoo, this doesn't help you because neither nature nor character nor ownership is in your favor.
No, I am.
So this is only a breathing space.
No,
you do not have. Maybe I don't know how you have filed the case. I don't know. Nothing is there. No record. Nothing. And
I
this
am not.
order is against you also.
Kindly
So Mr. Bora is objecting. Anyway, second.
Item number 6 also similar.
The municipality eviction na अन्य कौन?
Municipality eviction.
254.
Yes.
Okay. Same order. But the status order is also binding on you, Mr. Sahu, because it is to the purpose. Yes. It is maintained by the parties. Yes.
Yes, Miller. Yes. Grateful, Miller.
7.
Item 7, my lord. Here I am appearing item 7.
Siddhartha Das for the petitioner, Mr.
I am there.
Saurav Kumar ji.
I am there. My sole grievance is, my lord, OP number 5.
1 and 2. 1, 2, 1, 2, 4. Tapare 5, 6 blank. 3, 5, 6 blank. Yes, Mr. Das.
Here, my lord, sole grievance is that the Tata Power WTL OP number 5 and 6. They are constructing a substation for 11 kV, which has been they have shifted from other side of the road, man. Now it's been encroached my land and in some municipality land and PWD road. So it is.
You take notice. Yes. The petitioner is before this court being agreed by the construction of a transformer near existing transformer
near his premises at Gurdwara Chowk, Bargad. They submitted that though there is already one transformer before the house of the near the property of the petitioner, the opposite party number 5 is making construction to situate another transformer which will cause inconvenience to the nearby inhabitants. The village जो transformer लेके 11 kV कर देवे.
11 kV. My objection is there is a grievance redressal forum. He may go and approach them there.
The Lord AGS are referring to the complaint, the demands of the petitioner submits that. ଆପଣ GRF ଯାଉନାହାନ୍ତି?
GRF ଗଲେ ସେଠି he will get the relief.
ନାଇଁ ମୁଁ କହିପାରିବିନି, ମୁଁ ଜାଣିନି, ଆପଣ ଜାଣିଛନ୍ତି, ମୁଁ କହିପାରିବିନି GRF ରେ ଟ୍ରାନ୍ସଫର୍ମର କୋଉଠି ବସିବ ସେ ଡିସାଇଡ୍ କରିବେ କି ନାହିଁ. Because though I continue to be a student of law, I do not know. I have to learn. ଆପଣ confident ଯଦି ଅଛନ୍ତି ମୁଁ ସାର୍ ଲେଖିଦେଲି.
ନାଇଁ. Okay.
Confident ହୁଅନ୍ତୁ, not so confident.
Only I know that.
Don't lock it. If it is locked, Mr. G will be out. Yes. He can go to the GRF. At this stage, there is no instructions from the opposite parties whether the petitioner can have this effective redressal of his grievances regarding placing of transformer to be redressed by the GRF. Stop. Issue notice to the opposite parties. The Lord AG upon advance copies of. Also, I don't know whether they, even power sector, they are not taking permission of the government. George Palle Bosele. Empty entire ring road re khunto pota heichi. Upon dekthile, upon pila bele, khunto board thila. Who to dekhi nathile at least.
Nah.
One appears and waves notice on behalf of opposite parties 1, 2, 4. So notice to OP number 3, 5, and 6 by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 3 working days, Mr. Das.
Yes.
IETA कौन जो टी ट्रांसफर अच्छी से ट्रेस हो
status को आई फिर मैंने otherwise if they will go and construct
status को तो से ट्रांसफर और आने की ट्रक रे थुआई थो से रहिला सिटी ताबनी
से अपन
क्या से ओले जाबनी
अपन नोटिस टा फेरी
अपन ट्रांसफर को स्टेटस को ओडे कोन
हेल्थ कंस्ट्रक्शन
मिस्टर जी जेंती क्वेश्चन जीआरएफ जो है पे अपन ट्रांसफर स्टेटस को ट्रांसफर से उठे देवे से किसे
so that construction may be status
कौन से चालची भगवान को जाना इनी स्टेटस को आ जाने कहना इधर तो खाता प्लॉट किछि नहीं तापरे ए रिजल्ट हबो से आपण को घर रे आरपट कोन रे आपण थोइ देबे
अपन देखा तो रिटर्नेबल डेट
नहीं that is the only consideration since courts are not available perhaps कौन लिख दिया नहीं सेटा आइए लिखिए आइए इशू नोटिस है जब accept one set of process fee as well as postal requisites returnable date टा ऊपर लिखता कि नहीं the returnable date is fixed to ऊपर लिखी दियो ऐड कर दियो तो returnable date shall be fixed to 25/6/2026 the matter shall be listed before the assigned bench in the week commencing on 30/6/2026 stop आइए issue notice the hard-hearted counsel for the petitioner reiterates his submissions as above. Issue notice as above, accepts one set of process fee as well as postal requisites. requisites for issuance, sorry, the learned AG appears on behalf of so and so, so and so. That's it is. In the interim, it is directed that the opposite parties, TPCO DL council, parties 3, 6, 3 and 3, 5 and 6. 5 and 6 shall not take further steps regarding placing the transformer before the, in front of the, near the house of the, near the property of the petitioner.
Right.
Till the next date of hearing.
Okay, great point.
Before you returnability, the parties shall find a response.
Yes.
Upon serving copy thereof by 25/6/2026. ଆପଣ ଏଟା 29 କୁ ଦେଲି କି? ଏଟା କେ 25 ରିଟର୍ନେବଲ 25/6 ତା ଲିଷ୍ଟ କରନ୍ତୁ 6/7 the party shall find a response by ये के 7 कर दो.
Okay.
Yes. Item 8. Mr. Marana, you will appear in transformer matter.
Malat's in 8 I'll be appearing. In 7 Malat's WD I'm not there.
Oh, अच्छा. So Tata Power Western लिखियो. Tata Power Western Odisha distribution company. 8 रे Mr. Chittaranjan Patnaik. Chittaranjan Patnaik for the petitioner.
For this case,
Saroj Kumar Ji, additional government advocate.
No, but this case, I have challenged the illegal installation of transformer over my plot.
You are the for the opinion.
Yes, blood.
Mr. G करो वाले noise टास्क म्यूट कर देते हो. तो बहुत ठीक है जी.
कठिन है.
J double E type करो तो.
Yes. In this case, the petitioner challenged the illegal installation of transformer 11 kV transformer over my plot. Entire plot has been damaged. 11 kV. But entire plot has been damaged. But I have got the photocopy. I could not produce it. But it's the entire land has been damaged.
If your lordship,
this is the only place that should be shifted to some other place because the nearby.
One question, Mr. Patnaik.
My lord.
This shifting is whether it is Mr. Marana, which is the effective.
The honorable division bench of this honorable court has held in one of the case that is the leading case that the district magistrate under the Telegraph Act is the competent authority to hear the grievance and that particular order.
I have already made up. I have already made a representation annexure 3. That annexure 3 I have already made, but nobody is responding. That is the whole problem. But entire land has been damaged.
ଆପଣ ଏଟାକୁ ସେ ଯୋଉ ଟେଲିଗ୍ରାଫ ଆକ୍ଟ ରେ ଟିକେ କରିକି ଠିକ ରେ ଦିଅନ୍ତୁ. ସେକ୍ସନ 17 ଓକେ ପ୍ରୋଭିଜନ ଟା ସବୁବେଳେ ସଭା ଉପରେ ଜାଗା ଆପଣ ସଭା ତଳେ ରଖି ଦେଇଛନ୍ତି.
ଆନିଶା ମୁଁ ଲେଖି ସାର୍ ପ୍ରୋଭିଜନ
ଲାଷ୍ଟ ବର୍ଡ ପାରା
1 ପାରା 12 ଦେଇଛୁ ସାର୍. 17 says that district collector, district magistrate can take the.
So let the collector take a decision on that, Mr.
My lord.
Yes, my lord. Plus specific date so that otherwise.
इधर appear किए करछन्ती?
You are jana my lord. Udit Ranjan.
Additional government advocate.
May I pray one? May I pray one thing, Lord? But sir, lordship direct to take instruction through it matter can be so. Otherwise,
adjudicating authority instruction कौन नेबे? Administrative authority ने तो निया जाए instruction. जी adjudicate करेगा ताकि instruction कौन नेबे? जिसे कहा प्रति bias? मैं कौन? से Mr. Jenna का favor देबे कि Mr. Patnaik का favor देबे? That can be the only instruction. After he decides, then you have a forum or higher forum. I don't know. Telegraph after किसी forum के बाद वाले की read code को कोई भी
only
कि district decisions ऐतिबे की थिबे.
So collector 17 says that. May I read the 17 blood?
appellate authority पाको तापर जिबे ना.
apply authority se nothibo sir.
Malats, if may I assist this honorable court on that aspect, Malats?
Yes.
Malats, if it is decided that the shifting can be done, then the remedy is there. If there is says that the petitioner is to be compensated and the petitioner is not satisfied with the compensation, then your lordship has held that honorable district judge, learned district judge of that area. But if the petitioner still is remedial, then the writ petition.
But neither has given me an offer to
No, that
take
Manas,
the money,
I'm just-
nor has taken the step to.
ଶୁଣନ୍ତୁ ଆଜ୍ଞା ମୁଁ ଯୋଉ ଟିକେ ଜାଣିଛି ସେଟା ପରୀକ୍ଷା କରୁଛି ତ ତେଣୁ ମୁଁ ଦେଖୁଛି ମୁଁ ଟିକେ ଠିକ ଜାଣିଛି ସେଟାକୁ ପଚାରିଲି ଯେ ସେଟା ତାପରେ କଣ ହବ ସେଟା ସେ କହିଲେ ଯେ ଆପଣଙ୍କର ଯଦି କମ୍ପେନସେସନ ହବ ତାହେଲେ ଯିବେ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜଙ୍କ ପାଖକୁ
ଯଦି କରିନାହାନ୍ତି ମତେ ସେ ଅଫର କରିନାହାନ୍ତି
ସେଟା ଇନ ଜେନେରାଲ ପ୍ରପୋଜିସନ ଅଫ ଲ ସାର୍
ଆଜ୍ଞା
এই কেসে কোন এটা তো পেন্ডিং ଅଛି কোହାলা ଆପଣ କହୁଛନ୍ତି ইনস্ট্রাকশন ନବା ପାଇଁ ডিসপোজ অফ ହେଇଯିବ the petitioner is agreed by the erection and positioning of erection of structure and positioning of 11 kV transformer by the power supply utility TPCODL at Bodochada in the district of Jajpur. Apparent Rakiji. Mr. Udit Ranjan Jena, AGA for OP number 1. Mr. Lalit Kumar Maharana, counsel for Lalit Kumar Advocate, OP2. Apre code lekhi.
Transformer power supply utility is level. And what is the district
Jajpur? Over plot of the petitioner, that is plot number 1933, Khata number 759, Mauja, Chandital, district Jajpur. Stop. It is submitted that representation. Apna seta debe na, author lekhi debe.
No, Yes, already given.
The petitioner has approached the appropriate authority, that is Collector Jajpur, under Section 17 of the Indian Telegraph Act, copy of which has been annexed to the writ application marked as Annexure 3, which has been forwarded to the said authority by a speed post. Stop. It is submitted by the Learned Counsel for the petitioner that the said application under Section 17 of the Indian Telegraph Act has been is pending adjudication. The Learned Counsel for the OP number 2 refers to the decision of the division bench of this court in
the executive engineer
Subhani. ଆପଣଙ୍କ ଅଡିଓଟା କଣ ହେଲା?
My lords.
Please repeat again. ଆସିଲାନି ଆପଣଙ୍କ ଭଏସଟା.
Malats, it's the executive engineer electrical versus Srimati Sobhagini Patra.
Yes. Citation?
Malats, WPC number 21035 of 2021.
Correct. And submits that the division bench of this court has authoritatively dealt with the said the issue regarding placing of transformer and the allied constructions. And the authority under the Section 17 of the Telegraphs Act is the appropriate authority. Stop. In view of the above, in considered view of this court, no purpose would be served in keeping the matter pending before this court when the statutory authority is in season of the matter. Stop. Accordingly, it is directed the petitioner shall approach the petitioner shall approach the authority, that is collector and district magistrate, along with certified copy of this order. The authorities shall do well to consider the application. जो लिखिले नहीं कि approach the authority along with certified copy of this order as well as copy of the representation dated 5/5/26 annexed to the writ application marked as Annexure 3. The authorities shall do well to dispose of the application after giving opportunity of hearing to all the concerned parties, including the petitioner.
Yes. The writ petition is disposed of accordingly. Yes.
Let's
Plus
with your
specific
lordship
time, plus specific period may be fixed, my lord. Otherwise, specific time, my lord.
ଯେତେ ଡେରି ହବ ଭଲ ଆପଣଙ୍କ ଟ୍ରାନ୍ସଫର୍ମର ତାହେଲେ ବସିଯିବ
ନାଇଁ ସାର୍ ମୋ ଜାଗାଟା ଡ୍ୟାମେଜ
ଆପଣ
ହେଇଗଲାଣି
କୋଉଥିରେ ଟାଇମ ନେବେ ସ୍ପେସିଫିକ ପିରିୟଡ କୋଉଥିରେ ନେବେନି ଯଦି ଆପଣ ଦି ଚାରି ଥର ଆଡଜଷ୍ଟମେଣ୍ଟ ଦିଅନ୍ତୁ ଟ୍ରାନ୍ସଫର୍ମର ବସିବାଟା ଘୁଞ୍ଚିଯିବ କାରଣ ମିଷ୍ଟର ମହାରଣା ମଧ୍ୟ କହିଲେଣି କମ୍ପେନସେସନ ଦେଇକି ଆପଣ ବସେଇ ପାରିବେ
ସାର୍ କମ୍ପେନ୍ ଦେଇପାରିବେ କମ୍ପେନସେସନ ତ ସାର୍ ସ୍ପେସିଫିକ
some part be should be left to the authority
ନାଇଁ ଅଦରୱାଇଜ ସାର୍ ଯଦି ସାର୍ ସ୍ପେସିଫିକ ଡେଟ୍ ନହେଲେ ସେ ମ୍ୟାଟର ୱିଲ୍ ବି ପେଣ୍ଡିଂ ଦେୟାର
ଆପଣ ସେଟା କଣ କି ଏଟା ରେଭିକ୍ସନ ର ଏଟା ଅପୋଜିଟ ଏଟା ସିଚୁଏସନ ବୁଝିପାରୁଛନ୍ତି
ନାଇଁ ସାର୍ ଠିକ ସେ otherwise matter will be pending there I will be nowhere but neither I can file any content petition everything will be time fix नदेले से time fix नथिले content petition file हेई परिबनी
so se kon कहउछन सुनि दियो just yes Mr. Marana
since I don't have the copy, while your lordship was dictating the plot of the land, your lordship dictated it is in Jajpur. My lord, Jajpur does not come within the jurisdiction of TP CODL. It is TP Northern Northern NODL.
No.
If TP NODL is not a party,
so that is my understanding also.
Jajpur ta North Division re aschi Central re asibani.
Amendment karo do aଜ୍ଞା तो पट्टायक
ଆଜ୍ଞା sir
all efforts गला ମୁଁ ବି ସାଇଟେସନ ହେରିକା ଦେଲି କିଛି ଲାଭ ହେଲାନି because Jajpur I am sure that that it is north
I thought about
ଆପଣ COD ଟା central
I thought about objecting saying it during the dictation but I thought it would be
no ଆପଣଙ୍କର ପାର୍ଟି ଠିକ ହେଇଛନ୍ତି ପାର୍ଟି ଭୁଲ ଭାଲ ହେଇଗଲି ଆପଣ appear କରୁଛନ୍ତି CODL ପାଇଁ ଆପଣ NODL ପାଇଁ appear କରୁଛନ୍ତି ନା କରୁନାହାନ୍ତି
କରି ପାରିବି ମୁଁ କରି ପାରିବି
ତାହେଲେ oral create କଲେ ହବ
ଆଜ୍ଞା ହେଇ ପାରିବ
ଆଗ opening sentence ଲେଖନ୍ତୁ The Learned Counsel for the petitioner submits that inadvertent typographical error has crept into the writ petition as the opposite party authority has been mentioned as Tata Power जो short form लिखले ये problem होगा सब Tata Power Central Odisha Distribution Limited whereas it should be Tata Power North Odisha Distribution Limited at Jajpur. It is submitted that the petitioner, the Learned Counsel may be allowed to carry out the necessary correction in the cause title. In the court itself, the prayer is allowed. The petitioner shall carry out the necessary correction. ଆପଣ କେମିତି କାଉଣ୍ଟର ସେଣ୍ଡ କରିବେ ଆପଣ ତ ରିମୋଟ ଜାଗାରେ ରହିବେ ସେ ବି ହେଇପାରିବନି ସେ ସେଠିକେ ଅଛି ମିଷ୍ଟର ପଟ୍ଟନାୟକ ସେଟା ଇଟ୍ ଇଜ ଅଣ୍ଡରଷ୍ଟୁଡ୍ ଯେ ସେଠି ମାନେ ଆକ୍ଚୁଆଲି ବ୍ରିଫ ନାହିଁ କି କୋର୍ଟ ମାଷ୍ଟର ନାହାନ୍ତି
ନାଇଁ ସାର୍ ମୁଁ
ତ ଆପଣ କାଲି ଟିକେ କରିଦେବେ
ସାର୍ ଅଫିସରେ କରେକ୍ସନ କରିଦେବି ସାର୍
ଅଫିସରେ କଲା ବେଳକୁ ରାତି 10ଟା ହେଇଯିବ ମତେ ଆଜି ହେଲାଣି ମତେ ଲାଗୁଛି 10ଟା ବାଜିବ
ଆଜ୍ଞା
ସୋ ଆପଣ କାରଣ ଏଠି ସବୁ କାମ ସାରିଲେ ତାପରେ ଯିବେ କାମ ନ ସାରି ତ ଯାଇପାରିବେନି ଆପଣ ଟିକେ କାଲି କଣ୍ଟାକ୍ଟ କରିକି ଆସିବେ ଆଉ
ହଁ ସାର୍ କାଲି ସାର୍ ଟୁମୋରୋ ଆଇଲ୍ କମ୍
କାଲି କେତେବେଳେ କାଲି 11ଟା କପି ଅଫ ଦ ହେଲା correction which shall bear the initials of the Learned Counsel for the petitioner to be countersigned by the court master. ଆପଣ ସେଟା ଆଜି କଲେ ଆଉ ଯେହେତୁ ଏ ଯୋଉ ଫିଜିକାଲ ପାର୍ଟଟା ହେଇପାରିବନି କାରଣ ଏଇ ଜିନିଷଟା ରିମୋଟ କରିହବନି ଭିସିରେ ସୋ ଆଜି କଲେ ବୋଲି ଅର୍ଡର ହେଇଗଲା କପି ଅଫ ଦ ରିଟ୍ ଆପ୍ଲିକେସନ ୱିଥ annexure shall be served on Mr. L.K. Maharana, Learned Counsel, who usually appears for TPNODL. His name shall be reflected in the cause list as well as the case brief. But a copy aji diyantu.
ଆଜ୍ଞା ମୁଁ ଅଛି
ନା କାଲି ଦେବେ
କାଲି
The copy of the application shall be served by tomorrow.
Can I give submit to Monday ଦେଇପାରିବି
ଆପଣ ତ କାଲି କରେକ୍ସନ ନ କଲେ ଏଟା ଅର୍ଡର ହେଇପାରିବନି ଯେ
ସେଇ
ଆପଣ ଯଦି କରେକ୍ସନ କରିପାରିବେନି ଏଟା ସେ ରହିଲା ଏଟା ତାହେଲେ ନହେଲେ ଆପଣ ଯଦି ହେଇପାରିବନି ଭାବୁଛନ୍ତି ତାହେଲେ ଛାଡି ଦିଅନ୍ତୁ ସିମ୍ପଲି ଆଡଜର୍ନ
सर मु करेक्शन कर देबी आज करेक्शन कर देबी ऑफिस कर देबी
ऑफिस रे कोड फाइल पाइबे आपण
सर डायरेक्ट
ऑफिस रे कोड फाइल पाइबे
ऑफिस रे फाइल पड़े ऑफिस
फाइलटा कस्टडी रे अछि कोर्ट रे ना कोर्ट मास्टर कस्टडी सेटा कोन लिस्ट कि रजिस्टर अछि आपण पाइबे file once it is listed it goes out of the registry to the list then to the court से कथा आपण कहउतली काली कर दियंतु एवं मिस्टर महाराणा कॉपी दे दियंतु हला
आज्ञा हम
हला काली सुधा दियंतु
आज्ञा
सर वे कॉपी
आज्ञा can I take his number telephone number
Malas I'll contact Malas I'll contact I'll
give you.
I have already put it in the chat box Malas
yes.
But sorry yes
chat box se dekha jaytu seti
again
yes
item 9
and this repetition arises
for the petitioner yes
this
Mr. Mr. M.R. Mahanti additional government advocate
my lord
Mr. M.R. Mahanti additional government advocate for the opposite parties
1 to 3
1 2 and 3 yes yes please
my lord this repetition arises out of proceeding under the Society Registration Act my lord
yes
the society was registered way back in 1947-48
yes
and the members were Rama Devi, Gopabandhu Chaudhary and others my lord
yes
they have registered this society it is still functioning till date while the matter stood thus an amendment was brought to the Society Registration Act in 2021
yes.
in which for the first time renewal clause was introduced my lord the
yes.
society which were there they have to register they have to renew the society within 5 years my lord and the last date
so according to you renewal is introduced in the year
2021 my lord section 3b that is a Odisha amendment my lord
yes
therefore my lord the cut-off date for the old society was 13/5/2026
yes
when the body of this present petitioner society that was in online tried to file his renewal application at
yes.
that time he came to know that opposite party number 4 to 14 they have filed an application that the society is a defunct society and they should be recognized as the body of the society
okay.
the registered societies the opposite party number 2
yes.
without any inquiry without mail or anything recognize them as the body of the society on 8/4/2016 that was not within the knowledge of the petitioner
okay.
while he was filing his application for renewal it was going to that was not accepted as already the society has been registered in 8/4/2026
yes
his application was not accepted after collecting all the documents this petition was filed now the difficulty is my lord once the 4 to 10 4 to 14 have been recognized as the body of the society the entire my lord, system have been defunct my lord. That is bank transaction you have to pay the salary to our staff the entire thing
but it has come to standstill defunct since 2014
no 2008/4/26
अच्छा ସେମାନେ ଆସିଲେ 8/4/26 ରେ
ସେଟା ତାଙ୍କର ରେଜିଷ୍ଟ୍ରେସନ ହେଲା
अच्छा okay
when my lord I have filed an application for renewal as per the amendment act
I mean they have come into picture not from 14 because I heard it 14 26
okay. 8/4/26
so the order implemented is the new is there any order is there any order derecognizing or cancelling your membership
ସେମାନେ କହିଲେ defunct ବୋଲି Without any inquiry, without doing anything, my lord, the society is functioning since 1947-48.
So that order has been annexed. Defunct order se कहले.
हम पाखरे आगे खाली तंग registration रो येटा अछि और हम पाखरे किछि नाही.
Then how to I mean so that or how do you know that it has been said or it is your instruction?
Khali instruction.
Hard learned counsel for the petitioner. The petitioner is the petitioner before this court is society represented through its secretary. Challenging the order dated 8/4/2026, issuing certificate of acknowledgement of amendment to the society, namely Utkala Khadi Mandala, basing upon its original registration number 10 of 1947-48 in favor of opposite party number 4 to 14. It is submitted that before passing such order dated 8/4/2026, the opposite party authority, he is the Inspector General or Additional Registrar.
That is
IGR order, IGR na DSR.
IGR order. Annex 6, my lord, your lordship, you kindly turn to.
IGR.
The opposite party number 2, IGR, has not followed any procedure as prescribed and contemplated under the provisions of Societies Registration Act, 1860. Giving a brief background of the facts leading to such impasse, it is submitted by the learned counsel for the petitioner that the society is registered since 1947-48 by the famous personalities who were part of the struggle for independence, as well as at the forefront of the freedom movement in Odisha. Since then, the society is functioning. In the year 2021, a Odisha amendment was brought to the Societies Registration Act by introducing section 3(b), by which renewal has been mandated within 5 years of coming into force of such amendment, which would result in the amendment date by which would result in the amendment to be made by 13/5/2026. Stop. The present secretary when moved the authority for amendment of the registration in terms of the
renewal of the registration.
For renewal of the registration. Amendment renewal of the registration. It came to the notice that opposite parties 4 and 2/14 have approached the authority and has got a registration in their name on 8/4/2026. By stating that the society of 1947-48 has become defunct and they are the functionaries of the said society. Stop. So it is submitted, issue notice along with this order. The learned AG upon advance copy served appears and gives notice on behalf of opposite parties 1, 2 and 3. Learned AG shall obtain instruction and file counter by
4 weeks.
counter by 3/7/2024 upon serving copy thereof on the learned counsel for the petitioner. Notice be issued to the opposite parties 4/2/14 by speed post with registration and proof of delivery. Making the returnable date. It upon Quebec counter call. Making the returnable date. Fixing returnable date to 25/6/2024. Which is 20 दिन होची ना आगे अधिक दिन में तो. Fixing the returnable date to 3/7/2024. The matter shall be listed in the week commencing 20/7/2024. IA 10499 of 2026. Hard ordered counsel for the petitioner. She reiterates her submissions as noted above. In the interim, it is directed that the parties to the litigation shall not proceed with shall not take any further steps towards to the re-registration dated 8/4/2024 till the next date of hearing.
Operation of the order may kindly be stayed, my lord.
No operation, because you are saying that there will be because there are parties who may be receiving salary, so many things.
सेटा आमे दबु तांकर या केही नांती आमो सोसाइटी रो
आपनकर operation of which annexer?
Annexer 6 my lord.
As an interim measure, it is directed there shall be interim stay of operation of the. But इतने operation कौन होगा? Rather order that they shall not take any steps.
Order का रही है annexer 6 रे. We will continue, my lord.
नहीं, सेटा तो आपनकर challenge है. In fact, that I was trying to understand whether you have challenged that, because you are saying you do not have anything. Maybe you will be challenging that you have not received any communication.
No.
Your case is before cancellation. You have not, so you are not aware of any cancellation. That is your case.
My lord.
So that could have been because you may challenge that.
नहीं এটা তো challenge
कौन order लिखी? As an interim measure, it is directed to. नहीं सीधा को आपण जदि आपण कैंसिलेशन स्टे होता ताले किछ लाभ होता. Rather no steps no further action. No further action.
नहीं अगर cancellation
kindly listen to this. এটা শুনନ୍ତୁ. No further action pursuant to annexer 6.
नहीं no further action हेले operation order टा stay हेले हमर चलिबो.
देखो there shall be interim stay of operation of annexer 6. Certificate of acknowledgement of amendment of society. Dated
8/4/24.
8/4/24 till the next date of hearing. The matter shall be the returnable date as well the next date of listing shall be as indicated.
Item 10.
Please, my lord. My lord, here, a poor man.
Item 10, I am for the state opposite party.
Yes. A poor person who is also having a BPL card holder, possessing a land more than 50 years, and also converted the same into a inhabitable land. And the Tahsildar Jamankera has issued 2 letters directing for demolition of that house.
So what is the age of the petitioner? Poor petitioner. What is his age?
Date.
Age of the petitioner.
Sir, age. Yes. Age of the petitioner is 46.
So सेटा ठीक आपण पोजीशन टे कमे थाते ना.
More than because from the time of the father the land has he is also inherited. Sir, he is inherited at the same property after the death of his father.
आपण गवर्नमेंट लैंड को पर्सनल प्रॉपर्टी है.
Sir,
गवर्नमेंट लैंड ना जॉइंट फैमिली प्रॉपर्टी सेटा.
No. That is individually in the name of the father.
Oh,
son inherited that property.
So they are hereditary encroachers, like it.
ଆପଣ ଯେତେବେଳେ କହିଲା ବେଳେ ଆପଣ ଭାବପ୍ରବଣ ହେଇ କହୁଛନ୍ତି ଦେଖୁ ବି ନାହାନ୍ତି
without any objection he is also possessing the land.
ଆଜ୍ଞା ସେ ତ ଜନ୍ମ ହେଇ ନଥିଲେ ଆପଣ ଅବଜେକ୍ସନ ହବ obviously there will be no objection ଯିଏ ଜନ୍ମ ହବ 4 ବର୍ଷ ଥିଲା ତାପରେ ସେ ଚାଲି ବଡ ହେଇ 18 ବର୍ଷ ହେଇ ତାକୁ ଗୋଟେ 22 ବର୍ଷ ତାଙ୍କୁ 4 + 18 22 ବର୍ଷ
ସାର୍
ତାକୁ ଯଦି 18 ବର୍ଷ ଭିତରେ ଏନକ୍ରୋଚ କରିବେ ନା ଆପଣଙ୍କର ଏଇ ଯୋଉ ଆନିମସ୍ ଆଉ କର୍ପସ୍ ପଜେସନର ଥିଓରି ଆପଣ ମାଇନର କୁ ଆଟ୍ରିବ୍ୟୁଟ କରିପାରିବେ is the minor capable of possessing encroaching a government land?
Minor capacity.
Mr. Ponda?
Minor capacity represented by the legal guardian. Represented by the legal guardian.
ଭାବି ଚିନ୍ତି ଏନକ୍ରୋଚ କରିବେ ନା ଆଉ
sir twice sir he has also issued a notice. One is sir
ଆପଣଙ୍କର ସେଟଲମେଣ୍ଟ ପାଇଁ ଆପ୍ଲିକେସନ ଦେଖାନ୍ତୁ
sir
ଆପଣ ଯୋଉ ମେଜର ହେଲା ପରେ ସେଟଲମେଣ୍ଟ ଆପ୍ଲିକେସନ ଦେଲେ କୋଉ ପ୍ରୋଭିଜନ OPLS OGLS OPLE ସେଟା ଦିଅନ୍ତୁ
OPLE he has also issued the notice under OPLE.
ଆରେ ଆପଣଙ୍କ ଆପ୍ଲିକେସନ କୋଉଥିରେ ଦେଇଛନ୍ତି ସେଟଲମେଣ୍ଟ ପାଇଁ
sir ଆମର କୋଉଥିରେ
ସେଟା ବାପା କରିଥିଲେ ଆପଣ ପକେଇଦେଲେ ନା କଣ
ନା because as OPLE proceeding is also initiated I have challenged that OPLE proceeding the OGS
ଆପଣ ଯଦି ସେଟଲମେଣ୍ଟ ପାଇଁ ଆପଣ ଯଦି ସେଟଲମେଣ୍ଟ ଚାହୁଁଛନ୍ତି ସେଟା you have to apply for that.
OPLE proceeding also the Tahsildar has got power to settle the land in the name of the
power টা without ତାହେଲେ ତ ଆମେ ସମସ୍ତଙ୍କର ଗୋଟେ ଗୋଟେ ହେଇଯିବ
ନା there is a decision of this
ଦେବେ ଆପଣ ଆପ୍ଲିକେସନ ଦେଲେ ହବ
sir
କାଇଁ ଆପ୍ଲିକେସନ ତ ନାହିଁ କିଛି ନାହିଁ ଏଥିରେ
No, I will prefer an appeal, sir. Sir, I will prefer an appeal before the appellate authority. Till then, sir, my lord, I may be protected. Stay of that order, the eviction order. I do prefer an appeal before the sub-collector under section 12, sir.
So ଆପଣ appeal file କରନ୍ତୁ 15 ଦିନରେ ହେଲା
sir
along with an application for interim prayer if any.
No, he will not pass any. Only my lord to give me a protection that I have to prefer an appeal within a stipulated time, either 1 month or 2 months.
Stipulated time 15 ଦିନରେ ଆପଣ ଦିଅନ୍ତୁ.
Within 15 days also. Within 15 days I can let the I will direct to prefer an appeal within 15 days. Till then also no course action. Stay of that notice.
The status quo. ମୁଁ stay କରୁ ନାହିଁ status quo order ହେଇପାରିବ.
Instead of status, stay could be better, I think. Sir, twice he has also issued the notice. Twice he has confirmed my possession. Twice. One is a sir.
ଆଜ୍ଞା ଯିଏ ଆଜ୍ଞା ଜନ୍ମ ପୂର୍ବରୁ ଯାହାକୁ ନୋଟିସ ଦିଆଯାଉଛି ସେ ଜନ୍ମ 4 ବର୍ଷ ଆଗରୁ ସେ 18 ବର୍ଷ ପରେ କେତେ ଥର ପାଇବେ ତାର କିଛି ଠିକ ନାହିଁ.
Appeal filing of the appeal.
Yes. Mr. Niranjan Panda for the petitioner. Mr. Gautam Tripathi, additional government advocate for the opposite parties. Are you serious in submitting that your father was encroacher?
Yes. Sir.
लिखिଛନ୍ତି ରିଟ୍ application लिखिଛନ୍ତି
आगे लिखी sir.
The petitioners are hereditary encroachers.
Not hereditary, sir. Sir.
ସେଥିରେ କଣ୍ଟ୍ରୋଭର୍ସି ହେବ ଆପଣଙ୍କର ସେ ଫେରେ ଦେଖ ଆପଣ ଫାଦର ବି ମାଇନର ଥିବେ ସେତେବେଳେ
para 6 ରେ ଲେଖିଛି
ସେତେବେଳେ ବି ଆପଣ ଫାଦର ମାଇନର ଥିବେ
family now struggling with poverty the Tahsildar Jaman ke directed to
ଆପଣ ଯୋଉ 50 ବର୍ଷ ହେଲା ଆପଣ ରେକର୍ଡିଂ ହେଇଗଲା ନା ବର୍ତ୍ତମାନ ପ୍ରୋବ୍ଲେମ କଣ କି ଏଟା ସବୁ ରେକର୍ଡିଂ ହେଇଯାଉଛି ୟୁଟ୍ୟୁବ ରେ 50 ବର୍ଷ ହେଲା ଆପଣ ଏନକ୍ରୋଚ କଲେଣି 40 ବର୍ଷ ଆପଣଙ୍କୁ ସେତେବେଳେ ଆପଣଙ୍କ ଜନ୍ମ ହେଇଥିଲେ କି ନାହିଁ ଜଣା ନାହିଁ
ମୋ ବାପା କରିଥିଲା ସାର୍ ମୋ ବାପା କରିଥିଲା I am inherit only because the encroachment was also made by my father.
The petitioner before this court is agreed by the notice dated 15/5/2026 issued by the
sir another notice 2/6/2026 ର ଗୋଟେ ଦିଟା କରିଛି
15/5/2026
and 2/6/2026
and 2/6/2026
yes
directing the petitioner to remove the encroachment from government land. Khata number
159
plot number 238 acres 0.09 Moja Kotanga Pani. Dekhidebe page 10 there. The said encroachment case was the encroachment case being 4-161/2024 and heard on 22/11/2024. It is submitted by the Lord Counsel for the petitioners that the petitioner and his four brothers are generations of encroachers. And he is entitled for settlement of the land. The petitioner shall refer appeal under section 12 of the OPLE Act before the sub-collector,
Sub-collector,
appropriate authority.
Sir, Kuchinda. Kuchinda.
OP3. They submitted that if the petitioner is evicted before preferring the appeal, his cause shall be frustrated. Stop. The Lord DG in response submits that any appeal that would be filed by the petitioner, some shall be considered in accordance with law by the appropriate authority. Stop. In view of the limited nature of grievance, it is submitted by the petitioner, the Lord Counsel for the petitioner, the writ application may be disposed of, granting breathing time to the petitioner to move in appeal. Stop. Para. Having heard the Lord Counsel for the petitioner and the Lord DG, it is directed that the petitioner shall approach the appellate authority by filing appeal
6 weeks
under the provisions of law by 25/6/2026 along with an application,
sir,
seeking interim prayer as would be. The authority shall do well to consider the prayer of the petitioner in accordance with law. Stop. କେବେ ଦେଲେ 25 ଯାଏ ନା 25/6
Sir, instead of 25 3/7 टिक कर दो 3/7
नहीं 25/6 थाउ
आगे
सो ता भीतर आवड दी जनरेशन আছে সে আবার কেস হবে কিছু অসুবিধা নেই সে আপনাদের it is directed that status quo as on date regarding nature, character, ownership, possession of the subject property indicated above shall be maintained by the parties till
this for the appeal
17/7/2026
till filing of the appeal,
which shall abide by the orders that would be passed
by the
appellate authority. The abide by hobo now what change kar daba.
Oblige, sir. Oblige. Much oblige.
Yes.
Good.
Yes, next. 11. Mr. Sumit Kumar Manti for the petitioner.
My lords.
The dispensing code as 35 copy.
35 copy, my lords. Going to short time, we could not obtain the certified copy, my lords.
But सेटा तो condonable defect नो ना अपन बार कौन सेटा authenticated copy ना को फाइल देई छथि
एटा कॉपी टा आज्ञा आउ जने बाहर करथिले वन ऑफ द अपोजिट पार्टी ताको ठारू हमें आनी कि फाइल करछु जेरॉक्स करी एंड आई विल फाइल इट
इतने urgency कोन अछि Mr. Mahanti, as you know, I mean, you know it, this cannot be condoned. Non-filing of certified copy cannot be condoned by the court unless it is available in another writ petition. ताहले ठीक अछि.
We have already applied, my lords. It may be dispensed with for the time being.
अच्छा सेटा entertain केमति हबो?
My lords,
without looking at the आपनकर जदी prayer हेई परिबो जे हां एटा अछि बोली. I can extend the time for filing.
Yes, my lords.
High Court record रे तो नाही सेटा writ petition रे कोठी नाही अन्य writ petition रे.
नहीं. Can we have applied We have applied for the copy. And
what is the urgency? Urgency kon kuntu?
Urgency again. Urgency is that the RP was filed by the OP number 5 in the present writ petition, impleading the recorded tenants who are dead since long. And the present petitioner is one of the legal heir of the recorded tenant.
ଶୁଣନ୍ତୁ ଆପଣ ତାହେଲେ ଆଣନ୍ତୁ ସେଟା କରିହବନି
ଆଜ୍ଞା
ଆପଣଙ୍କର ଆରପି କେସ୍ ରେ ଅର୍ଡର ହେଇଛି ତ ଆରପି କେସ୍ ଅର୍ଡର ଟା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
ଆରପି କେସ୍ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରୁଛି କିନ୍ତୁ ଏଇନେ କଣ ହେଇଛି ନା ଆଫ୍ଟର ଦି
ଆରପି କେସ୍ ଅର୍ଡର ଟା ରିଭାଇଜେବଲ ନୁହଁ
ଆରପି କେସ୍ ଅର୍ଡର ରିଭାଇଜେବଲ ନୁହଁ ବିକଜ ଇଟ୍ ଇଟସେଲ୍ଫ ଇଜ ଏ ରିଭିଜନ
ଆଉ ଆପଣଙ୍କର
ଅଣ୍ଡର ସେକ୍ସନ 15B of the OSS Act
ତା अगेंस्ट अपील की କିଛି ଅନ୍ୟ କିଛି ପ୍ରୋଭିଜନ ନାହିଁ
no
somoto revision ki nahi read is the only remedy
is read. And in the meantime, what has happened, pursuant to the order of the learned commissioner, so consultation and settlement, the miscase has been initiated by the Tahsildar Cuttack. And that is my...
Anantu, liberty to mention. Mu apanako prayer allow kar douchi hela. Aye prayer allow kar douchi apana seda ani ki diontu.
Mu debi again 2 weeks bhitere 2 weeks may be granted. In the meantime, I'll file it.
2 weeks kai kete nauchandi.
Let notice go to the opposite parties.
Na setare condon kariki notice kari hobani.
Kaina the time nahi kana Tahsildar will conclude the proceeding.
Eta actually it's a defective petition. ଆପଣଙ୍କର relying on any photocopy the high court cannot take up এটা high court rules ରେ ହିଁ ନାହିଁ ଆପଣ ଯଦି ଗୋଟେ authenticated copy ସେବେ ମୁଁ ପଚାରିଲି ବଟ୍ ଆପଣ କହୁଛନ୍ତି ଆପଣ ପାର୍ଟି ନଥିଲେ most likely ଆପଣଙ୍କ ପାଖରେ କପି ନାହିଁ
କପି ନାହିଁ
ଆଉ ଜଣେ ଗୋଟେ ଯାହା ଆଣିଛନ୍ତି ସେଟାକୁ ଆପଣ ଜଲ୍ଦି କରନ୍ତୁ ମୁଁ 2 weeks ଟାଇମ ଦଉଛି ଲିବର୍ଟି ଦଉଛି 2 weeks ଟାଇମ ଦେଇଦେବି ବଟ୍ liberty to mention they do.
By that time, the Tahsildar will conclude the miscase, my lords. Pursuant to the remand order, he will conclude. My predicament is
without issuing notice केमती हबो केबे Tahsildar को order रे से करछंती
Tahsildar
आपण सेटा गले चैलेंज करंतु ता सेटा चैलेंज करू ना ता आ संगरे
मेन ऑर्डर टा चैलेंज न होले सेटा केम चैलेंज हबो मेन ऑर्डर
अरे आ संगरे और आज कोन हेची असुविधा आपणकर आरपी ऑर्डर संगरे Tahsildar ऑर्डर भी चैलेंज करंतु
only
main submain जोटा भी करंतु दीड जग एकाठी करंतु IA number the petition writ application has been filed without filing the certified copy of the order impugned that is order dated 3/2/2026 passed in RP case number 450 of 2023 एटा पॉजिटिव ऑफ टाइम केमती हबो आपनकर 4 मास होइली
4 मास माने हम नॉलेज जेबे 12/5 रे आसिला जेतले गला तहसील रु आरआई गले
It is submitted that the petitioners were not parties in the RP case number 450 of 2023. They were not aware, hence could not obtain the certified copy in time. The petitioners are granted further 2 weeks time to file the further 2 weeks time to file the certified copy. If the copy is obtained earlier than 2 weeks, the same shall be filed and shall be accepted by the registry. Stop. Liberty to mention before the vacation bench. Yes.
Obligation. But I was not a party, my lords. Neither any notice was this.
ये जो आरपी केस ना गोटे दिन रे सर्टिफाइड कॉपी बाहरी
नहीं बाहरी हो गया किंतु हम नॉलेज आसिला जेबे
एते कैजुअल ले केमती होबो हाउ द कोर्ट विल एंटरटेन any document as and that is challenged. You must understand it has a consequence. And do you know that suppose I pass a order, it will be challenged in the higher forum. What will be the first ground taken by you? Suppose you are the counsel.
Well, the thing is
the order has been passed in
defective
application.
The order has been passed without
defective. The order has been passed in a defective writ application where the certified copy was not there. That touches the root of the matter. You must understand what you should do. That should be in the interest of the party.
I understand, my lords. I understand.
जी आपन को behind your back what order नहीं पड़छन सेटा चैलेंज कर परिबेन. Yes. Next.
Item 13, I am appearing for this state, my lords.
Mr. Dole is tired actually. For the last 2 weeks, he is in vacation mode. He is tired. He is now unable to speak. Or the audio is not working perhaps.
Lordship, in fact, Lordship, item
Sukanta Kumar Dolai for the petitioner, Mr. Umesh Chandra Behura for the opposite parties.
My lord,
One and 4.
My lord.
Have you served anyone for the corporation, Mr. Dolai?
No, in fact, Lordship, they are from parties, but Lordship, notice will go to them, Lordship. But I have not served them copies, but the panel of lawyers, they are, Lordship, that's why we are.
Take notice. Yes, Mr. Dolai.
Lordship, Lordship, can you see 13 and 14 both are similar, Lordship, both the matters, Lordship. Lordship, here, Lordship, kindly see it is a paddy procurement procedure, and we are working in this procedure since 2019, Lordship. And we are the highest, Lordship, paddy procurers, Lordship, and having, Lordship, excellent certificates.
No facility. Having no facility, no equipment, no storage.
No, Lordship, that is very wrong concept, Lordship. So, Lordship, kindly say, for a moment, Lordship, can straight away come to Lordship, their own relying letter, Lordship, kindly annexure 4, page 40. The tested case is page 40, Lordship, annexure 4.
Yes.
On 18, 12, and 25, the state government issued a letter, Lordship. If the women's self-help group is having no infrastructure, they will be immediately, Lordship, eliminated from the Lordship procedure, Lordship.
Yes.
And actually it has been tested. It had been tested, Lordship. We are declared qualified, and because we are working since 2019, still we are working, Lordship. It is a now procurement of Rabi Fasal, Lordship. Procurement of, Lordship, now it is Rabi, Lordship. So now, Lordship, state Lordship coming annexure 2.
Yes.
Because of annexure 1, Lordship, can the date on 18/5/2025, the same collector, Lordship.
Yes.
Lordship being the qualified, and Lordship kindly come to next page, page 36.
Yes.
Page 36, Lordship. The Lordship kindly see they have allotted the Lordship the purchasing officer. They have allotted nodal officer. They also allowed me to operate by Lordship completion of training, and they allowed me for farmer registration. And these two society, Lordship, these women self groups is the highest farmer registers, Lordship. Highest numbers of farmers have registered in our self-help groups. And Lordship, the Lordship, the petitioner name finds that serial number 20 in page 37. Page 37, Lordship, serial number 20. On 18, Lordship, the particular same collector selected in consonance with the entire procedure. Then Lordship, Lordship, annexure 3. Just next day, Lordship, without any reasonable opposition hearing, when the highest numbers of farmers have registered with us, entire infrastructure is ready, and we are going to procure, Lordship. Here pass this order, and Lordship, we peculiarly relying upon the order 18, 12, and 25, which has already been tested during Lordship Kharif, and we have been qualified, and more especially, we have been qualified since 2019, having all infrastructure, Lordship. Just for example, we have annexed some of the document, Lordship, kind of annexure 5 series. We have proper go down, we have proper office room, we have proper infrastructure, and also interestingly, Lordship, now without any reasonable opposition hearing, without giving us a show cause, on 18 they selected me.
Have you approached the authority with all these details?
Lordship, there is no scope, Lordship. On 18 they passed.
So you will approach the authority, or you will take notice?
Lordship, your Lordship kindly said that the Lordship kindly, this order has to go, Lordship kindly quash this order. You take a fresh decision.
No, without hearing them, I cannot quash.
Then Lordship kindly stay and notice them, Lordship.
No, stay cannot be granted because it is a petty procurement.
Petty procurement, Lordship, we are Lordship working
once you cannot collect paddy, and I said it is state.
No, Lord. Since 2019 you are procuring, Lordship kindly say annexure 2.
Let it come in the reopening. So if you do not want to approach authority, so then they have to take notice.
No, Lordship, if Lordship sending me authority, then this order should be not given.
No, not that, because you have not brought on record. I was asking, that is how I was asking you. Have you brought on record anything showing that you have all these facilities? That I wanted to.
Lordship, all these facilities are annexure 2.
No, let it not.
Admission. Annexure 2, their admission, Lordship.
Annexure 5. Annexure 5.
Annexure 2, Lordship. No, Annexure 2, Lordship, their own admission. Annexure 2, they are selected in 19.
No. Annexure, kindly read Annexure 2. It does not refer to any facility.
Yes, that refers to facility, Lordship. Lordship, may I read, Lordship?
Kindly read.
Lordship, kindly. in pursuant to the letter number such and such, this is the procurement letter, Lordship, of the state government. The officials as recommended by the BDOs and EOs are hereby appointed as Mandi nodal officers for Rabi procurement. The names, designation, contact number, petition numbers, Mandi is attached to Annexure 1. The Mandi nodal officers are remain present all along in the assignment PPs on procurement days to resolve the issues coming during petty procurement. Means
so you have read it correctly. There is nothing there. Can you read now Annexure 4?
Lordship, Annexure 4.
Yes.
Yes, Lordship. Annexure 4.
With reference to the subject cited above, read them.
Lordship. It is, Lordship, during the during Kharif Fasal.
Whatever. So
it is during Kharif procurement, Lordship.
So if you read that Annexure 4, then you will get the point.
Lordship.
Just read it.
That is my entire submission.
Just 4 lines. Just 4 lines.
Lordship.
First 5-6 lines you read, then you will get it.
Lordship, it has been tested in last Kharif Fasal.
No. Who has tested or whoever has not tested, that's not the issue here.
Lordship, we are the highest procurement Kharif procurement. Lordship, this is tested. That is my entire submission.
Quantity of procurement is not the criteria.
No.
The criteria is criteria is whether minimum required infrastructural facility.
Yes.
So that is. So if you have that, you approach the authority, let them take a decision. You took notice.
Lordship.
But this can't be state, there will be confusion.
No, you did not say it will be infructuous, Lordship. Lordship, kindly see.
No, it will not be infructuous. It will not be infructuous because paddy, again, the next season you will be available.
No, Lordship, kindly come to Annexure 21, page 21, Lordship. Page 21.
No, paddy procurement never stops in one season.
No, I'm not saying page 21, Lordship, kindly see page 21.
For Rabi, this is Rabi?
Rabi, Lordship, I am...
So Rabi, you are out. Kharif, you will be in. Next procurement.
Then the win of the political leaders, Lordship. Then it is not what rule of law will work.
Could be. Let them file that counter. Let them file the counter political way.
Lordship, can such an accreditation will survive?
No, it will not survive. It will not survive, but I can't be arbitrary without hearing them. No, for your suggestion of arbitrariness, I will be more arbitrary. That's not the
No, I'm not saying. I'm saying, Lordship, their purpose.
You have to, because you are not before this court by bringing anything on record that you approach the authority, you have approached, and there is facility. You have not approached.
Lordship, there is no scope. Lordship only say, Lordship.
So that is how we are issuing notice.
Lordship is absolutely correct. Lordship, kindly see the date, Lordship. Can page 21, Lordship, for a moment. Why I'm saying, you Lordship may remand, but what are the observations?
No, it's not a question of remand. It is not a question of remand. Whether you have approached the authority on the criteria of you having all the facilities.
Lordship,
so you are saying that they have because you did in Kharif season the highest procurement, there is a presumption.
No.
There cannot be any such presumption.
Lordship, my argument is just reciprocal. The authority should have been asked me, these are the deficiencies. That then have been, that's why I'm saying it has to be passed. Lordship,
yes. It has to be passed after hearing them. Like they have not, without hearing you have passed, they have set you, but I mean, they have removed you. I cannot just, without hearing them, set it aside.
That's why, Lordship, give me protection. Let it be, Lordship, kindly issue notice that my friend is there, Lordship. Let it be reopened, kindly protect me, Lordship.
No, there can't be any protection in a removal order.
It is not a removal order.
Then it is as good as granting the relief in the writ.
It is an arbitral order. What is
Yes. I'll record that. It is arbitrary. But I can't give a finding that it is arbitrary.
Lordship.
I had Mr. Sukanta Kumar Dalai for the petitioner, Mr. Umesh Chandra Behra for the opposite party. The petitioner is a self-help group. Represented through secretary has approached this court challenging its exclusion by office order dated 20/5/2024 issued by the collector Bhadrak, whereby the petitioner self-help group has been excluded from participation in the paddy procurement process for Rabi marketing season 2025-2026. It is submitted by the Learned Counsel for the petitioner that the petitioner has not been granted any opportunity before the decision to exclude the petitioner
from paddy procurement for the Rabi crop marketing season. Referring to the earlier order dated 18/5/2026, it is submitted that in the last Kharif marketing season, खरीफ नो सेटा तो रबी पे
सेटा खरीफ लॉर्डशिप खरीफ पे
पूरा खरीफ
खरीफ पे
पूरा खरीफ
18/12 रे खरीफ पे इशू करथिले
18/12 ना 18/5 है, 18/5
ना
पचास
18/12 खरीफ लॉर्डशिप देख आई हैव चैलेंज दिस ऑर्डर
अरे 18/5 है सर, 18/5 है, 18/12 को 18/5 ना 18/5 में रेफर 18/12
लॉर्डशिप
18/12 इज खरीफ
18/12 का खरीफ पे नोटिफिकेशन गवर्नमेंट करते
Okay, set 18/12/2025 for Kharif procurement season. They submitted that Kharif marketing season 25/26. The petitioner was allowed to participate, and they have collected the maximum paddy and maximum number of farmers. Maximum number of farmers are also participating in the procurement process by supplying paddy to the petitioners.
Now have registered lordship. Now also have registered.
The petitioner self-help group, it continues to be registered as a procurement agency of paddy. Issue notice along with this order, the learned AG upon advance commission notice.
Lordship collect direction they do within 3 days you will consider. Setting of grievance within 3 days. Otherwise it will be infructuous.
3 days no, 2 weeks. 2 weeks.
And 2 weeks lordship setting up a phase देखौची. Phase
ଆପଣଙ୍କର once you are because that will be a problem for farmers. ଆପଣ ଚାଷବାସ ତ କରୁନାହାନ୍ତି.
ନା ନା phase 21 lordship ଦେଖନ୍ତୁ କାଇଁ କହୁଛି 3 days lordship phase 21 lordship କାଇଁ लिसी. Phase 21. Phase
2 weeks. ଆପଣ ଶୁଣନ୍ତୁ either you wait for 2 weeks or reopening doctor debe
definitely I'll got a lordship this order will go but it will infructuous, so lordship is suggesting that I will go there.
Someone you must understand, as you are procuring for kharif, you are now out for rabi, you will be again back for kharif.
No lordship if you not Samoli back a call lordship I will entry. That is the I am not telling before lordship. So lordship kindly direct collector.
Let us not do that.
Lordship kindly give
let us not do that. Let us not do that in a court, Mr.
Collector lordship that is happening lordship. So lordship
that is not do that.
That's why lordship kindly say the collector within 3 days will consider.
Let us not 3 days. Not 3 days. 15 days.
Sorry, infructuous. No, lordship 7 days. Lordship
15 days. 15 days.
15 days. 15 days.
मत देंगे फोन आसुनी मत से हो जाएगा.
No, 15 days लगा
सुगंध धुने कहिए मतलब 3 दिन हेगला आपण जेति कहछन सेंति होबा
15 days रे ऑटोमेटिक infructuous lordship काली पेज 21 से कहूची
ऑटोमेटिक सेमियोटिक कथा पढिनी 15 दिन टाइम में कर परिबे
15 दिन लordship 1 day काम लordship पॉलिटिकल
डिसीजन आपण पे 1 डे आपण कलेक्टर माने आपण कोन समझते आपण सिना 1 डे हबो 15 दिन टाइम दियो तो से करो
15 दिन लागे केस infructuous हो जाउची लordship पेज देखंतु
at this stage is अबे इशू नोटिस मना कली इशू नोटिस आपण इशू नोटिस कहउछन जे डिस्पोजल कर देबा पे
लordship
yes disposal नहीं इशू नोटिस काटी दियो. At this stage it is submitted that the petitioner self-help group with the details of the facilities available with them shall approach the appropriate authority collector to take a decision regarding their continuance as a procurement agency for the
Rabi lordship.
For the Rabi crop marketing season 2025 2025-26. Stop. Perusal of the writ application indicates that the petitioners have not enclosed any document regarding the availability of the facility.
I have enclosed lordship. Lordship I have enclosed. I annex 5 series.
Though not a document indicating the facilities available with them, though the annexer 5 series, that is the agreement between the parties, agreement between the self-help group with the
May I submit go down owner and lordship.
सेटा बहुत authority कथा को जाउछ
the petitioner have not enclosed any document regarding the details of facilities available with them that could have been presented or has been presented to the authority for consideration. However, it is submitted by the learned AGA. And however, it is submitted by the learned AGA in response that yes, Mr. Beura.
My lords, kindly see page 44. The agreement by which they have taken go down has elapsed since March 2026. My lords,
Yes.
kindly see page 44.
No, Mr. Beura, I am not expressing any opinion.
My lord. That is prima facie.
Though the Lorded Council relies on Annexure 5 series, I have recorded that. She relies on Annexure 5 series.
My lord.
The Lorded AGA upon advance copy served and appeals and waives notice on behalf of the opposite parties. He submits that if the petitioner will appear before the authority along with the necessary documents indicating the facilities and capacity for procurement of paddy as prescribed, the authorities shall consider the same along in accordance with law. Para. Having heard the learned counsel for the petitioner and the learned DGA for the opposite parties, state JT or
1 and 4.
1 and 4. In considered view of this court, no purpose would be solved in keeping the matter pending when the petitioner is to approach the appropriate authority for taking a decision regarding its capacity and eligibility to continue as a procurement agency for rabi crop season. The petitioner shall approach the authority along with all the relevant documents within a by 5 तारीख
by tomorrow, lordship, tomorrow.
10 तारीख
ना tomorrow मैं फिर करी lordship.
by से जाई परियो से आपन प्रॉब्लम है
ना tomorrow करूँ तो lordship हम ऑनलाइन कॉपी नहीं जाऊँगी.
by 9 जून 2026
आप lordship से 8
अपन सच आपने ये कौन सा अपन सच representation public application being filed along with all relevant documents indicating the capacity and facility available with the petitioner for procurement of paddy. The authorities shall take a decision within a by 15 पर रजो छुट्टी
रजो छुट्टी लड़सी 15 पर रजो छुट्टी by 15 लड़सी से
by 18 by 18 6 20
My lords may grant some more time. 2 weeks.
19
thereafter.
19 6 करो ହେଲା 10 दिन ହେଲା Mr. Beura, Mr. Dore is also right to saying that it will not require that sort of course he will seek a field report. See jodi କହିବେ ଆଗ ପାଖରେ ଅଛି ତା ଅଛି ସେ that he will require. So that is how I am saying for
my lords
ठीक है so that decision
any documents before this court having facilities, my lord.
Mr. Dole is so mellowed down. He looks tired. Document here, so you would have torn apart your submissions. Mr. Dole, Munis na baisi. Koti line koti. Can you hear Mr. Dole?
Line कटि जाइथो नेक्स्ट मैटर भी अछि तांगर
वर्षा आरंभ हेला तो
लॉर्डशिप वर्षाटा ही डिस्कनेक्ट हे जाउची लॉर्डशिप
हां बहुत जोर वर्षा
22 जाए सर टेक अ डिसीजन बाय 22 तो 6
लॉर्डशिप काइंडली लॉर्डशिप बिफोर वन विल सफाइस लॉर्डशिप वन विल सफाइस
चल 20 ताले ठीक है लॉर्डशिप 20 जो वर्किंग नहीं मिस्टर दौड़े यू मस्ट अंडरस्टैंड प्रैक्टिकलिटी ऑफ द सिचुएशन से जो से मागिवे रिपोर्ट एरिका जो छुट्टी पड़िबो से केई तो रेस्पोंड करिबेनी सो टेक अ डिसीजन बाय
ना मोर छोटिया क्वेश्चन लॉर्डशिप चलो मोर छोटिया गोटे क्वेश्चन निजे पचारुची अंडर व्हाट डिसीजन दे हैव टू डिस्क्वालिफाइड मी देयर मस्ट बी डिसीजन इट हैज टू बी ओनली वेरीफाइड
से उत्तर केवल अपने अंतरात्मा ही दे परिबो से कोन अछि आमे को सेटा त मैडम सब इशू हे परिबो
ଆମେ ସେମାନଙ୍କ ମାଇଣ୍ଡରେ କଣ ଚାଲିଛି ପଢି ପାରୁନୁ that is all difficulty ଅଫିସର ଟା କେତେ ପାୱାରଫୁଲ ଅଛି ତାଙ୍କ ମାଇଣ୍ଡରେ କଣ ଚାଲିଛି ଆମେ ପଢି ପାରୁନୁ
20 ତାରିଖରେ
that is gospel to ଦେଇ ଅଛି Lordship, only Lordship say only till that period order ta effect not दियंतु Lordship.
No.
मोर registration tag कर देइचंती.
Again, that will have to
registration tag कर दिल आगे संग Lordship.
सेटा से तो आपण जदी टैग हेछि त आपण पाइबे that is better, that is a good entry measure, then alerting it to tag what are better than alerting it to somebody else, that is in your favor. You should thank your
Lordship they tag means Lordship जो जा को tag करछन तार infrastructure नाही किछि, they don't have house also.
ठीक अछि
कोन Lordship ए ऑर्डर आपण इंटरफेयर करबिन ऑफिसर विल बी monarch of the state Lordship. सेमन जाहा करछंती
कोन करा जो
Lordship at least ऑर्डर टा प्रोटेक्शन देबे Lordship ओटे रीजनेबल
this order cannot be allowed आपण करतले allowing the writ application हे गल
no
13 now 14 to समान 14 is same
जदी से
same 13 and 14 same 15 next
Lordship deal decision is taken protection दियो
से जेतरा आपण स्टेटस को आंटे करी होबनी because there will be confusion
हम कोने से पर्यंत at least मु आगे नो कोर्स एक्शन मो अगेंस्ट करंतु मोर
आपण अपेक्षा करंतु 20 रे जदी आपण सैटिस्फाइड हेले नला हम चैलेंज
20 रे आगे आई विल कम विथ सर्टिफिकेट आगे हम सेमति केस गोटे करूनी आगे 100 केस करूछु कलेक्टर ऑर्डर को हम टच कर परनु आगे सेटा दैट कलेक्टर ऑर्डर मींस दैट बिकम फाइनल ऑर्डर आगे जो टाइम रे क्वास होची से टाइम रे रिट बिकम इनफ्रक्चर्स आगे ना हम ग्रेट एंजाइटी हम कहू Lordship
I understand that, but that order cannot be restored.
No, I am not say restored. Let's say till there more no course at least.
Leave it there, Mr. Dole. Next item.
मो जो फार्मर रजिस्ट्रेशन करिछि Lordship मो पाखरे
एटा आपनकर जहा को टैग हेछि से नेबे अपन सेटा मु क्लैरिफाई करियो
ताल रहिला कोन Lordship रहिला
whatever consequence unless it is tagged you that will be prejudicial to you, at least it can be restored to you. Yes
मते आगे से प्रोक्योर करते मो रेस्टोर से केम करिवे
disposed
आगे से सीधा के कर देबे ये रेस्टोर कोन करिवे के आगे सेमती सेन
take a decision within with appropriate observations the writ application is disposed of. Yes
entry mode कोन आंती
please your Lordship
I am not getting entry mode
my lord
किछि प्रोटेक्शन भी पाउनी Lordship
तहसीलदार बडबिल
प्रोटेक्ट करि होबन आपनकर थरे गला परे प्रोक्योरमेंट ही करि होबन
ना Lordship
yes Mr. Das
Lordship कोन सेमान जहा कहबे से
तार सीधा कहबे काई हो ताले
आगे
it is clarified that this court has not expressed any opinion add karantu regarding merits of the case of the petitioner or the contentions of the parties.
At least time security reduce करे मुक्त पाइबे किछि कि ना के कोर्ट आसीबाटा इनफ्रक्चर किछि कोन लाभ आगे कोर्ट को आसीबाटा को मीनिंगलेस बेटा
सब केस रे का रिजल्ट हुए कि
ना ना रिजल्ट हो जाके एट लीस्ट प्रत्येक केस
से रिजल्ट हो
अछि समस्त इंस्टीट्यूशन ऊपर
विश्वास रखा दरकार किछि असुविधा है. यस नेक्स्ट
कलेक्टर करबनी कलेक्टर कंडक्ट में गोटे
सेटा कलेक्टर करबनी को ऑब्जर्वेशन देबी सेटा तो करि होबनी. यस नेक्स्ट
may please your Lordship my lord the Lord Tahsildar Godby issued a notice in a encroachment case number 4-326 of 2026 to the present petitioner. Your Lordship may kindly come to page 13 and Annexure 1.
Where is your reply?
Kindly see the Lord Tahsildar has lacks jurisdiction to send the notice on the ground that this honorable court has decided that the law. Your Lordship may kindly come to page 16 Annexure 3.
Mr. Das, you have to stop while submitting. Maybe your voice is not. Can you hear me?
Yes, my lord.
So look at page 13, Annexure 1.
Annexure 1, my lord. Only four links of land. SC 0004.
Question टा सुनी की उत्तर दियो. न सुनी की उत्तर देले केमति? पढ़ंतु से.
ଆପଣ ନିମ୍ନ ତଫସିଲ ଦର୍ଶାଇଥିବା ଭୂମିକୁ ବିନା ଦଖଲ କରିଛନ୍ତି ଆପଣଙ୍କ ପ୍ରତି ଏତଦ୍ୱାରା ଏହି ଆଦେଶ ଦିଆଯାଇଛି ଯେ ଆପଣ କିମ୍ବା ଆପଣ କ୍ଷମତାପ୍ରାପ୍ତ ଅଧିକାରୀଙ୍କ ଜରିଆରେ 8/6/2026 ସମୟ 30 ରେ ନିମ୍ନ ସରକାରଙ୍କ ସମ୍ମୁଖୀନ ଆଦର ଓଡ଼ିଶା ପ୍ରିଭେନ୍ସନ ଅଫ ଲ୍ୟାଣ୍ଡ ଏନଫୋର୍ସମେଣ୍ଟ ଆକ୍ଟ 1972 ମସିହା 4 ଏବଂ 6 ରେ ଅନୁଯାୟୀ କାହିଁକି କାର୍ଯ୍ୟାନ୍ୱୟନ ଆପଣଙ୍କ ପ୍ରତି କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କରାନଯିବ ତାର କାରଣ ଦର୍ଶାଇବା ନିମନ୍ତେ. The property is only SC 0004 links. This property is located in
हाँ मिस्टर now Mr. Das आपण कारण कोड दर्शाइले दियो देखांतु
Your Lordship may kindly see this notice. The non-Tahsildar has got lacks jurisdiction to send the notice on the ground.
सेटा तांकु कहबे तहसीलदार को कहबे आपण जुरिस्डिक्शन नाही
The property located, Your Lordship, I have
सेटा सेमटी माने आपणकर एक्सपोनेंशियली डिटरमिनेशन हे परिबनी यू हैव टू राइट आपण एटा तहसीलदार को लिखि कि दियंतु जुरिस्डिक्शन नाही बोली
I have similar matter has been decided.
Dissimilar order हबो सिमिलर सेना बाइंडिंग प्रेसिडेंस हेतिले हबो आपण कोन तहसीलदार मु कोन तहसीलदार एटा को विचार करबी आपण तहसीलदार को जुरिस्डिक्शन नाही बोली जोटा कहउचंती कोर्ट लिखि कि देले
Will may kindly come to page 38, page 15.
अरे आपण तो काइंडली कम नहोंती आपण स्टेट कहंतु जे को पेज रे आपण लिखिले जे तहसीलदार को जे आपण को जुरिस्डिक्शन नाही
may not may kindly come to page 17, annexure 4. Annexure 4.
आपण तो पढिबे किछि बुझिबेनी आपण तहसीलदार को एटा तारादत्त देथिले तारादत्त जोटा देथिले सेटा सुनंतु तारादत्तଙ୍କର कहले तारादत्तଙ୍କ जो नोटिफिकेशन रे कोठी नाही जे तहसीलदार को के रिप्लाई देबेनी बोली आपण तहसीलदार को कोठी रिप्लाई देइछंती
that reply has not been submitted.
अच्छा छाडंतु छाडंतु
that reply has not been
urgency नाही केस रे
Your Lordship may kindly come to page 4.
before this court is an inhabitant of Mr. Shatrugna Das मु आया जेते कांड हेले कोन हो मु कोन तहसीलदार ही जीवन
No, my lord.
आपण तहसीलदार को कहबे आपण को जुरिस्डिक्शन नाही तहसीलदार जा डिसाइड करिवे मु ताकू तापर सब कलेक्टर तापर एडीएम तापर कलेक्टर तापर आउ के सेक्रेटरी की तापर बहुत
my lord is correct.
तो आपण जहा जवाब दबा कथा तांकर जुरिस्डिक्शन नाही बोली कहउचंदी ताको कोड लिखित जणेले
No, my lord, that has not been stated. That has not been filed before the appropriate authority.
I am not
the property located in Portfield municipality.
तांको कोहंतो आपण से नोटिस भी पढी ना नोटिस भी पढी ना लेखा रीड ड्राफ्ट कर देले
I have gone through the notice as because they lacks jurisdiction.
सेटा तो नॉन जोरी लिखा हिची म्युनिसिपलिटी कोड लिखा हिची
नॉन जोरी that is the classification in the record of rights. That is not none jury.
आपणकर आरआर रे कोड लिखा हिची सेटा म्युनिसिपलिटी बोली प्रजार नाम
म्युनिसिपलिटी located in
अरे सेटा इमेजिन करछथि ना डॉक्यूमेंट देबे
No, I have given in affidavit. Your Lordship may kindly come to my
document देबे ना affidavit देबे
my averment. Your Lordship may kindly come to averment.
दया करे averment दियंतु नाही आपणकर लेख कोठी अछंती सेटा सीधा ये करंतु
para 8 Your Lordship averment
para 8 record of right ROR खतियान
record of right I have not annexed but the property located in the national in the side of national highway.
आगे वर्तमान भुवनेश्वर रे भी तहसील प्रॉपर्टी अछि भुवनेश्वर रे जी डिपार्टमेंट प्रॉपर्टी अछि कटक रे भी सेया म्युनिसिपलिटी अछि तहसील प्रॉपर्टी अछि
तहसील प्रॉपर्टी in rural areas.
बिडनेसिटा तहसील प्रॉपर्टी ना म्युनिसिपलिटी प्रॉपर्टी
municipality
बिडनेसिटा तहसील प्रॉपर्टी सब जगह रखि दला बाती कोना म्युनिसिपलिटी प्रॉपर्टी
we are paying rent to the Tahsil, but the jurisdiction under the Kotak municipality.
आपण खजना कथा पचरा होनी आपणकर बहुत जगह रे आपणकर दैट इज एडमिक्सचर ऑफ प्रॉपर्टी आपण जदी निजे पर्टिकुलर हेबेनी रिट पिटिशन रे ई प्रॉब्लम हबो आपण ओडी इमेजिन करले ताकर अथॉरिटी नै ता लिखि दियंतु जे आपण प्रॉपर्टी नो बोली सेटा
Your Lordship may kindly observe that I will find the
the petitioner before this court is an inhabitant of Joda in the district at Joda in the district of Kendujhar. The petitioner hele Mr. Shatrugna Das into bracket opposite party Mr.
Chandrakanta Pradhan.
Mr. Chandrakanta Pradhan, additional government advocate. Mr. Pradhan, you are up to which item?
4 and 14, 15 and 16, both are same.
15 16 15 ରୁ 17 ଗୋଟେ order ଅଛି.
17 I am there.
15 16 है 17 रे किए सर?
मैं
17 Mr. Prem Kumar Mohanty, additional standing counsel. So disposed of kar debe. The petitioner before this court is the inhabitant of Joda and Joda in the district of Kendujhar. He is before this court challenging the notice annexed to the writ application marked as Annexure 1 dated 22/5/26 na kete dekha jaଉଛି 22/5 intimating the petitioner to show cause why actions shall not be taken against for encroachment under the Orissa Public Land Removal of OPLE Act 1972, sections 4 and 6, with regard to the encroachment of खसड़ा नंबर 115 प्लॉट नंबर 77/860 किसम 9 जोड़ी total area acre 1 3000 decimals, out of which under encroachment is acre 0 dot
4 links only. 4 links.
Or 4 links.
Only 4 links you lost.
Or 4 links कौन? Decimal system में link कौन? Decimal system में link कौन?
In 1001 acre, it comes to only 4 कोड़ी.
सेटा अलगा हिसाब कौचु. आपनकर decimal system रे कोड़ी व्यवहार हुए.
Decimal में ये लॉटशिप में either
00040.
No.
It is submitted by the learned counsel for the petitioner that the authority doesn't have any the authority issuing the notice doesn't have authority to issue such notice as the area encroached comes within the municipal area of Joda. On being asked whether the petitioner relies upon any document to show that details of land which will indicate that the authority doesn't have jurisdiction is fairly submitted by the learned counsel for the petitioner that he has not enclosed the petitioner has not does not have the record of right of the area to show that the Tahsildar to show that the area does not come within the jurisdiction of the Tahsildar. Stop. On being further asked whether the petitioner has approached the Tahsildar in response to the notice and replied and filed any reply, the learned counsel for the petitioner submits that giving some time, he will file the reply before the Tahsildar. The learned AG upon advance copy served appeals and waives notice on behalf of the opposite parties, he submits that if the petitioner files any reply, the same shall be considered by the authority in accordance with law.
8/6/26 is the last date.
How did it समय दे दियो? How did समय दे दियो? In view of the submissions made, having heard the learned counsel for the petitioner and the learned AG for the opposite party, it is directed that the petitioner shall file his reply before the authority by 18/6/2026. The authority shall take 22 माने 2026 ना 2027 रे से कहले आपनकर डेट अछि 8 मु ताको एक्सटेंड करछि 18 जाय ताको आपण फेर करन 22 से कि सुनियो ना कोन से वकील नहंती सी भी जण वकील ना आ कथाटा रिस्पोंड कलेनी जे आपण सेठी जाई नांती काहेकि यू शुड हैव अप्रोच द अथॉरिटी देन यू शुड हैव कम हियर सर फाइल द रिप्लाई बाय 18/8/2026 18/8/20 18/6/2026 the authorities shall do well to consider the same and take a decision thereafter. It is further directed status quo as on date regarding nature, character, ownership and possession of the property shall be maintained
by both the parties. By both the parties.
Yes, by the parties to the writ petition. Yes. He has to. Mr. Das, you have to maintain status quo. Don't change anything.
No, my lord, I will not.
16 भी जोड़ा है?
No.
17? ठीक है, 18?
Item 18.
Item 18, my lord. Item 18, I am appearing for the petitioner.
So Vibhuti Bhushan Mishra for the petitioner. Mr. Prem Kumar Mohanty, additional standing counsel for the opposite party.
My lord, the petitioner is a landless person. She is in possession of the schedule mentioned property since last.
Kindly speak to the microphone, Mr. Mishra. Microphone ta apna pakhuk nahi jante. Ha, sit. Yes.
The petitioner is a landless person. She is in possession of the schedule mentioned property since long. She has taken electric connection. She is also paying regular rent to the local NSC. And while he is in possession, a third person who is a stranger to the petitioner filed a writ application before this honorable court. This honorable court directed the Tahsildar to consider the representation and take a decision. The collector, the Tahsildar, acting upon the said representation, has directed the petitioner for eviction, that is under Annexure 5, my lord. Your lordship may kindly at page Annexure 5. No proceeding is initiated under the OPLE Act. He has been directed to vacate the land within 15 days. Though he is staying there and she has been issued with a land right certificate, that is Annexure 7. So they cannot.
Did you ଆପଣ ବର୍ତ୍ତମାନ ଏଠି ଯୋଉଟା କହୁଛନ୍ତି ହାଇକୋର୍ଟ ରେ ସେଟା ଅଥରିଟି କୁ କହିଲେ କି?
ଅଥରିଟି କି ମୁଁ ଆଜ୍ଞା ଦେଲି, ସେ କହିଲେ 15 ଦିନ ଭିତରେ ଛାଡନ୍ତୁ, ହାଇକୋର୍ଟ ର ଅର୍ଡର ଅଛି ବୋଲି
ସେଇଟା ଦେଖାନ୍ତୁ, ଆପଣ ଅଥରିଟି କୁ ଯୋଉଟା ଦେଇଛନ୍ତି ସେଟା ଦେଖାନ୍ତୁ କଣ ଷ୍ଟାଣ୍ଡ ନେଇଛନ୍ତି।
Annexure 6 ରେ ମୁଁ ସିମ୍ପଲି ଟାଇମ ନେଲି ତାଙ୍କୁ।
ସେମିତି କାହିଁ କରୁଥିଲେ? ଆପଣ ହାଇକୋର୍ଟ ରେ ଇଲାବୋରେଟ ରିଟ୍ ପିଟିସନ ଫାଇଲ କଲେ ଯୋଉଥିରେ କି କିଛି ଜୁରିସଡିକ୍ସନ ନାହିଁ ହାଇକୋର୍ଟ ର। ଅଥରିଟି ପାଖରେ କିଛି କହିବେନି।
ଆଜ୍ଞା ସେ ରିଟ୍ ପିଟିସନ ରେ ଯେହେତୁ ଅର୍ଡରଟା ଅଛି, ସେ ପ୍ରୋସିଡିଂ କିଛି କରୁନାହାନ୍ତି।
ଆପଣ ଆରେ ସେଠି ତ ଫାଇଲ ଲେଖିକି ତ ଦେବେ।
ଆଜ୍ଞା ସେ ପ୍ରୋସିଡିଂ କିଛି କରୁନାହାନ୍ତି, ସେ ତ ଓପିଏଲ ଆକ୍ଟ ରେ ଗୋଟେ ପ୍ରୋସିଡିଂ କରିଥାନ୍ତେ, ସୋକଜ ମାଗିଥାନ୍ତେ।
ଆରେ ସେଇ ଜିନିଷଟା ଲେଖିକି ଦିଅନ୍ତୁ।
ଆଜ୍ଞା ସେଇଟା ସେ ତା ଭିତରେ ତ ପ୍ରୋସିଡିଂ
ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି
ଆଜ୍ଞା
ସେ ଅଥରିଟିଙ୍କର without initiation of proceeding cannot evict ଲେଖିକି ଦିଅନ୍ତୁ।
That I have stated in my
that as a lawyer you have to do, you have to rise to the occasion, Mr. Mishra. In this kind of situation you have to guide them.
ବର୍ଷ ତ evict କରିଦେ ବସିଲାଣି 15 ଦିନ ତାର ଏକ୍ସପାୟର କରିଗଲାଣି from the date of notice. So I may be evicted, I will be seriously prejudicial also.
ଆପଣ ପଢିଲେ ହବ ନା, ଆପଣ ପଢିଲେ ହବ। ସିରିୟଲ ଆପଣ ସେଟା ପଢି ବି ନାହାନ୍ତି, ତାକୁ ଚ୍ୟାଲେଞ୍ଜ ବି କରି ନାହାନ୍ତି।
ସେ ନୋଟିସ ଟାକୁ ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରିଛି।
ନା ଏଲଇସି ର କ୍ଲାରିଫିକେସନ ଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରି ନାହାନ୍ତି।
ଏନଏସସି ର କ୍ଲାରିଫିକେସନ ଟା ଆଜ୍ଞା ସେ ଯୋଉଟା ଦେଇଛି ସେଟା ବି ମତେ ସେ ଦେଇନାହାନ୍ତି, ସେ ଖାଲି ସିମ୍ପଲି ଅର୍ଡର କରି ଦେଇଛନ୍ତି 15 ଦିନ ଭିତରେ ଛାଡ, ନହେଲେ
ଆପଣ ପଢିଲେ ବୁଝିପାରିବେ। ପଢନ୍ତୁ, ଲାଷ୍ଟ 4 ଲାଇନ୍ସ ପଢନ୍ତୁ, ପେଜ 5 ପେଜ 30
Page 30, my lord. The EO NSC G. Udayagiri has given his clarification by letter number such and such pertaining to WPC number such and such regarding the issuance of LEC to you, that your eligibility for issuance of LRC is rejected as per proceeding of the urban area slum land settlement redevelopment and rehabilitation.
तो सेटा कौन करियो? सेटा चैलेंज करिवेनी?
सेटा आगे हम पढिछि सेटा Annexure 7
चैलेंज करंतु।
आगे Annexure 7 देखंतु टिके मु मे ड्रॉ योर लॉर्डशिप्स काइंड अटेंशन। Annexure 7 रे तळकु जो अछि द्रष्टव्य, जदि आपण अयोग्य जमीन रहुथांती आपनको अन्य बासयोग्य जगह रे भूमि अधिकार प्रमाण पत्र प्रदान करा जिवो।
So they cannot throw me out like
problem है जे आपका problem है योग्यता प्रमाण पत्र रो date ना now you have a order where it says that you are not entitled and you have not challenged that.
Well, that they cannot throw me out.
At least आपण तो ए रीट पिटिशन से प्रेयर करि परिबे.
Again, mu रीट पिटिशन करछि for settlement of the land.
सेटलमेंट नो आपण जोडा आपनकर योग्यता नाही बोली से लिखि दैछन्ती.
से लिखि दैछन्ती से लेखाटा तो मो बहिर नाही.
सेटा कि माने हाई कोर्ट प्रोवाइड करिवे.
नाही माने
जदि आपण हाई कोर्ट रे से कहिबे आज्ञा सेटा जो दैछन्ती से लेखा मो पाखरे नाही हाई कोर्ट विल प्रोवाइड.
Again, may I submit my lord?
So you have to obtain that copy.
Again, मते तो proceeding
आपण नेबे केमती नेबे सेति भाबे हाई कोर्ट साहाय्य करिवो ना कोन.
नाही मु से कथा मोर तो जोड proceeding तो इनिशियल
आपनकर फलक्रम ऑफ योर आर्गुमेंट इज दैट यू आर एंटाइटल्ड फॉर आपनको योग्यता अछि लैंड सर्टिफिकेट योग्यता प्रमाण पत्र अछि. इंटरेस्टिंग होछि जे आपनकर नोटिस रे लेखा हला जे आपनकर योग्यता नाही.
से नोटिस लिखि दैछन्ती.
हां से लिखि दैछन्ती केमती सेटा आउ जने अथॉरिटी लेखछन्ती.
Authority election, but मते
आपण सेटा को चैलेंज करू नाथि कि यू आर नॉट बॉदर्ड अबाउट दैट आल्सो.
ए नोटिस ता पाइला परे मु आई
के सब जिंस रे कोन गोटे प्रोसीडिंग रे हेई परिबोनी.
अगे मु सेटा चैलेंज
कैन द सपोज now कैन द तहसीलदार डिसाइड दैट यू कैन नॉट.
सेटा चैलेंज करिवि मु.
करूना
for the time being मेला मते एविक्ट कर देबे nothing will remain to be adjudicated.
आपण 15 दिन चैलेंज करंतु एटा अर्जन हो
11/5/26 रे आगे से नोटिस करथली. ताप 15 दिन भीतर न खले मते एविक्शन कर दे. मते इंटरव्यू प्रोटेक्शन टी दियन मु मोर
11/5 रे 15 दिन सॉरी लडी.
आगे हां बरा ताप
सो आपण एविक्टेड हेतियो जदी हेतिबे स्टेटस को अजन डेट
हेई नाहंती दैट इज माय इंस्ट्रक्शन से
that's a different thing.
But see, he has not been evicted. And tapre out another writ application is pending before this honorable court. During pending
who has filed that application?
That application the stranger has filed.
So obviously strangers are against you and you are stranger to your own cause.
Against stranger to mo against file करछि एवं सेटा भी pending अछि.
आपण you should have intervened or appeared in those matters. जोथरे स्ट्रेंजर आपण नारे फाइल करछोंती सेटा आपण अपेयर करो.
आगे वेकेशन देखि करी से माने से केस पेंडिंग थिला परे भी से मते नोटिस करछन के से जगह बाहर कर देबे. Because the stranger is interested because he is having a land adjacent to the land of
Mr. By saying stranger 10 times it is not a mantra that you will improve your case. You should you are not a stranger to your case or you are also stranger.
Madam, I am leaving it to your lordships.
Oh, so how can you leave it to me? Where from I will get those orders? How I will challenge it? I have left that side. I have come to this side.
I guess unless I am protected.
लिखिले press लिखिले Mr. For the petitioner stand accept करो 1 to 4 1 2 to 4 up 5 none. It is submitted by the learned counsel for the petitioner is before this court. It is submitted kati diyantu. It is the petitioner is before this court against the order of eviction notice. Get it?
11/5/26.
Page
30.
11/5/2026 issued by the Tahsildar G. Udayagiri. Wherein notices has been issued pursuant to the order dated 21/4/2023 in WPC number 1217/0/2023. Pursuant to the said order, as indicated in the notice, the authorities has taken step for removal of the petitioner from the government land. The petitioner produced land entitlement certificate issued by the notified area council, G. Udayagiri.
Annexure 7.
Into bracket, Annexure 7. The land entitlement certificate is not dated. Stop. The notice to the petitioner further indicates that the notice to the petitioner at Annexure 5 further indicates that the executive officer NSC G. Udayagiri has given his clarification with a letter dated 21/4/2025 with regard to WPC number 4783 of 2026 date ta kon bhul achi 4783 of 2026 that the eligibility for issuance of land entitlement certificate as per proceeding of the urban area slum land settlement redevelopment and rehabilitation committee has been rejected. देखिए लेकिन मुझे स्लम एरिया रे लिखा है अर्बन स्लम अर्बन एरिया स्लम लैंड पेज 30 is submitted by Learned Counsel Mr. Mishra that the petitioner was not heard in the writ application WPC number 4783 of 2026. Even by the said
the previous writ application 12170
121702023.
Yes. And the other writ application is pending.
The other writ application 4783 of 2026 is pending. और से नंबर उड़ा का भूल भाल है बुझिले वो तो चेक करिबे अपन लिखि था तो it is submitted that the petitioner should once having been issued land entitlement certificate should not be evicted without initiating in proceeding against him as has been done by the authority. So it is submitted that unless status quo is maintained, the petitioner shall suffer irreparable loss and injury as he will be evicted after having been issued a land right certificate into bracket annexer 7. Land right certificate under the 2017 rules by Act जोड़ा थी. Issue notice along with this order. Requisites for issuance of notice to the opposite party. 4 shall be filed within 3 working days. The Learned AG, Learned Additional Standing Counsel shall appears and waves notice on behalf of opposite parties 1, 2, 3, and 5. The Learned AC shall obtain instruction whether any proceeding has been initiated against the petitioner before issuance of the eviction order under the OPLE Act or any other act by the Tahsildar G. Udayagiri pursuant to the direction issued by the coordinate bench in WPC number 121702023 disposed of by order dated 21/2023. Stop. If any such proceeding has been initiated, the records of the said proceedings shall also be produced. Stop. The executive officer NSC G. Udayagiri shall also file affidavit indicating whether any proceeding was initiated before cancellation of the land eligibility certificate issued to the petitioner with annexer 7. The counter affidavit by the opposite party shall be filed by the matter shall be listed for orders before the assigned bench in the week commencing 13/7/2024. तो counter लिख लेनी. The counter shall be filed upon serving copy thereof on the Learned Counsel for the petitioner.
just tapare IA lekhotu issue notice as above. The Lord accept one set of process fee as well as postal requisites. The Lord AG as well as shall file the response of the Tahsildar. The opposite party, number dash, executive officer, G. Udayagiri NSC, OP number 4, U. Udayagiri NSC shall file the response along with the counter. Stop. Till the next date of hearing, status quo as on date regarding the nature, character, ownership, and possession of the property, as well as the construction made thereover by the petitioner, shall be maintained. The schedule ta kete?
Schedule that is there in the writ application as well as IA malad.
Khata 23 lecture seta.
District
Khata number 23.
Khata 73.
Plot number 166.
Yes, malad.
Area 0 acre 0.0790.
Hectare 0.079 out of hectare 0.948.
Out of
hectare 0.948 are
0.948. So out of total area. That code lecture.
Again?
Who page re?
Page 10 of the writ application.
10. Page 10 to the key lecture. Yes.
Obliged.
19. May I please, Your Lordship, my lord. Form का eviction notice has been issued, my lord.
Yes.
The form का eviction notice has been issued.
Yes.
The annexation on page 7.
Yes.
That is applicable under section 12 of the Act. Since this vacation is going on, I may be charged to file the appeal and I may be protected for that period.
Eco
Eco double put like that. Most systems go touching through like.
What did I say? Upon reader join कर दीजिए.
No, more गोटे कर दीजिए. गोटे system.
संत कुमार सतपति अच्छे दिया गोटे. उन्हें तो बंद अच्छी. आपण को जोटा ऑडियो रिसीव करछन गोटे बंद कर दियंतु मिस्टर सतपति. You have joined at two places.
Two places. Single joint is.
Petitioner is before this court against the petitioner by filing the writ application, challenging the eviction notice in form KHA in OPL case number 30/24-25 issued by the Tahsildar Bond. Stop. It is submitted that the petitioner shall approach the appellate authority under section 12 of the OPL Act and he may be granted some breathing time to move the authority. The lauded, sir, your name?
P.K. Ponda, Additional Standing Counsel.
Mr. P.K. Ponda, Additional Standing Counsel,
Right.
Appears on behalf of the opposite parties. 1, TO2, 4, and Webb's notice. It is submitted by in view of the limited nature of prayer made in the writ application and submissions of the learned counsel for the petitioner. It is directed that petitioner, if so advised, shall approach the appellate authority.
Collector Bhadrak.
Sub-collector Bhadrak by जो 5 ने की by 19/6/2026 रज पर 19/6/2026
along with ଛୁଟି ଆପଣ 20 କରିଦେବ by 20/6/2026 along with application and along with the application seeking interim relief as would be sought for. Upon filing of such application, the authority shall pass appropriate orders in accordance with law. The status quo as on date regarding nature, character, ownership and possession of the property under possession of the petitioner. Khata number 1524.
Plot number 3030.
Plot number 3030. Gharobari. Area 0.12 out of total area 0.27 shall be maintained by the parties till 2020. Till 6/7/2024.
मतलब till consideration of interim application से कोई interim application
till 6/7/2024. If the interim order shall be given effect to this interim order shall be the order that would be passed by the appellate authority shall be in continuation of this order.
Milords, that will be, Milord, with utmost respect, that will be interpreted as this order being continued till the interim order, Milords. Your Lordship may clarify that once your Lordship fixes a particular date in this matter, Milords, then that particular date, let it be operational till that date, Milords. Within that time, plenty of time is there.
I am suggesting, Milord, that interim order may continue till consideration.
No, your Lordship. I humbly submit, Lord, this is considered as the continuation of your Lordship's interim order.
Interim order, if the authority will pass order,
your Lordship may fix a particular date. That's it. Once your Lordship fixes a date for your interim order.
The authority shall pass appropriate orders in accordance with law in the application that will be filed before the authority. Yes. Yes, next. This poster.
But in this case, the petitioner has challenged the inaction of the action of the
Shakti Prasad Das for the petitioner, Mr. Ponda ASC for the opposite party. Yes.
But the action of the Tahsildar Chandwali in demolishing the shop rooms of the petitioner by constructed on a plot on plot number 2499 of an area of 2 decimals out of 78 decimals. It is an encroachment, admittedly, and the backside of this plot there are private plots. One person who is at the back of this petitioner's encroachment plot, he came before this honorable court and filed a writ petition bearing number 7060 of 2026. In that petition, this honorable court directed the Tahsildar to dispose of the encroachment case which is against this petitioner. And the Tahsildar, without giving any notice for hearing of that petition, that encroachment case.
You take notice. Hard Lording Counsel for the petitioner, it is submitted that the encroachment case initiated against the present petitioner for encroachment of the plot number 2499 was decided without granting any opportunity to the petitioner, though by order dated, say High Court order ta likhi earlier order of the bench.
High Court order, matter I have quoted in page 6, my lord, of the petition.
Though by order dated 17/4/2026, the writ application filed by persons without making the petitioner a party was disposed of. were directed to be disposed of in accordance with law. They submitted that disposal in accordance with law would definitely mean giving opportunity to the petitioner who was the occupant of the land in question. That is subject matter of encroachment case number 1926 of 2024. Issue notice to the opposite parties. The learned additional standing counsel upon advance copy served appears and waves notice on behalf of opposite parties 1, 2, and 3. Notice to open number 4, 5, and 6 be filed. Notice to OP number 4, 5, and 6 be issued by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 3 working days. Stop. Returnable date be fixed to 3/7/2024. The matter shall be listed for orders in the week commencing 13/7/2024 before the assigned bench. Yes, next.
Interim status.
Disciplinary proceeding ताका against हवा interim order कौन हो? अपना prayer होची disciplinary proceeding against the tahsildar.
My lord, and to dispose of the actually to demolition of the other plots which have been enclosed on the same plot.
Set a prayer करंतु, नाले appeal करंतु.
That I prayed, my lord. That I prayed the prayer.
You are making prayers in two opposite directions. Either you are concerned with the eviction case pending, or you are concerned with the conduct of the tahsildar. What you are saying is correct, that you have not given any opportunity. But unless you challenge that order, where you have challenged? Where is your prayer?
My prayer is for a direction to issue to the tahsildar to demolish the entire enclosed plot, my lord, enclosed constructions on plot number 2499.
Set upon details which case re pending अछि. It a High Court no High Court re somehow I don't feel that High Court should take up. Upon set amend nal karantu. File karantu.
Then I pray only one thing, the observation that I'll approach the tahsildar for that purpose.
Tankar disciplinary proceeding ho. Saru taka against it. Se ta tahsildar hoibe ki nahi question hai. Both the Mr. Panda sitting now will take action against him. 2499 रे जदि encroachment अछि that the proceeding should be before the tahsildar or the appropriate authority whoever may be. Sita ho. Yes. Next. Mr. Mahanta. H.K. Mahanta for the petitioner.
Here is not a part. I am challenging Annexure 16 year old severe petitioner is the mother of the deceased employee who is the member of employee state insurance corporation.
So you read that order impute.
My lord. That is Annexure 16, page 56, your lordship. My representation.
Go to page 57. Go to page 57. B. Last but third paragraph पढ़ले भी चलेगा. Since we are already behind the schedule, last but third paragraph पढ़ो. It implies that
if the first category of dependents, widow or legitimate or adopted child or widow mother are not available, then dependents. He is the mother, your lordship. Petitioner
he is a mother, your lordship. He is the mother, your lordship. Purata padibe. That is the difference between an ordinary person and a lawyer. Are not available, then padantu.
Dependents benefits shall be payable to parents other than the widow mother.
In the instant case?
In the instance, the accident case of late Rajesh Kumar Koro, INS was admitted as employment injury and DB has been paid to the
DB death benefit. DB has been paid
to the daughter of
the insured person.
My lord. ID death benefit card number FA, which was communicated to the dependent. The mother of the insurance person is married, not widow mother. Hence, no DB is payable either to mother or the parents of the IP.
So you have a competing claim against the daughter of the deceased, or your granddaughter?
No. No, your lordship.
अरे नो कौन जे बेनिफिट पाइले से किए
Daughter of the deceased.
हाँ ताले नो कौन कहउछंती आपण मिस्टर महंत आपण टिके आपणकर डाहण पटु पळे आसुंतु आपण खुंटो रहि जाउची आपण सामना यस
But not against her.
Then how two persons will get? आपण आपण पाइबे आपणकर बाहा हेतिबा मा पाइतिबे विधवा मा पाइबे आपण विधवा नोंती आपण सधवा.
My lord, but I was dependent on her income, on his
सेटा
income.
सेटा प्रोविजन रे नाही ना सेटा प्रोविजन रे नाही. Obviously, the provision is beneficial. The daughter will be more dependent on the father than the mother. Your only son, you are dependent on your husband. A married lady is dependent on the husband. किसी नहीं मिस्टर महंत अर्जुन नहीं जो
payable to parents.
सेटा आपण प्रोविजन टा पढिले नि आपण को टाइम सेव करिया पे आपण को मु कहली जे सीधा कंक्लूजन को आसंतु आपण से प्ली कोठी नै ना जे सेटा प्रोविजन नाही ताको दबा पे.
I have taken that I was dependent on the income of my son. That I have taken.
सेटा हबोनी नाही आगा कैपिटल ए रे आपण गोटे सुनंतु ESI is a statutory thing. ESI Act रे insurance is prescribed and provided and disbursed according to the statute. That is statute. On page 56 रे पढले.
My lord.
The defendant's benefits shall be payable to DB कहउचंती to his widow, children and widowed mother.
Subsequently,
you are unfortunately your son has passed away, but both you and your husband, his parents are alive, so you are not entitled. ना एथरे किछि अर्जेंसी अछि ना किछि मेरिट अछि.
Let it come after week.
After week, that can simply date कर दो. No orders. Yes, next. Contrary to.
May I please, your lord. Here in this case, this is an eviction matter, my lord. That demolition matter. Admittedly, I am in possession of the government land. And
Prashanta Kumar Nanda for the petitioner, Mr. P.K. Panda, additional government advocate for opposite parties. 1, 2 to 5. Notice by whom?
The executive officer, Bodville Municipality, 6 milo.
Why is it? Kai say that copy da kai copy nahi. OP6 black page.
Page 17, your lordship, kindly have glance. Page 17.
Page 17, my lord. Initially, my lord, I am in possession of the land, my lord. And during
आपण तो मोहम्मद रोहित नुहंती ना
ना
आपण तबस्सुम जहांकर नोटिस देखांतु स्ट्रेट अवे कम टू द नोटिस पेज.
No notice, no. So far as the Topsum Jahan, there is no notice, but his.
predictive interim order हे परियो.
No.
तापर problem कौन हो that will not help you, because when you are not the noticee, how you will be protected.
That I have in reply, my lord, I have stated that my son is not there, for which, my lord, that the name of that house belongs to the present petitioner.
ताको कोंदु आपण ये रोहित को कोंदु आसीबे.
रोहित नहीं again right now. रोहित नहीं, for intentionally issued such notice, my lord.
नहीं से ताकर जदि intentional मिस्टर पंडा will argument that jurisprudence कहबो जे से कहले जे to argue based IPC CRPC jurisprudence.
plot against
how you must understand my order should make a sense. You would have marked that I start the or dictating the order. The petitioner before this court is the so and so, so and so.
My lord.
Tabasum jahe tale kichi nahanti setire.
Nine.
but in pursuant to the
ଆପଣ
notice,
ଶୁଣନ୍ତୁ ଆପଣ ଏଟା ଶୁଣନ୍ତୁ simply adjourn କରି amend କରିଦିଅନ୍ତୁ। ସିଏ ବର୍ତ୍ତମାନ ଦୁବାଇରେ ଥିବେ ତବସୁମ ତାଙ୍କ ମାଆକୁ ପଚାରୁନାହାନ୍ତି। ଧରନ୍ତୁ ମୁଁ ଏକ୍ସାମ୍ପଲ ଦଉଛି, ସେଟା କଣ ସେଠି ପ୍ରୋଟେକ୍ସନ ହେଇପାରିବ ସେଟା? ଆଜ୍ଞା ସ୍ଥିତିବାନ ପ୍ରପର୍ଟିରେ ହଁ ଆପଣ ଏଟା କହିଲେ ଠିକ ଅଛି। ଆପଣ ଏନକ୍ରୋଚମେଣ୍ଟ ଲ୍ୟାଣ୍ଡରେ କିଏ ଏନକ୍ରୋଚର, କାହାର ରାଇଟ ଅଛି, how you adjudicate?
Annexure 3 your lordship may kindly glance. Annexure C below. Annexure 3 that eligible certificate has been given in favor of that Topsum Jahan.
Are seta apana you are arguing against yourself. Just now this was argued by Mr. Misra. There I have intervened. In fact, this court has intervened, not I. Because the person herself is the beneficiary. ଆପଣ ଯୋଉ ଦିନ ତବସୁମ ଯାହାକୁ ନୋଟିସ ହେଇଥିଲେ ଆପଣ ଏଇ ସାର୍ଟିଫିକେଟ ଟା କାମ ଦେଇଥାନ୍ତା, just like G ଉଦୟଗିରି। ଆପଣ ତାକୁ ମିକ୍ସ ଅପ୍ କରିସାରିଲେଣି।
Absolutely right. You're all absolutely absolute, but the plot number which has been mentioned that belongs to the present petitioner.
ଆପଣ ସେଇଟା ଆପଣ ଯଦି ଏନକ୍ରୋଚର ଆପଣ ତାହେଲେ ଅଥରିଟି କୁ କୁହନ୍ତୁ ଯେ ଆପଣଙ୍କର
I filed the reply annexure 5 page 18.
ଆପଣଙ୍କ reply is against your contention actually.
That she has written that eligibility certificate has been issued in her favor in respect of that house below.
That who will
that authority will
no ଶୁଣନ୍ତୁ ଅଥରିଟି ଜଣକୁ ନୋଟିସ ଦେଲେ, ଆଉ ଜଣେ କହିଲେ ଯେ ମୁଁ ତାଙ୍କର ମଦର, ମୁଁ ତାଙ୍କ ରିପ୍ଲାଏ ଦଉଛି giving regarding my eligibility. You must understand that is the problem. That they should not have done.
Now the petitioner is affected party. Now by virtue of that notice below, the petitioner is the affected party because her house is going to be demolished.
ଆପଣଙ୍କର ସେ ଯୋଉ ଆପଣ ତାହେଲେ you have to challenge that order. ଆପଣ ଯଦି eligibility certificate ଅଛି ଆପଣଙ୍କ ନାଁରେ ଅଛି, ଆପଣ ସେଟା କ୍ୟାନ୍ସଲ ହେଇନି, ଆପଣ ସେଟା ତାଙ୍କ ଅଥରିଟି କୁ ଲେଖିକି ଦିଅନ୍ତୁ। କୋଉଠି ଲେଖିଛନ୍ତି ଆପଣ?
Annexure 5 ରେ।
ବଟ୍ ନୋଟିସ ଆପଣଙ୍କୁ ହେଇନି
ନା, ନୋଟିସ ହେଇନି। She specifically mentioned that certificate has been issued in her favor. Eligibility.
So what happened thereafter?
But now they are going to demolish my house.
Are now they are going to अपन तो notice नहीं अपन किंती कोई भी। से जो order against है, तब अपन notice नहीं होता।
हाँ, a proceeding against रहेगा।
Proceeding against अपन किंती देगा। I have to record that you are not the notice.
Order against.
You have a problem here, Mr. Nanda. You are not following.
Yes.
You have caught in this
because I have not been noticed. The son has been noticed, but mother has appeared before that.
ଆପଣଙ୍କର eligibility ଅଛି, ଆପଣ notice ହେଇନାହାନ୍ତି, ଘର ଆପଣଙ୍କ ନାଁରେ ନାହିଁ, ଆପଣ କହୁଛନ୍ତି ପ୍ଲଟ ନମ୍ବର ସମାନ। ପ୍ଲଟ ନମ୍ବରରେ ଗୋଟେ ଆଉ ଗୋଟେ ପ୍ରୋବ୍ଲେମ ଅଛି, ଗୋଟେ ବଡ ଏରିଆରେ ଆପଣ ଗୋଟେ ପୁଅ ଗୋଟେ ଆଉ କିଏ କରିଛନ୍ତି। ୟୁଜୁଆଲି ଆପଣ ଦେଖିବେ ଲାର୍ଜ ଏରିଆ ପ୍ଲାନ୍ ରୁ କିଛି ପର୍ସନ ଲୋକ କରିଛନ୍ତି। That is another problem. So ଆପଣ ଏଠି next instruction ନିଅନ୍ତୁ, ଆପଣ instruction ନିଅନ୍ତୁ, ଯଦି ତାଙ୍କ substitute କରିପାରିବେ ନହେଲେ ମଣ୍ଡେ ମୁଭ୍ କରନ୍ତୁ, ଆଉ କଣ କରିବେ। There will be a problem. If I direct the authority will simply say that she is not the noticing. ଆପଣ ଧରନ୍ତୁ ଜଣ ଘରେ ଭଡା ରହିଛନ୍ତି ତବସୁମ ଯାହା, let us assume. Can she protect that house? She cannot.
Because
like ଆପଣଙ୍କର you will find many slum dwellers are rented out. Slum space is rented out. So somebody is a beneficiary, somebody is staying, somebody is a subletting.
Now
so it is simply urgent. You take move it on Monday. If you take your chance on Monday,
that house will be demolished unless I will be protected.
I'm simply adjourning without any order. ମୁଁ କିଛି ଅର୍ଡର ବି କରୁନି, ଆପଣ ମଣ୍ଡେ ମୁଭ୍ କରନ୍ତୁ।
purpose of filing of the writ.
ଆପଣଙ୍କର ଆପଣ କାହା ଘର ପାଇଁ ଫାଇଲ କରୁଛନ୍ତି? ସେ ଯିଏ petitioner should come to High Court.
ଆଜ୍ଞା ମୁଁ ସେଥିପାଇଁ High Court ଆସିଛି because that house belongs to me. That's why I approach this honorable.
How do you establish that?
I being the affected party, I have not been noticed. My son has been noticed. So, since the house belongs to me, as per the survey conducted by the government. So I being the affected party, for which I sought for prayer in the writ petition.
Then Mr. Nanda, I observe you accept that the petitioner is not the noticee.
Noticing, my first prayer is to issue certificate. My first prayer is to issue.
That prayer you have to move the authority. If you move the authority to issue me a certificate, then you come to court. By which application you have moved the authority for certificate?
No, it is there in the statute. Once the eligibility
statute automatic no. Apna apply कोठे करछिन देखंतु.
apply no आज्ञा. Survey हेइ सला परे eligibility दिया जिवो
सेटा आपनकर जो सर्वे हैला आपण enumeration हेइछि सेटा देखंतु.
That is annexure 3 at page 15.
যদি অযোগ্য জমিরে রহুতান্তি আপন বাসযোগ্য অধিকার
that proceeding will initiated.
Hence, my lord.
Most likely you are Mr. Nanda, you are being wrongly briefed.
Again.
से वर्तमान आपनकर पुअर नोटिस पाइला परे से आपनकर सर्टिफिकेट यूटिलाइज करछथि.
ना अगे से जो खाता नंबर
आपण जहा मंडे जहा करिवे
खाता नंबर प्लॉट नंबर करछि that belongs to me.
Because once I start dictating the details, there will be problem. So I cannot justify that. I cannot justify that why you have approached and where is your house. You are not noticing.
No, I am not the noticee, for which I am specifically mentioned in the reply before the authority that that house belongs to me. Notice was not issued to me.
That house doesn't belong to you. That house doesn't belong to you. If your son is also encroacher, he's not entitled. He has to go. If you are entitled, you stay. So that is some
last para annexure 5 to 10 18 देखंतु last para रे मु लिखिछि.
आपण जोटा लेक्चर मु पढिछि, but if I dictate the order, it will go against you. It is up to you. If you accept, I will pass that order.
Your lordship may say that I will approach the authority regarding till then I may be protected.
Regarding what you will approach? Regarding what you will approach?
Either notice to me or that.
Why? Where is that? Where is that? That I have been banging my head now to explain you that I will direct authority in a matter where till now there is no such case where any other person has come in place of the noticee. This is the first case.
That I will. Yes, that opportunity may be given me, Lord Mirot, so that I will approach the authority.
How I will direct in a proceeding against Rohit? He will appear. That I have been asking you. I cannot direct.
The schedule of property which has been mentioned in the notice that belongs to me.
Most likely, he is not a beneficiary. You are the beneficiary. So in the subterfuge of your eligibility, he has encroached.
Maybe that.
Se gharara description kona?
Aଜ୍ଞା
ଘରର description
that khata number 144 and plot number 67.
सेटा नाही आपणकर घर होची हाउस नंबर 0135 वार्ड नंबर 1
हाउस नंबर आଜ୍ଞा but khata number and that I have mentioned
so that is discrepancy, Mr. That is discrepancy, Mr. Nanda. You should have asked these questions to your client. It is better you
plot number, house number I have not mentioned. House number has been mentioned and that I have
house number lekha hai
खाता प्लॉट लिखा ही चाहिए मु लिखि छि annexure 5 रे पेज
आपण हाउस नंबर कहूची आपण खाता प्लॉट कहउछंती आपणकर घर हैला तबसुम जहां हाउस नंबर 135 वार्ड नंबर 01 हिराकुद कोलुदी
आज्ञा ना your lordship पे annexure 4 series at page 16 plot number 67 खाता नंबर 144
आपणकर तो ना पढिबे ना कॉन्शियस है कि पढिबे आपण देखंतु आगे पेज 14 हाउस नंबर 135 वार्ड नंबर 01
हाउस नंबर
सो फेरे
हाउस नंबर आज्ञा प्लॉट नंबर
आपण तरबर होचती बोले आपण नेक्स्ट पढंतु पेज 15
आज्ञा
एक नंबर वार्ड हिराकुद कॉलोनी सेम थिंग
आज्ञा
सेम थिंग Upon suddenly you find that plot number 67, khata number 144. No mention of any khata house number.
No, house number, that is the
So that is how, if I mention these discrepancies, it will not be in your favor. That I am sure. And I cannot ignore these things. You should have asked these questions to your client. That apana gote ghare rohuchanti, gote electric bill achi, ward number achi, house number achi. How you are mentioning a khata number, plot number?
That municipality has reflected in the notice. I have not mentioned.
Khata number, plot number kodi thai janchani to? Khata number, plot number gote ROR re thibo. Se ROR re lekha hibo prajar naam. So you should have checked that. You should have checked that.
No,
maybe
no, because that is a
maybe ଆପଣଙ୍କର page 17 ରେ ଯୋଉଟା ଅଛି ସେଟା ତ ଆପଣ ପୁଅକୁ ନୋଟିସ୍ ହେଇଛି।
ପୁଅ ଆଜ୍ଞା ସବୁଥିରେ ପୁଅ ସେ ଜାଣି କରୁଛନ୍ତି। ପୁଅକୁ ନୋଟିସ୍
ଆପଣ ପୁଅ ନାଁ ଘରଟା ଅଛି ସେ କଣ କରିବେ?
ନାଇଁ that I have received and I have also filed the reply before the authority. It's not that I have flee away from the justice. I have also replied to the authority. And the date which has been mentioned in the Annexer 4 series, page 17, that you have to file the reply 1/6/2026.
Just kindly look at your reply, what you have written.
That I am
reply टा पढନ୍ତୁ page 18.
Again, I have been residing with my family member by constructing a dwelling house over a piece of government plot number 67 under khata number 144 in Mouja, Nalda.
So where is your house number?
Again?
Where is your house number and what number?
House number, that plot number has been mentioned.
So that plot is the problem that I have been asking you. I have been banging my head to explain you that both records are contrary to each other. ଆପଣ ଧରନ୍ତୁ ଦିଟା ଜାଗାରେ ଘର ଅଛି, ଗୋଟେ ଆପଣଙ୍କର ୱାର୍ଡ ନମ୍ବର 1 ରେ ଘର ନମ୍ବର 135 because it's a dwelling house.
ବସ୍ତି ଏରିଆରେ ଆଜ୍ଞା କଣ ହୁଏ ନା ସେତେବେଳେ ଯୋଉ ସର୍ଭେ କରାଯାଏ ସ୍ପେସିଫିକ ହାଉସ ନମ୍ବର ମେନସନ କରାଯାଏ, ସେଠି ପ୍ଲଟ ନମ୍ବର ଖାତା ନମ୍ବର। ବର୍ତ୍ତମାନ ମ୍ୟୁନିସିପାଲିଟି ଦେ ହାଭ୍ ଗିଭନ୍ a notice that plot number and khata number. That is why actually the
ସେଇଟା ଆପଣ ଏକ୍ସପ୍ଲେନ୍ କରିବା କଥା ଯଦି ଆପଣ କରନ୍ତୁ, I will not entertain.
ଆଜ୍ଞା ସେଇଠି ଏକ୍ସପ୍ଲେନ୍ କରି that
maybe this is a harsh order or otherwise I don't know, but I am not entertaining anything. If you want, I will pass that order. That is because it is already.
ଆଜ୍ଞା ସେ 7:30
No, I will not allow the occupant of ଘର number 135 ward number 1 to intermingle with plot number 67 khata number ete. I will not do that. That you do.
Then I will explain before the authority that.
Whatever you go, but no judicial order.
Tomorrow it will be demolished.
Let it be. For tomorrow's demolition, the court cannot be held responsible. It is your choice.
It is not arbitrary, that notice itself.
No, I have to say, Mr. Nanda, if you are telling you, I am record, you are just spending time. Half an hour we have spent. You have not been able to. I'll say all these things in the order. If you are ready, then I'll pass the order. It is your choice. Or I will leave it without passing any order. I cannot simply ignore the facts. You make up your mind, I'm passing it over. We have already spent sufficient time in analyzing it. Yes, Miss Jinu Rani. Mr. Sabat, yes?
Yes. May I please your lordship?
Yes.
Your lordship, item number 23 is opposite part number 7 have been without given any opportunity for hearing have given from number notice on dated 15/5/2026 for evict to house bearing khata number by
So you will challenge that order in appeal or not?
Your lordship,
I have already passed order in similar matters where I have directed you will approach the appellate authority within 2 weeks or something like that.
Yes. Only suppose my lordship. Similar order copy sir, my lordship. Your lordship bench.
Se order ta diyontu. Number other side ko diyontu.
Number 17456.
WPC
WPC 17425 of 2026 dated 2/6/2026.
So earlier order on dated 2nd June, my lord.
2/6/2026 ହେଲା WPC 17425 of 2026 order dated 2/6/2026.
Yes, my lord.
My lord, my lord.
So Mr. Brahma.
Yes, my lord.
So you are appearing here.
Yes, my lord.
So then same order.
15 working days, my lord, given for appeal, my lord, allowed for in that previous order on dated 2nd June, my lord.
So it is better I will specify because that Raja is intervening.
My lord.
So ସେଥିପାଇଁ ଡେଟ୍ କରିଦବା ସେ ଅର୍ଡରଟା ଟିକେ ପଢି ପାରିବେ ମିଷ୍ଟର ବ୍ରହ୍ମ और ମିଷ୍ଟର ପଢନ୍ତୁ ମିଷ୍ଟର ସାବତ Can you speak to the microphone ରେ ପଢନ୍ତୁ
Yes, sir. 19/6/26 ଜାଗାରେ ଟିକେ ବଢେଇ In case of the petitioner does not file any appeal.
ଲାଷ୍ଟ ଅପରେଟିଭ ପୋର୍ସନ ଟା ମିଷ୍ଟର ବ୍ରହ୍ମ କହୁଛନ୍ତି ଅପରେଟିଭ ପୋର୍ସନ କଥା ଅପରେଟିଭ ପୋର୍ସନ ଟା ପଢି ଦିଅନ୍ତୁ
My lordship para 7 in case
19/6/26 ଜାଗାରେ ଟିକେ ବଢେଇ ଦିଅନ୍ତୁ
ମାଇକ୍ରୋଫୋନ
19/6/26
ଟିକେ ପୁରାଟା ପଢି ଦିଅନ୍ତୁ ଜଷ୍ଟ ପଢି ଦିଅନ୍ତୁ ଅପରେଟିଭ ପୋର୍ସନ
Operative. In this case, petitioner does not file any appeal as undertaken by 19/6/26. This order passed in writ petition have no effect. Your lordship can extend it 19/6 to another 5 days or 10 days.
हाँ कर दियो
हाँ yes
बात करी कर दियो
my lord
ସେଟା କୁ 26 कर दबा
yes
19 जो ଅଛି କିଛି ଦିନ ଅଧିକା कर दो
My lordship 19 ଟା जो ଅଛି ସେ ଟିକେ 29 ତାରିଖ कर देले बेटर हो
29 ଟା 26 ଟା ଛୁଟି ଅଛି 27 ବି ଛୁଟି ଅଛି
हां yes my lords
29 କରିବାକୁ पड़िबो
my lords
Lordship, in the meanwhile, status quo to be held.
status quo till ସେଥିରେ କେତେ ଥିଲା
My lordship 29/6/2026 ଅଛି ତାକୁ ଟିକେ ଆଉ 1 month extension कर दो
इसको shall be extended till till 10/7
yes my lordship 20 कर दो
ठीक ଅଛି 17/7
my lord
yes
my lordship item number 23 to 33 except 32 are similar matter my lordship
just 23 24 Mr. Brahma SK Brahma
25 I am appearing upon behalf of the opposite parties 25 your lordship may note my submission regarding this case is not maintainable since appeal is there only that part may be inserted my lord
आपण तो पढिबेनी सेराला प्रॉब्लम that part is inserted काई हबो आपण ऑर्डर टा को पढि छथि
my lords at para 4 my lords your lordships on that order in view of the submission made at the bar it is directed that the petitioner is so advised shall approach the higher authority in appeal against the order
appeal is not maintainable
yes my submission
अरे my submission कोन अरे डोंट स्टेट द ऑब्वियस कोर्ट को जंदी अपील ले जा आपण को जंदी रिट नॉट मेंटेनेबल अपील ले जाओ
yes man
अगर कोन अधिया कोन कहउचंदी आपण कोतरे अपील करचंदी को मैटर
25 man
खाली 25 आपण को ना सर
CM Singh man CM Singh
CM Singh
my lords item 30
जेतरा अपील अछि सब से लास्ट लाइन ता चेंज करे पड़ो
my lord item number 31 Swayam Mishra for the state
just one second मैं this छोटा हूं 17/7 shall file his appeal by
Notice.
29. अच्छा आपण कहउचंती मिस्टर सिंह जे आपण को सबमिशन रिकॉर्ड है अच्छा अच्छा
Yes.
he says the para 4 add कर दियो तो it is submitted by the learned counsel for the state जी भी था हला that the writ petition is not the writ petition is not maintainable as the petitioner has a remedy available under statute in the form of appeal to the sub collector to the appropriate authority कर दो का ऑर्डर तो जानी most likely तहसीलदार
Sub collector, my lord.
yes
Most obliged, my lord.
তারপরে 5 6 7 फाइल अपील फाइल पे केते कहले 27 29 छुट्टी अछि 27 इज हॉलिडे 26 इज हॉलिडे 27 फोर्थ सैटरडे
38 29 lords.
29 6
Yes, yes, lords.
26 is holiday.
Yes.
Moharram na kaun hai. सेम ऑर्डर रे आपनकर अपीयरेंस गुडा लिखिबे 23 24 25 मिस्टर सीएम सिंह 26
in item 26 Mr. AK Pati is there because
Mr.
of
Akshay Pati 26 Mr. Akshay Pati additional standing counsel 27
27 Mr. My lord SJ Mahanti Sarathi Jyoti Mahanti
27 Sarathi Jyoti Mahanti 28
Mr. SJ Mahanti
S.J. Mahanti 29
29 and 30 my lord I am appearing
29 30 Siddhartha Prasad Das
my lord
31
Lord, item 31 Swayambhu Mishra for the state, my lords. Lord, I have no power at my residence, so my lords, that is why I am.
So he has become powerless. You should have approached Mr. Dolly. 31. Power has to, don't power for state, but no power at home. 31 Mr. Swayambhu Mishra. 31.
31 I am appearing for the state, my lords.
31 Swayambhu Mishra additional standing counsel. 33 Mr. Manmoy Kumar Das.
Yes.
Additional standing counsel. Yes. 32 who is appearing for state in 32? Or all have run away
yes,
now?
No, my lordship. I am appearing for 32.
Sorry, no, I thought that everyone has left looking at Mr. Dolly. No one is present in court.
But 32 is different matter, my lordship.
Oh, yes, yes.
Your lordship, my another prayer, your lordship.
Wow, prayer.
There
must be a limit to
the last 10 years.
Lords, my humble another prayer, lordship.
Miss Jinurani, petitioner ପାଇଁ Miss Jinurani and P. Sabath. Yes, Mr. Sabath, कौन prayer कहउछंती?
Your lordship, my another prayer is WPC number 17797. Unfortunately, today not listed, my lordship, but allow the same matter, my lords.
How can some matter which is not on the list be allowed?
Monday.
Only one petition, lordship. One petition. I have left.
Mr. Sabath, since court in oral mentioning, Mr. Actually, other day, Mr. Mishra, Swayambhu Mishra had mentioned that matter. It was listed, but in the process of listing, it was missed. That has happened. And coincidentally, Mr. Mishra is now become powerless.
Actually, my
Actually, my lordship, only one petition has been lifted, my friend.
Effective
No, my lordship. SR completed, defect move, and the number also, registration number also allotted, my lordship. My lordship, one, my lordship.
তিনটা পরে কিছু করি হবনি আজি তো মেনশনিং ডেট বি নো সো মন্ডে ইজ এ মেনশনিং ডেট আপনাদের সুবিধা তো করা হইছে গোটে দিন মেনশন হবো তা পর দিন লিস্ট হবো ইয়েস
হাই লেভেল
you have a record now Mr. Sabath and Ms. Rani that maximum cases in vacation yes
Also
And only.
And that also, my lords, all are unauthorized documents.
32. Yes, Mr. Dolai.
Lordship, here, Lordship, case is very simple here, Lordship. All, Lordship, here 16 numbers of petitioners are there, and all are residing over Bhutan land, Lordship. There is special statute operating in the field, Lordship, and they have been elected since 1961. And their Lordship they were staying peaceful, Lordship. Theta Lordship, kindly come to page 17. Because in the meantime, the status of the land has been changed. That was before the settlement officer, and that was order passed against the petitioners, and that's why writ petition is still pending before this Hon'Ble Court. And Lordship, kindly come to page 17 of my brief. Page 18, Lordship, there perhaps I have quoted 3 orders, Lordship. Lordship, can see page 18 of the brief. Here, Lordship, in every case, almost all cases.
Earlier writ application number is?
Number, Lordship, I have given you certificate. There are a number of writ applications, around 16 writ applications. I have given in certificate page 6, Lordship. Page 6. And I have quoted 3 orders, Lordship, in page, it starts from page 17. In all cases, Lordship, stay is operating and very peculiar status quo till disposal of the writ application. Your Lordship will kindly see the page 18 second order. There, Lordship, the possession may not be disturbed till disposal of the writ petition. Despite that stay order, Lordship, last week, Lordship, last 15 days back, the administration, Lordship, ransacked the entire residential of the petitioners. Now, partly remaining there, Lordship. Now, Lordship, while demolishing the same, when we are in a possession, now, Lordship, interestingly, kindly come to Annex 9, Lordship, page 102. Now, the Lordship, resorting to Section 19 of the ODA Act, they have issued notice, and they are now on the rest of the Lordship buildings remaining there. They are going to demolish the rest of the buildings, Lordship. Stage operating 60 applications. Now, Lordship.
No, it is a 2-5 Galadi.
No, now it is 6-5 को अर्जन कर 6 को अर्जन कर. I have taken the appointment, Lordship. 6 के अर्जन कर. Lordship, and that is at running page, Lordship, 20 para 29. 6 के अर्जन कर, Lordship.
So you are participating in the proceeding?
Yes, Lordship. I'm now here. I'm raising maintainability. Lordship, when the land is of Bhutan and we are in possession 61, and ODA came into force, Lordship, in 1982 only. And when the same set of proceedings pending before this Hon'Ble Court with the operation of interim order, how this Lordship ODA will come to play, and will restore Section 91, and the entire buildings have been constructed since 1961, Lordship. In the name of Lordship, resorting to a strange law, Lordship, they are going to demolish.
May I please, the Lordship?
Yes, please.
My Lordship, regarding the maintainability, they can appear before the ODA court and they can argue before the ODA court. Second, my Lordship, the stay is continuing from 2023, my Lordship. And second, if your Lordship will see page number 105, the order of the ODA court, my Lordship. They are not taking any action because of the stay order continuing, my Lordship. And they are also not, the petitioner also not taking any initiative for the listing of the case. Because the court observed that may I read, my Lordship, the relevant part?
You are saying that already a stay order is there?
Yes,
Yes.
they are saying because of the stay order, they cannot take any action, even if the maintainability, even if the jurisdiction, whatever, my Lordship, but they are not taking any action because of the stay order. And they are saying it is because it is of 1961 settlement or whatever, my Lordship, that will be decided by the lower court, not the High Court, my Lordship. But though there is a stay, my Lordship, but because of the stay order, my Lordship, they are not able to take any action. Regarding those who are participate in the ODA court, my Lordship, who has filed in the ODA court, rest of the part they can take because there was no stay order. Those plot, they have a stay order. That part, they are not touching, my Lordship. But those plots are no stay order. But that part they can demolish, my Lordship. Because 61 settlement, after that, my Lordship, the notice to be issued, we will take the instruction from the GA department, what has happened, BMC, whatever, my Lordship, we have to take the instruction, then we can file our counter, my Lordship.
You are saying that
61.
The deputy commissioner they have taken note of the High Court stay order.
Yes, my Lordship, they are saying though there is a stay order, they are not able to do anything.
Lordship, may I speak one line, Lordship?
Yes.
In fact, Lordship, it happens with every state council. In fact, never they go through the council contents of the petitioner. A Lordship, she is making a statement. This is 1961 statement. She should order that what, Lordship? It is not the settlement. It is under the Bhudan Act. The land is settled under the Bhudan Act. Lordship, kindly come to page annexure 8.
But Mr. Dolly, you are a petitioner in all the writ applications that
Yes.
the authority is noted.
Yes,
And they have noted the stay order.
Lordship, kindly come to
Then
page 80.
how another writ application is maintainable?
No, Lordship, I come to annexure 8 series. That is the crux of the matter. She has not gone through my file. They have ransacked the Lordship.
No, even if I have not gone through the file, that may be possible. But the thing is that you find that it is reflected in that order. All these writ applications.
Kindly come to annexure 8 series, Lordship. Lordship, kindly come to annexure 8 series.
Annexure 9, just look at.
No, Lordship, annexure 8 series, Lordship.
105 देखो तो आपण का सेटा आपण फाइल करछंती देखिले कोन फरक
No,
105 रे देखो
I am agreed by their eviction order. Lordship, kindly they have passed the eviction order. Lordship, it starts from annexure 8 series.
Date कौन तो date.
Lordship, page that is called, Lordship, the past in last month, Lordship.
Date ता कहबे ना date कौन?
Lordship, 24 2026.
सेटा ता परडा. So you just look at 105. That order is 252026.
No, this is, Lordship, this is now before ODA
court. So on 24 the writ application is pending. You should have moved the High Court. It is still pending. Status quo order is there.
No.
Now look at page 105. Page 105. Order dated 252026.
Lordship, despite status order the demolished. Lordship, come to page 89.
Look at page 105.
Yes, Lordship, 105. That is my application before the ODA court, Lordship.
Yes, just look at it.
That is my order. That is my contention.
Because you are now challenging the proceeding before the ODA authority.
Yes, Lordship.
So look at the order.
Yes, Lordship. I have annexed the Lordship. That is my contention. Lordship, what they are saying, Lordship, I am challenging the initiation of proceeding. I am saying.
You are challenged.
Lordship, they have referred to the Lordship that on my contention, they refer to it. So now the matter.
Second para.
Lordship, in the writ petition such Lordship, in the Hon'Ble High Court was pleased to pass status quo order in respect of possession of a disputed property to the maintained till next date listing. However, the learned counsel appearing before the opposite party verbally submitted that the case has not listed before the Honorable Court till date. At this juncture, he seeks some time to file detailed so-called reply and an approved plan in respect of Alice construction. This is my contention, Lordship.
This is my contention. Further,
Lordship, it is opposite to mention here that the instant UP case initiated against the OPs for raising of unauthorized construction without approved plan and deviation of the approved plan, thereby violating the planning building standard regulation of the ODA Act 1982. However, this court has no jurisdiction in respect of the settlement of land record of right in the name of OPs. In view of the matter concerning oral prayer made behalf of the party, the matter has been adjourned to 12-5. Now it is on 6-6, Lordship. For the filing.
During pendency of the earlier application, this application I cannot take up.
Lordship, here it is a complete different application, Lordship. Here the application
so it has to be taken up with the other writ application.
Lordship, they have already
13005, 12990.
Lordship.
And 4482. All are pending.
All are pending. 16 applications pending, Lordship, not one before, Lordship.
Yes. So you have to move that writ application.
That cannot be moved during vacation, Lordship, because that is old matters.
Every day old matters are taken up with IE. Every day.
No, here, Lordship, I am challenging the initiation
because there cannot be two writ applications and two parallel orders.
No, Lordship, perhaps I am not able to convince you, Lordship. Here is a different cause of action. I am challenging initiation of proceeding under the ODA Act. ODA Act is not maintainable because
that should have moved along with that writ application.
How can it be, Lordship? Lordship, that is a different writ application, different cause of
action.
So
you take your chance because if I pass that order, it should be taken up with the other writ application pending. So that may create, that may be, you may have the difficulty in the next week. But that application you have mentioned also, that is there.
Yeah, I have mentioned. I have given every details to that, Lordship.
So you have to move those applications.
Lordship,
So if you say no, I will not take up without those records. I will not take up the matter.
I am not saying it. I am saying, Lordship, can you protect me, Lordship? Only pass me no course of action in the court's order. In view of the earlier order, Lordship say.
No, I am not inclined.
Will not pass
I
any order,
am not inclined with in view of the earlier orders passed by the court. Because that is status quo order passed by the court.
Lordship, kindly come to page.
So let it come. Let it come next week. Let it come next week.
Lordship, they have already demolished.
Whatever.
Demolished, Lordship.
Whatever.
Lordship, what they can do, Lordship.
Whatever has been done. But I'm not saying that they can do anything that you are saying. But
Lordship,
of the earlier applications, these applications cannot be taken up.
The documents, Lordship, page 89. Lordship, kindly see.
Could be. If you want, I will pass that order. That this writ application has to be taken up along with the other writ application.
Lordship will not protect me, Lordship.
No. Till Monday, I cannot protect you. Tuesday, you may get protection. Because this order was passed in 12/4. And the writ application is filed after vacation.
Lordship?
That order, just now you have gone through, that was passed in April.
Yes, Lordship.
Yes.
Now I'm saying no, Lordship.
That proceeding is initiated even March or maybe prior to that. It's not during vacation.
Kindly see, Lordship, again 106 page 106, Lordship. Matter is urgent to 12/5 on 12/5.
ता पूर्व डेट
ता पूर्व डेट 12/5 केस थिला. Now it is 6/6.
12/5 पूर्व डेट केबे कोंतु
12/5, Lordship, that is on 2/5, Lordship.
Yes, so 2/5 is much before vacation. So it is initiated prior to, I don't know whether there was an order prior to 2/5, but at least 2/5 order is there.
Yes, Lordship.
So and on 2/5 they have taken note of that pendency of the writ applications.
Yes, but they have not considered my prayer, Lordship. They are saying, Lordship, they have not considered my contents of the writ application pending.
They have you see, the notice is 27 so that I was telling you, it is the month of April. So on 27/4 itself you could have moved this court.
No. Now my entire prayer before Lordship, the maintenance of the UAP proceeding. Because I am saying when the land
so that I will I will consider in presence of the other writ application along with the writ application.
I have quoted the writ applications, Lordship.
No, I have those records are not there. Those records, if you want, I will observe them. No problem.
Your Lordship kindly observe, Lordship. Your Lordship kindly observe that there are interim orders and they have done it. Your Lordship kindly adjourn to
I am not taking up. I am not taking up the matter. I will say that since already writ applications are pending, the notices are issued on 27/4/2026, and the petitioner only approached this court by filing on 4/6/2026 after 2 months of issuance of notice.
Yes, Lordship.
Challenging the proceeding. The proceeding is 27/4.
Lordship, it is every time open to me, Lordship. It is up to me, Lordship, when I can challenge. Because I am challenging the initiation of
proceeding. So it is up to the court whether to entertain during the pendency of the other writ application.
That is the solicitor of
I
that is the sorry, Lord, for us, Lordship. Now the present litigation arises, Lordship. We are receiving it. That is the Lordship, even if they are not getting protection,
it's not a question of the lawyer being receiving it.
Lordship, kindly see, Lordship, even if you are not getting protection.
Mr. Dole, it's not a question of the lawyer or the petitioner being receiving it. It's a question of propriety of taking a month of April and in June.
Your Lordship, we Lordship with the vast experience, every Lordship, you are also feeling the
not as fast as your experience.
Anxiety of the petitioner's counsel, Lordship. Your Lordship also feeling the anxiety of the petitioner's counsel.
Not as fast as your experience. It is not that. That I am not saying. But there should be some semblance, because you see there are orders, there are interim orders protecting you.
No, but that's why Lordship, I have come with the test.
Notices
had it been carried out, it's not my pleasure to come to court. Because there is a violation, I am coming and I am taking
Dole, you are saying the authority cannot initiate the proceeding in view of the Ghudan Act because you are settled of 1962, and you are now this 81 Act has come. So that itself, that plea you should have taken.
That plea,
the court.
That I
anyway, you leave it there. If you want, I will record that, but that is not. That will not solve your purpose. Why to pass an order?
No, I am saying Lordship only protect me. Let it be any day, but kindly protect me, Lordship.
No, without those records, I cannot direct listing. That is the other problem. You must understand. I cannot direct listing with suppose on second I would have directed list with the other cases, like to some matters we have directed. Yes, Mr. Nanda.
I permitted to withdraw. In the meantime, last night that demolition order has been issued, so I may be permitted to withdraw.
No, so permitted to withdraw, you have to file that memo and next date.
Simply permitted to withdraw.
Yes, you file that. You file memo before the next court.
No, today
you should have checked. You should have. This is the first case where the notice and the plot number, khata number are not matching. You should have asked this thing to the petitioner because they convinced you that that is the same. We do not know. You do not know also. That is the problem.
That house number, plot number, khata number.
Upon Monday दियंतु आज हो परिबो.
ताले withdraw आज कर दियंतु withdraw.
Monday. Already I have heard that matter. I have not. Se पळेलेनी से भी पळेले. आपण मेंशन कलेनी बासावरजू कली. All have left.
That other matters are your lordship is hearing other matters, so I will not interfere in that.
No, I gave you time to reconcile because there was a gross discrepancy. House number and this what number? Another plot is different. Another revenue land.
Number, plot number, that is the same, Milo. That my mother is staying.
So that you said that why? Because when you asked that, when you were asked that why the mother has come and why the son has not come.
Son is not there. That she has already mentioned before the authority.
So that you withdraw on Monday. Okay. Yes.
Monday withdraw कौन करिवे again?
अरे Monday file करें Tuesday withdraw करें. Tuesday sorry. Tuesday mention date ना कोई. Tuesday. You are not passing a order by
Demolition order has already passed.
So demolition order has been demolition order has been passed. Demolition order has been passed against the mother of the son.
No, that has been passed against son, but property is mine, Milo. Property is mine.
So that is no order passed. You simply leave it. Okay. Thank you.
Withdraw on basis of my submission. That can be withdrawn on my submission.
No. Because both of Mr. Panda has left. We should have mentioned that.
Panda role nahi. Seti Borbin municipality.
Whatever, sir. In their presence, the matter was taken up. Apano khata plot do choni seta municipal plot no. Seta hochi revenue plot. Yes.
Municipality has initiated that proceeding.
Lordship, item 32 Lordship more कौन हला Lordship 32 टा?
आपण बातरे मंडी दिन चाहिले लिस्ट करि परिबे.
Lordship अर्जुन दे matter judicial order so that it can be listed.
ना अर्जुन करि होनी. ताको मोर बेंच चलियो.
ना ए बेंच टा को Lordship आज तो मोर
I cannot list matters in the other bench. You must understand. Since Monday Mr. Nanda को कहउतिली से आई कहउतिली जे Monday you have to file memo for listing again.
एतर मोर से Lordship से जो ये आदि टा को सिंध कर दूना मैं मेंशन कर आर कोटर करबी. सीधरा जो कलेक्टर पर पठेले सेदिरे भी सेडी मेंशन करी करथांती
कोडे
जोटा लॉर्डशिप आइटम मोर थला 13 14
सेटा ऑर्डर हेला कि तो पचारथिले आपण आई टोल्ड यू सेटा आपण रिमांड कर दियंतु कहले अथर कथा को दियंतु ऑर्डर देला पर आ करिवे